Good morning, everyone. Welcome to the third and final day of our fall 2025 marathon session here in Philadelphia. As you may know, the Pennsylvania Supreme Court is the oldest Supreme Court in North America, the oldest appellate court, in fact. Our roots date back to William Penn's Provincial Court of 1684, and the Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1722. In May of 2022, our court celebrated its 300th anniversary in Philadelphia, right here. We are privileged to sit in three historic and majestic courtrooms in Harrisburg, Pittsburgh, and here in Philadelphia. Construction on this building began in 1871 and took 30 years to complete, longer than the Great Pyramid in Egypt. It was designed in the French Second Empire style. For nearly 15 years, City Hall stood as the tallest habitable building in the world. Sitting atop of our building is a bronze statue of William Penn, standing 37 feet tall and weighing 27 tons. Mr. Penn's statue faces northeast and points to the spot where he signed a treaty of friendship with the local Native Americans in 1682. Interestingly, our court building would not exist had not it been for this Supreme Court. The Public Buildings Commission was established by the Pennsylvania State Legislature and tasked with the planning and construction of municipal buildings in Pennsylvania, including City Hall. Throughout the construction of this building, this court resolved issues with respect to funding, displacement of property already on site, and even the constitutionality of the commission itself. On January 1st, 1877, our Supreme Court became the very first tenant in this beautiful building. I'd now like to turn it over to Justice Sally Mundy to introduce some students who are here with us today. Justice Mundy.
Thank you. We are very excited to welcome the students from St. Mary's Interparochial School's 8th grade class, and they are here today with their teacher, Mrs. Croissant Sannicki. And they are not strangers to this courtroom. Last May, after several months of studying on a weekly basis the trial of the Molly Maguires, they came into the courtroom in May. We set the courtroom up as a trial courtroom, and we did a mock trial with the students participating, and Justice McCaffrey was their trial judge. And after the mock trial was concluded, we then transferred the courtroom back to an appellate courtroom, and Justice Doherty, myself, and Justice McCaffrey, along with a number of the students, we kind of were in the Supreme Court style with 9 justices, performed an appellate argument in the courtroom with the students. And I want to applaud the students for their hard work and really a great understanding of the concepts, which were somewhat difficult, and certainly the languages of the case back in that time were difficult to understand. They did a terrific job. Would you like to stand up so the courtroom can acknowledge your presence here today? So we're delighted to have them back today to see how our court operates. So welcome.
Thank you, Justice Mundy. You may be seated, kids, and the duty is now on the attorneys arguing to persuade some of these young people to pursue a career in law. If you dissuade them, I'll be very disappointed. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. Excuse me. I will then give a short summary of the case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of facts or procedural issues and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for particular issues. In cases where there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when we are asking you a question. A justice's question is not meant to trip you up. It rather indicates that there are particular issues we wish to explore further. I remind you that we do not allow rebuttal. Finally, while we have no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
City of Philadelphia versus Superholder Police Watch Number 5, representing the city, Mr. Craig Gottlieb, representing the FOP, Mr. John Hughes.
A police lieutenant sent a series of sexualized texts and a pornographic bestiality video to 2 female subordinate officers, and then, during the resulting investigation, encouraged one officer to lie and suggested a promotion to the other officer for her support. The Philadelphia Police Department suspended the lieutenant with the intent to dismiss him. The lieutenant grieved his termination under the applicable collective bargaining agreement, which culminated in an arbitration award that suspended him for 50 days, but reinstated him to his former position. The issue before our court is whether our 1995 decision in Betancourt, which set forth a narrow certiorari standard of review of a grievance arbitrator's award, should be modified to apply a JNOV standard such as that utilized under the Uniform Arbitration Act to adopt the essence test, which is the appropriate standard for grievance arbitration awards rendered pursuant to the Pennsylvania Employee Relations Act, or to embrace a public policy exception to the narrow certiorari standard. Good morning. Please proceed.
Good morning, Your Honors. May it please the Court, Craig Gottlieb representing the appellant, City of Philadelphia. With that recitation of the facts in mind, I just had one bit of housekeeping up front. We're actually making 2 alternative arguments implicit in what Your Honor described. Our first argument is that the Court should overrule Betancourt. Betancourt is largely a question, as we'll get into momentarily, of the General Assembly's intent under Act 111. Our second alternative argument is that even if the Court accepts Betancourt, the Court should still then overrule the Smith case. And the implication here is that under Betancourt, if the Court accepts Betancourt, which it shouldn't, but if the Court accepts Betancourt, the Court would apply a narrow certiorari scope of review to grievance arbitration. But we're then asking the Court to import a public policy test into the narrow certiorari scope of review in contravention of the Smith case. So our first argument is the Court should overrule Betancourt. Our second argument is that even if the Court accepts Betancourt, the Court should overrule Smith.
Thank you for that clarification.
Let me start with Betancourt. As I mentioned, Betancourt is largely a question of the interpretation of the statute. The decision there hinged on 2 factors. It looked at the text and it looked at the history. I'd like to discuss both the text and the history of Act 111. The text, if you read it, is almost exclusively about interest arbitration. It describes the procedure for starting collective bargaining, and it describes the procedure for what happens if there's an impasse in collective bargaining. That is the import of Act 111. There is one reference to the word grievance. That is it. There is no reference to the word grievance arbitration, and there is certainly no reference to a scope of review for grievance arbitration. So our position is that Act 111 is silent as to a scope of review for grievance arbitration.
Counsel, could you back up for a second? Because this is starting to sound like an argument that was made during Betancourt. Can you start with stare decisis and your best argument as to why we should overrule Benacourt at this point in time under principles of stare decisis?
Yes. And the stare decisis factors, I mean, so one of them is the quality of the reasoning of the decision, so that's where I was starting to get into. There's also the other key factors are on workability, reliance, and consistency with other cases. So let's go, I'll come back to the reasoning, because I do think that when the court understands that Act 111 is an impasse arbitration statute and not a grievance arbitration statute, the reasoning becomes extremely flawed. But it has also proven unworkable in addition to flawed reasoning. And the unworkability is over 30 years. I mean, and in several of the briefs, we've described, we and our amici have described dozens, if not more, cases where the results have been egregious. And starting with this case in particular, looking at the Smith case where an officer put a loaded gun into an ex-girlfriend's mouth, these cases are simply untenable.
Get back to the quality of the reasoning, because it has to be egregiously wrong in its reasoning. What makes the reasoning in Benincourt egregiously wrong?
The language of the Act.
But the Act prescribes that interests and grievances will be arbitrated pursuant to the Act. What does that mean?
So Section 1 of the Act,
Right.
I think you're referring to, right?
Yeah.
Section 1 of the Act says that there be grievances, disputes and grievances in accordance with the Act. So what we know from that is that if there is a section of the Act that affects either interest arbitration or grievance arbitration, you have to comply with that. But we know that is not every section of the Act. For example, we know from the Township of Moon decision that Section 4 itself does not apply to grievance arbitrations. It only applies to interest arbitrations. I'm just going to read a quote from Township of Moon. It says, the procedure described in Section 4 sets forth time limits that are clearly related to a contract negotiation impasse and not to an alleged grievance. So Township of Moon looked at Section 4 and said that Section 4 only applies to impasse arbitration.
Why were they looking at Section 4? What was the issue before them?
The issue in Township of Moon was, can the grievance arbitration be a panel of one as opposed to a panel of three?
So maybe Moon was wrong.
I don't think so. I mean,
Well, but you're picking and choosing. The Act clearly contemplates, I think, in Section 1, that grievances will be subject to arbitration. The question is, what does pursuant to the Act mean? Is that correct?
right, in accordance with the Act. Right, and so Township of Moon looked at the language of Section 4 and concluded that under the language of Section 4, it clearly applied to interest arbitrations only. And the reason why it applied to interest arbitrations only is because it says so. I mean,
But Benincourt considered that argument, did it not?
it did.
And rejected it.
It did. Right.
And it was wrong in rejecting it for what reason?
Because Section 4 is about impasse arbitration. And Section 7, which is really the section that is critical in this case, is also about impasse arbitration. The key language I think that we're trying to resolve here is the language in Section 7. The language in Section 7 says, no appeal therefrom shall be allowed to any court. So one simple way to think about Betancourt is, what does therefrom mean? Right? That's the limiting language. No appeal therefrom shall be allowed to any court.
Should we consider the fact that I think it's been 30 years since Betancourt, is that right? 30 years?
It has been 30 years since Betancourt.
That the General Assembly hasn't seen, they could have stepped in any day, they could step in today and tell us we were wrong, right? The fact that they haven't done so, does that signal some legislative acquiescence in this court's perspective on the matter?
I don't think so, Your Honor. I think the doctrine of legislative acquiescence doesn't put a burden on the General Assembly to reach out and affirmatively change acts when it's not otherwise changing them. There have been no amendments to Act 111 since Betancourt. It's when there's an actual amendment. If the court started amending, if the legislature started amending Section 7 and didn't change the language, that may be one possible indication of legislative intent. But there have been no amendments to
I'm not certain
Section 7.
I'm not certain that that's an accurate description of what can or must take place. I recall distinctly about 6 years ago deciding a case for the court in which we concluded that the manner in which a regional task force for police officers was put together was not permitted by the Act. And it upended the manner in which task force were doing DUI checkpoints. The legislature changed that act in 30 days, because we either got it wrong or we got it right. It said what we said it said, but that's not what they meant. So if the legislature is dissatisfied with something that comes from this court, it's not that they're not aware of what we do.
Yeah, the same thing happened with PROTS, with
Right.
workers' comp. Same thing.
Hey, counsel, a question. At this point in time, it appears that your argument is that you don't like the decision of the arbiter and you want us to change the scope of review. I don't believe you've gone to answer Justice Robson's question as to why we should vacate stare decisis. You indicated that you'd get back to it. Could you please get back to it now and explain to me? Because right now your argument is the city doesn't like the fact that the arbitrator makes a decision, therefore we want to change it.
Right. Yes, Your Honor. And just to put that into context, I think that the start of that argument is not simply that we don't like what the arbitrator said, but that the Betancourt decision was not grounded in the text of Act 111. That's part of the stare decisis inquiry. It's also been over 30 years of horrendous decisions that have created problems, right? In situations like this, the message, just in this case, for example, in Smith and in these types of cases, the message that is sent to the public is that the police can get away with this. The message that is sent to other officers is
So
that
you're asking us to make a policy decision with regard to Act 111, and that's a creation of the General Assembly, and they are empowered to make policy decisions for the people of the Commonwealth of Pennsylvania. So I guess following the stare decisis and the fact that I believe it was Justice Wecht who asked you regarding the General Assembly's refusal or failing to amend Act 111 since Betancourt. So with those two strong arguments against you, tell us this hurdle that you want us to come. Why are you asking us to make a policy decision when that falls within our friends in the General Assembly?
because I'm not asking you to make a policy decision. Ultimately, the language of the statute is the language of the statute, and a reading of Act 111 shows clearly that Act 111 is about interest arbitration. There's the reference to one reference to grievance, which we've been talking about. The rest of it is about interest arbitration.
And what is it? What test should we give? Are you seeking the essence test?
We're seeking, if it's silent, which is our argument, then the court should use either the J&OV test or the essence test. Correct.
The essence test, as we know, is dealing with public employees.
Correct.
Public employees have the opportunity and the power to strike. Act 111 has precluded firemen and police, firefighters and Philadelphia officers from striking. That was a major concession. So what you're asking us to do is acknowledge a major concession and revoke Act 111 based upon a decision that, again, other than your argument, it looks like stare decisis, and the last 30 years of common law indicates that we're on the right course.
I would respectfully disagree with that last point. I think that unless what you mean by on the right course is the legislative silence. And I will come back to that. But on this comparison to the employees under Act 195, I suggest that one proper comparison are the guards and security guards who are not permitted to strike. So then you have an actual direct analogous comparison, right? You have the Act 195 security guards who are not permitted to strike and who have the essence review.
Once again, this is a policy argument. The fact that Act 195, it's a creation of the General Assembly.
It is.
Therefore, if you want security guards to be included in Act 111 or vice versa, it's not for this court to decide how the General Assembly should create its writings. We just interpret them.
It's not, Your Honor. I was just going back to your point about how there's a big difference because there's the right to strike. But neither security guards nor police and fire have the right to strike. So that's directly analogous. And you have to continue that by saying, what does the language say in both statutes? And importantly, there is no scope of review in Act 195, and there is no scope of review in Act 111. So in each case, the court, in Act 195, the court was willing to infer an essence test from the silence. We're asking this court to do the same thing, to infer an essence test from the silence.
All right, if you, unless the justices have more questions on the narrow certiorari standard, do you want to move on to the part of your argument focused on the public policy exception if we decide not to change the narrow certiorari standard?
I do, and if I may just answer one other point before moving on. I think that this concept of legislative acquiescence is, certainly the General Assembly is permitted to step in right away. That happens, but I think that what the case law suggests is that there's no obligation for them to step in right away. And the fact that 30 years have gone by and they haven't amended the particular statute is also important. If they had amended Section 7 itself since Betancourt, that would be telling, but they haven't. And I contrast this to the E.L.R. decision, which is from 5 or 6 years ago, I believe, where this court looked at the fact that the statute in question that the General Assembly had gone into that section dozens of times. There's no comparison to that here. They could have acted in the 30 years, but that imposes a burden on the General Assembly to correct judicial errors that this court has recognized as not their burden.
Well, maybe they thought we got it right.
Maybe. I don't. They might.
Well, that's why statutory construction, that's why stare decisis is at its strongest in a statutory construction case as opposed to a constitutional case, because of the deference to the legislature. If we say what a statute means, the General Assembly has carte blanche power to amend the statute, to alter it. Unlike the Constitution, when we say what the Constitution means, that's purely within our rubric. So you're in this stare decisis hurdle for you in this case is particularly higher.
I acknowledge there's a difference with stare decisis between the statute and the Constitution, but there still is. There are examples where the court will overrule statutory interpretations. I mean, we're not asking the court to create that law, and the plain reading of Act 111 requires that here. So just on one step back before I move on to the public policy, the key language is Section 7. Section 7 is the language that says there's no right of appeal, and that no right of appeal has been interpreted by the courts as narrow certiorari. Right? That is the court has said if there's no right of appeal, that means you have to apply a narrow certiorari standard. Well, what has no right of appeal? And the answer is what Section 7 says: no appeal therefrom shall be allowed to any court. So what is therefrom referring to? That's the question. What is therefrom? Therefrom, in Section 7, refers to the Board of Arbitration. The Board of Arbitration is what creates. Is what judges when there's an impasse. So the language of, Betancourt simply just misunderstood how that worked. I mean, I don't know a more respectful way to say that, but the limiting, narrowing language, the Section 7 narrowing, limiting language, only applies to interest arbitration. That's all the therefrom refers to. And if it only applies to interest arbitration, this court is free. And plus, in terms of the history of the act, it makes total sense. It makes total sense that that the General Assembly would be very reluctant to have prolonged litigation when you're talking about the formation of a collective bargaining agreement. But when you're talking about the interpretation of a collective bargaining agreement, which is what grievance arbitration is, you're talking typically about one employee, specifically if it's a disciplinary grievance. That's not the sort of thing that's going to slow down the operation of the whole police department. That is a very important distinction, Your Honors, and that's why the Betancourt decision was clearly wrong, because there's simply no reason to care about prolonged litigation, which is the purpose of all this. There's no reason to care about prolonged litigation in the context of grievance arbitration. The logic is clear.
We understand that argument. Why don't you go on to the public policy exception?
Public policy exception assumes that the court agrees with the Betancourt decision and finds that this language that I've been talking about, the no appeal language, applies to both impasse and grievance arbitration. Again, we think that's wrong. But let's say the court upholds Betancourt. There is still space for the court to say narrow certiorari applies to grievance arbitrations. But narrow certiorari itself is judge-made. Right? Narrow certiorari itself is a judge-made doctrine. So the court can look at narrow certiorari and import a public policy exception into narrow certiorari. Now that is going to require you to overrule the Smith case, because Smith considered that argument and rejected it. And Smith relied on 3 points, and I'd like to just briefly address all 3 points. Smith relied on the fact that the public policy test is ill-defined and nebulous. But Smith was a 1999 case. We now know from the 2007 case in Westmoreland that there's a very defined way to look at public policy. It's the test is defined in Westmoreland. Number 2, they were concerned that the public policy test would markedly increase the judiciary's role. That's the language from Smith. But as we know, the public policy exception has been construed very narrowly. In fact, this court said in Mill Creek that the public policy exception is a narrow exception to a narrow test. So we're not asking for a broad test here. We're asking for a very narrow public policy test.
If I may, counsel, and I guess this connects back to the nebulous point. Once this court starts down the road of, quote, public policy, unquote, as the court has done at times in the past, more so when some of these folks were sitting on the court than in recent years, but it has done so. The more it does that, the more it ventures into the legislative realm, doesn't it? In other words, even though we are an elected bench, we weren't elected to declare public policy, were we? Isn't that the realm of the General Assembly? Because once this court starts to invoke public policy in support of its decisions, the question necessarily arises: did we take a poll? Do we have some other thermostat that tells us what the public mood is? Because at bottom, when a court speaks of public policy, isn't that just the seat of the pants sentiments of the individuals who happen to be sitting on the court at that time?
And may I add another layer to Justice Wick's question when you respond, and that is there a difference between our court creating a public policy and recognizing and invoking what is quite obviously to most people an accepted public policy?
So I understand, Your Honors.
Well, I don't join the most people thing. I don't know what most people think. That's not my job. My job is to interpret the Constitution and laws. So I wouldn't ever feel comfortable venturing a guess as to what most people think.
Well, then let me strike my most people part of the question and just say something that is quite obviously recognized.
By
Agreed.
statute.
It
By
has to be-
statute.
By statute and
Or
by
the
previous,
Constitution.
previously by the legislatures as well.
There you go.
Okay.
Or as,
Now, this is a very long compound question.
Yeah, I don't know if,
And she just answered Justice Weck's question, so, so move on.
well, I'd be more interested in your response.
I agree with Chief Justice Todd, but I would say that this court has already allowed for that in the Act 195 context, right? It has created that public policy exception. That didn't come from the legislature. That came from this court. But the court's articulation of that is that there has to be the public policy has to be well-defined, dominant, and ascertained by reference to the laws and legal precedents. That's all we're asking this court to do. It's very narrow.
Counsel,
Oh,
I'm sorry.
I'm sorry, were you finished?
I thought he was.
That was such a long question, I guess I anticipated a longer answer.
Well, I think
You got
that,
it.
yes,
Okay.
that is it. It's just that,
Counsel, you previously just said that there were numerous horrific cases. If we follow your public policy, doesn't that conflict with your comment now that by changing the public policy, there would be less cases?
not sure I understand, Your Honor. I'm sorry.
You indicated that there were a horrific number of cases. You're asking us to change the system, which means you're now requesting more judicial involvement. Why?
Well, I don't.
But you're asking us to overstep our boundaries of the General Assembly's confinement of arbitration and our Betancourt decision from, what is it, 98? 97?
Betancourt's 95, Smith's 99, and I think that I didn't mean to suggest that well, what I meant to suggest that there have been horrific results, including this case, under that legal doctrine. But if the court, again, if the court accepts Betancourt, all that means is that the court's applying narrow certiorari. Narrow certiorari is a judge-made test. We're asking the court to import a public policy exception into the judge-made test, but a very narrow public policy exception. As this court said in Mill Creek, it has to be a narrow exception to a narrow test. It's only the very rarest few cases.
So articulate for us what this narrow exception to this narrow test should be.
Yes, and I'm recommending that the court adopt the same test that the court adopted in Westmoreland for Act 195, which itself was judge-made. And that is, it had three parts. First, a reviewing court must identify precisely what remedy the arbitrator imposed. Next, the court, and I think here's the part that cabins it. Next, the court must inquire into whether that remedy implicates a public policy that is well-defined, dominant, and ascertained by reference to the laws and legal precedents, and not from general considerations of supposed public interests. And then there's a third part that says that the award then has to violate that policy. But it's that last part, Justice Weck, that I think is at least attempting to address your concerns, that we're not trying to globally, take the temperature of the room. These are public policies here that are limited to ones that are dominant, well-defined, and ascertained by reference to
Counsel,
laws.
let me, as someone up on this court that was in this situation that had to apply the public policy exception when I was on the Commonwealth Court, the public policy exception, as I understand it, requires you to look at the award and determine whether the award violates a dominant public policy. Now, you say this award was egregious. I think the Betancourt award was egregious. I think the Smith award was egregious. So we're not breaking new ground here. But my question is, what about an award that finds misconduct against the police officer, suspends them without pay for 50 days as opposed to a termination, violates a dominant public policy? Where is the dominant public policy that says, a statute that says this person must lose their job?
Yes, and I'll answer that in 1 second, Your Honor, but let me first say that question itself, obviously assumes that, I mean, what we're now talking about is what the public policy exception looks like. We've already, that has now said.
Well, okay, well, your 1 second is up. Give me a public policy that says this officer had to lose his job for what he did. I'm not saying if I was the arbitrator, I wouldn't have had him lose his job. I'm just saying if you're going to invoke this narrow exception to the narrow review, and it has to be the award that dominates a dominant public policy, give me the policy that said, under these circumstances, has to lose the job. Suspension without pay is not good enough. Training is not good enough. Demotion is not good enough. Public policy, have to lose your job.
Public policy is just, as in PHA, the public policy against sexual harassment. And what would happen here is if this individual is reinstated, it's
Reinstated to supervise the same women he had harassed? Was he reinstated to the same position as superior to the same 2 women he had sent the pornographic video to?
Well, he was reinstated to the same position. I know that one of the officers was promoted in the interim, and I don't know if he would actually have been the supervisor of the other one or not. I'm not
Okay,
sure.
that's fair, but he was reinstated to the same position.
Same position, yes, in the same office, and people obviously know what happened, and that is so the
You said it has to be clearly defined, set forth in statute, and this issue of the public policy exception has been debated on this court about this very issue. There are some dissenting or concurring opinions on this very subject about, and I think we're actually dealing with the case later, not today, but at some point in time dealing with this, is there's a continuum of misconduct. There is also a continuum of punishment. And the question is there certain misconduct that, as a matter of public policy, demands firing, and no lesser penalty could ever be adequate from a public policy perspective?
Yes, and our position is this is that case, right? That combination of the correlation between the punishment and the action necessitates termination here. He sent a bestiality video to 2 female subordinates. Then when he wasn't sure if they got it, he sent it again, and then he asked one of them to lie about it, at least one of them to lie about it. Yes, this person is a supervisor to them. He can't continue in that position. If any case is going to fit into that public policy exception, this would be that one, Your Honor. This would be that case. He had been.
Was Smith that case?
Yes.
But in Smith, this court did not adopt the public policy exception.
Correct. We're asking the court to overrule Smith. Correct. And 30 years have gone by since Smith now, right? And I'm sorry, 26 years have gone by since Smith. And as I started before when answering about Smith, the world is different now than it was 26 years ago. This is the, you and I started this argument today talking about the stare decisis factors. Let's apply the stare decisis factors to Smith, as you have to, because we're asking the court to overrule that as well. And in the 26 years since Smith, look at what's changed. We have a public policy exception. We know that the public policy exception has worked. And when I say it's worked, it certainly hasn't slowed down how things have gone with Act 195 employees, right? I mean, this fear of bogging down the system hasn't happened with 195 employees, so there's no reason that it should happen here, right? So the existence of the public policy exception defined by this court, its operation, and plus we know that in the last 26 years, we know that a lot of unfortunate cases have happened. So it has proven to be unworkable, and there's it's even more than it's unworkable. We know empirically that there's a workable solution.
All right, we understand your argument. Is there anything you'd like to say to conclude?
No, just
That's a perfect answer.
Thank you, Your Honor.
Thank you. Thank you. All right, we'll hear from Mr. Bielski for the Aplt.
Good morning, Your Honors. My name is John Bielski, and I represent the Fraternal Order of Police, Lodge Number 5. as Justice Brobson has indicated, this is about stare decisis. We have a decision by this court at 30 years old that's been in place and been effectively reapplied in grievance arbitration awards over the last 3 decades. Counsel for the city claims that somehow the justices in 1995 got it wrong, but then he would also have to claim that the justices up until Northern Berks County Regional Commission, that was wrong, the case written by Justice Donahue. The fact of the city also takes the position that somehow, at least in their brief, that it was a perfunctory decision. They didn't really go into the analysis. They did. I mean, Act 111 is a 2-page statute, maybe 11 provisions, okay? They looked at the history of the statute. What was the problem that they were trying to address? Labor unrest in the 1960s. What was the remedy they chose? They chose to have that police officers would continue not to be able to strike, but they would get the right to collectively bargain and the right to have an adjustment of their disputes and grievances in accordance with the terms of the Act. That's what they got. And that's what the court in Bencart looked at, and then they applied it. And in the end of the day, they said, using principles of statutory construction, they determined that grievance arbitration, in fact, is included.
Can I ask you a question about the narrow certiorari? Was that wrong? I mean, should the court instead, way back in '69 in City of Washington, have just said that the no appeal language is unconstitutional, rather than crafting a narrow certiorari standard based on, I guess, a rule of this court which was repealed a long time ago?
I mean, I guess the court,
was that the original sin, in other words? The court starting, crafting something from scratch, so to speak, rather than just saying that's unconstitutional?
I mean, I guess the way I think about this, Justice Wecht, is that it seems to me that it wasn't unreasonable. Even if Rule 68.5 didn't exist, it wasn't unreasonable for the court to say, well, there's got to be the most minimal of a scope of a review. I mean, the whole purpose of adopting that rule at the time was, to provide some due process rights.
Yeah, I think it's just interesting, and it's a sidebar, but you see the sort of the fork in the road there is do it clean, so to speak, say that's unconstitutional, or say, well, we're going to leave that in place. We're just going to say that they didn't really mean it. They meant we're going to have this narrow standard, and that sort of cures the pretty glaring constitutional problem to say there can be no appeal ever at all.
Right. I mean, certainly, I guess the court could have gone that route. I mean, that would have been one way. I mean, but just to, but they ultimately, there was a Rule 68.5, and they decided for due process grounds that they were going to apply that. I mean, one thing that they absolutely made clear in Ray Washington when the scope of review was first applied was they pointed out, as we've been discussing, that the statute says there shall be no appeal. So they're trying to honor that provision, but still recognize people's potential due process rights. So, I mean, it seemed, it's a reasonable decision and interpretation, including it. I also want to point out, I mean, I've said it, but the fact of the matter with Batten, it's not like Battencourt's the first time that the court had considered what Act 111 means. And it certainly wasn't the last time. Okay, as I said before, it's been considered and reapplied, throughout the 3 decades. But counsel mentioned Township of Moon. And I just want to, if I may, read a portion of that decision, because I think it goes right to this issue. And they said, it is difficult to accept appellant's underlying premise that the legislature intended to exclude grievance arbitration as a method for resolution of disputes as to meaning, interpretation, and implication of the terms of the collective bargaining agreement. And then goes on, the mere fact that the arbitration procedure is set forth in the context of an impasse does not warrant the inference that the concept of binding arbitration was limited to the resolution of contract negotiation difficulties. To do so would render meaningless Section 1's assurance that the resolution of grievances and disputes comprise part of the subject matter to be addressed by the Act. This court has already been considering it. And if you look at all the decisions, I'm sure you're aware, there is a consistent review of the history of the Act, what was going on, why the legislature enacted the Act, also mention of the state constitutional provision that was adopted to allow for Act 111, and what the balancing was that was created. This is not like new, and to suggest somehow that oh my gosh, I didn't realize that the statute has been misinterpreted is simply in error. And this court has considered it repeatedly and continually affirmed it, that this narrow certiorari scope of review applies. And just a few other points. I mean, I agree with Justice Dougherty, I think, who indicated, and I guess Justice Weck, that this is a legislative function. What they want is for you to modify and rewrite this statute, which is simply in our tripartite system of government is not permissible.
Mr. Bielski, go ahead, Justice Donahue.
But, counsel, we did, in a way. If the provisions contained within the Act that require that there be no appeal and narrow cert applies to grievance arbitration awards, how did we find that the three-arbitrator panel that's set forth within that same arbitration provision doesn't apply to grievance arbitration? We decided, no problem, using the Uniform Arbitration Act in that context. And if you could explain the legitimacy of that inconsistency within our jurisprudence, I think that would be helpful.
Well, if I understand correctly, I believe that's Township of Moon, in which that's discussed. And Township of Moon was a case in which an Act 111 interest arbitration panel had adopted a grievance and arbitration provision for the collective bargaining agreement. One of the issues in the case was whether or not that is allowed. And one of the arguments was that it's not, one of the parties to the case tried to argue that that was not allowed because grievance arbitration is not mentioned, despite Section 1's clear reference to disputes and grievances. So the court says, no, grievance, they can create an interest arbitration panel under Act 111 can create a grievance, and arbitration provisions in the award. And then they went on to the issue, so apparently in that award, they used the Uniform Arbitration Act provisions and
they used a single arbitrator.
Right, exactly. And then and the argument was, well, is that illegal? To do so, because Act 111 has different procedures. And the court in that case ultimately said, well, if we're just talking about whether or not we have three-member panels and other things, it just is not relevant to whether or not to impose that on grievance arbitration. So, that was their interpretation of it.
But it is inconsistent, is it not? Doesn't necessarily make it wrong, but that's picking and choosing what provisions in the interest arbitration provisions of the Act are going to be applied to grievance arbitration.
It is, at least in the terms, but in the context of that decision, it was an award that used the Uniform Arbitration Act provisions to create a grievance procedure. So it wasn't, you know, I don't believe that the case stands for the proposition that you can just ignore that you can just always ignore what's required under Act 111 for at least interest arbitration.
Benton Court said there was no problem with that decision, but I mean, looking at the reasoning as we're required to do, it just brings that question to my mind. And you know, those two cases were not decided that far apart in time.
Right.
But to decide to use the Uniform Arbitration Act to provide the framework for the grievance in one situation, and then very shortly thereafter to say, no, not so fast. This is a no appeal, which triggers narrow certiorari, and as opposed to the Uniform Arbitration Act, which would have given the JNOV review. Is that problematic?
Again, I don't think it's problematic because it was a part of the process that created the grievance in that case. I mean, that's what, you know, that was what they were reviewing. They were reviewing whether or not a panel could create a grievance and arbitration provision and then use certain parts of the UAA to sort of create that panel. I mean, in the end of the day, the court said, well, yes, you can do that. I don't know if the case stands for the proposition that the UAA always can be used with respect to certain provisions of the UAA could always be used for grievance arbitrations under Act 111.
And of course, Benton Court said that.
And then Benton Court effectively, you know.
The suggestion that I'm making to you was not unique
but
to
Benton
me.
Court
It was
also,
made to Benton Court
I'm sorry,
also.
Your Honor, apologize.
Go ahead.
But Benton Court also, you know, it rejected the idea that the UAA applies.
Right.
I mean, and because it was inconsistent with the UAA, the Act 111 was inconsistent with Act 111.
Okay,
So,
unless there are further questions on Bennett Court and narrow standard of the narrow certiorari standard, I'd like to move on to the public policy exception.
and that seems to me also a situation of stare decisis, Your Honor. And this court has said that
But we've recognized a public policy.
you have recognized it in under para,
Correct.
which does not have the language that exists in Act 111 that there shall be no appeal. That's why Smith ultimately ruled the way it did, was
So you're saying
because
it would be impossible for us to keep Bennett Court and preserve the narrow standard of review and impose a public policy exception?
I think it would be this court has
Because
consistently.
it seems possible to me, the way I've looked at
It
it.
seems inconsistent both with decisions of this court that keep on saying, just as in Benton Court, that the restraint, judicial restraint, they said, is the linchpin of the Act, of Act 111. And other decisions of this court have made it clear that, and actually have ruled in the ways they do, whether it's on, you know, whether the court or arbitrator can hear mootness, whether they can hear arbitrability, that can't be done because it's got to be an arbitrator, because judicial restraint is again, an important component of the statute. And so I would just say that while I understand that this court has in fact applied the narrow cert standard in Act 111 awards, even though the language says there shall be no appeal, but I would say that if you add a public policy exception to this, you are expanding the amount of review that can exist.
That's true. That is true. But on the subject of judicial restraint, if we are not creating a public policy exception, but simply recognizing and invoking a public policy that is already very well evident in existing statutes and laws, and applying that to this type of case, I don't see where that would be inappropriate. Maybe you can explain why it would be.
It would be.
We're not creating it, right? We're just recognizing it.
Well, I mean, I don't know what the, respectfully, I'm not sure I understand the distinction.
Well, let me explain the distinction. If we have, as in this case, a supervisor of a number of police officers, including two women who are subordinate to him, and he sends them sexually explicit texts culminating in sending them a pornographic video depicting sexual relations between a dog and a woman, sending it twice and then approaching them to make sure they received it and asking one to lie if asked about it. If there is not a public policy exception for sexual harassment that encompasses that, then I'm not sure what a public policy exception would encompass.
I mean,
Question mark.
I mean,
Thank you.
the public, again, the public policy, the public policy exception would be, I can't say in derogation to the no appeals language, but it would send the court down a road, which is, I think, what's suggested by Justice Wecht, that if you can do that, then what's the next thing that's going to happen?
Yeah, because isn't the point, counsel, that once we, this sort of connects to the point I made earlier about your so-called, my moniker, original sin, is once you start eroding the no appeal language and go further and further, there's no limit to what we can all imagine is a public policy exception.
Right. I mean,
there are all kinds of human misbehaviors and corruption that we encounter, that we've experienced, and that we can see, and the door opener is then foresees cases coming to this court with requests for creation of an additional exception, and then the justices of the court are debating how much bad behavior is enough.
Right.
Isn't that the problem?
yes. I mean, and when you start saying it that way, that sounds like a policy issue that is best left with the legislature.
But if it comes to us, again, in a different circumstance, what the court would be debating, I think, is the subject matter before us already recognized by existing statutes, by our legislature, as a public policy, not should we create a new one. So I don't see that as a problem, particularly in an extreme case like this, which I think would be very difficult to argue that this was just bad behavior and not something encompassed by the state's public policy, recognized public policy against sexual harassment.
But the question or concern is, as Justice Robson indicated, for the exception, we have to look at the remedy or the award. So it's not the conduct, however repugnant it is. It's whether the suspension without pay is grotesque compared to termination. So that's the issue.
Right.
I believe Justice Wecht is indicating that once you open that door, we're permitting judicial review and sticking our nose where the General Assembly has limited to. Again, I believe this is more of a General Assembly problem and not a judicial problem.
Counsel, can I turn this all into a question?
Sure. That'd be good.
So my question is, if there were a statute passed by the General Assembly that goes beyond just saying sexual harassment, I mean, I think we all agree sexual harassment is repugnant. I think the General Assembly has acknowledged it in statutes. I think Congress has acknowledged it in statutes. So let's get past that debate. Right. Sexual harassment is repugnant. Let's say the General Assembly passed a statute, though, that says not only is sexual harassment repugnant, but it shall lead to the automatic discharge of any public employee in the Commonwealth of Pennsylvania. Let's say it said that. And you had this exact arbitration award here, where the arbitrator's like, yeah, he committed sexual harassment, but I think firing is too much, spotless history. I'm not saying these are the facts in this case, but I'm saying like that case. Spotless history, and the arbitrator goes, not irredeemable. I'm suspending him without pay for 50 days and putting him back into place. If we had a public policy exception in place, would that statute that I'm talking about, that specifically says it's the public policy of Pennsylvania that a person who commits sexual harassment cannot be employed by a government agency, come into play?
Does, in your hypothetical, is it a statute that says it's the public policy, or is it that,
well,
or is it that, or does the statute say there shall be no public employee, no public employee may be continued to be employed if they engage? The latter?
Yes.
Then it falls within the illegality portion of if an arbitrator brought that person back, and there's a statute that we just described, then it would fall within the third prong. It's excessive. He exceeded his authority. The legislature has spoken. It is said that no one can be employed who has engaged in sexual harassment.
This was, I think, Justice Sandra Schultz Newman's point in the dissent.
Correct.
Who this courtroom is now named after, by the way, the first woman ever elected to the Pennsylvania Supreme Court. I think this was her point in her dissent was, what is the difference between adopting a public policy exception? Now, she felt, I believe, that the public policy section was subsumed within that part of the test. So, would you agree with Madam Justice Newman that there is sort of already a public policy exception baked in to the Benacourt standard?
I guess the way I'd say it is, I mean, if I remember her dissent, she indicated that there was like a morality code, or I can't remember what the provision was, and that the officer in question had violated it, and so bringing him back was illegal, right? I mean, I don't claim to know the details of that case, like the underlying details in the factual case, but that is an argument that could be made. And quite frankly, it's an argument that could have been made here, but wasn't. I mean, they could have made the argument, the city of Philadelphia arguably could have made the argument that sexual harassment in the workplace is prohibited under Title VII and under the PHR and is illegal. And therefore and argued that the arbitrator could not have brought this person back under those grounds. Now, I'm not saying that would have been successful, but it is what Justice Newman was getting at. But that indicates that it's not the standard, it's not the scope of review that's the problem. Keep in mind, the city didn't do that, and of course waived their right to do so. But that's not, they are, I guess, to answer your question, they are very similar. That is a public policy in this type of scenario. Whether something is illegal and you can't bring it would necessitate an arbitrator engaging in a legal act and a public policy exception.
All right, are there any other questions? Thank you very much. Well argued by both.
Thank you.
Well, from sexual harassment to insurance. The appellee in this appeal, Balfour Beatty, develops and operates privatized military housing projects across the United States, including Tyndall Air Force Base in Panama City, Florida. Appellee insures its properties through multi-tiered insurance towers obtained from various insurance companies, including Aplt. When applying for policies, appellee is required to submit a statement of value for each property, which includes estimated replacement costs. For the 2018-2019 policy year, appellee obtained a second-tier policy from appellant Penn Patriot Insurance Company for $50 million, which would be paid only if appellee suffered damages above its first-tier maximum coverage of $100 million. Notably, in its policy application, appellee provided a statement of value of approximately $68 million. In 2018, Hurricane Michael caused significant damage to Tyndall. Appellant's adjuster estimated the damage amount to be approximately $250 million. Appellant, however, refused to pay out on the policy, alleging that appellee misrepresented the statement of value for Tyndall in its policy application. Appellee filed a complaint to recover the unpaid policy limits, and appellant responded by asserting the affirmative defenses of fraud and equitable estoppel based on appellee's allegedly low statement of value. The trial court held that the defense of equitable estoppel is not viable for an insurance claim. Appellant sought permission to file an interlocutory appeal, which both the trial court and the Superior Court denied. We granted review to consider, 1, whether equitable estoppel is an available defense to an insurer, and 2, the appropriate standard of review for orders denying an interlocutory appeal. Good morning. Please proceed.
Good morning, Madam Chief Justice Todd and Justices. May it please the Court. Maureen McBride for Appellant, Penn Patriot Insurance. With me is my partner, Joel Frank. Your Honors, the question before this Court, the primary question, is whether equitable estoppel runs only one way in an insurance relationship. Our position is simple. Fairness requires reciprocity. If insureds may stop insurers from denying coverage after inducing reliance, insurers should likewise be able to invoke estoppel when insureds mislead insurers to their detriment. That's because equitable estoppel is a doctrine of fairness. It must apply symmetrically. Denying insurers the right to do that, categorically denying insurers a right to use this defense, makes it one-sided and unjust. In this case, as Chief Justice Todd mentioned, Penn Patriot issued excess coverage in 2018 based on Balfour's representations, and I want to make it clear they were not estimates. These were observable facts presented by Balfour, which is one of the largest construction contractors in the U.S. that builds and manages military housing throughout the country. It has its own engineers, architects, and construction experts, and it touts its ability to build military housing inexpensively. So this is a sophisticated insurer providing factual information to an insurer. Certainly.
Of course, we're not just deciding this case. When we decide the case, it's going to be a holding one way or another, one of many ways, I guess. And to once again invoke the door opening metaphor, I have a concern about a holding that would put an arrow in the quiver of carriers so powerful that that denials of coverage become epidemic. I just don't know where the addition of the equitable estoppel tool leads us in in coverage disputes, and I'm concerned, given that whatever the relationship between these two entities is, the general disparity in sophistication and bargaining power between the carrier and the insured. Now you have a whole, you would have, wouldn't you, would you not have an entirely additional layer of coverage denials based upon not the fine print, that's the first step, but now the importation of equitable estoppel doctrines?
Justice Weck, that's an excellent question. Let me just say from the beginning that this is a very limited defense. The insurer must prove a material misrepresentation, actual prejudice, and it has to prove justifiable reliance, which is also going to be only applied in very limited circumstances. It has to prove it by clear and convincing evidence, and it has to relate to the specific claim at issue. And I recognize that you're looking at the broader rule, not the specific case, but in this case, this is a sophisticated insured who submitted a statement of value. Now we're talking about 174 locations and 20,000 separate buildings. This is Balfour's business. This is what it does. It builds and manages military housing. It understated the values. It created a spreadsheet and provided a statement of values that intentionally, well, whether it's intentional or not is irrelevant to the question, but that systematically lowered the values in places that are high risk, like Florida, hurricane-prone places, while inflating the replacement costs for lower risk places.
Ms. McBride, can I
Yes.
just interrupt real quick? Oh, over here. How are you?
How are you, Justice?
Wasn't there a specific provision in the insurance contract that said that this insurance contract is not predicated upon a statement of values?
Your Honor, this is an equitable, we're talking equity now. We're not trying to rewrite the contract, but equitable.
This is where I'm going, because
Yes.
if we allow the import of equitable principles into an insurance contract or any contract between sophisticated parties, aren't we really allowing parole evidence in to kind of dispute the entirety of the agreement? Because Penn Patriot, I assume, as the insurer in this particular agreement, drafted the agreement subject to negotiations, and there's a provision that says, although there's a statement of values by Balfour Beatty, this insurance tower, this insurance contract is not predicated exclusively on those statements of value. So if that's the case and I'm the insurer, don't I have an opportunity to say, you know what, I don't want to buy in on this tower?
Okay, let me just correct the hypothetical that Penn Patriot did not draft this policy, and I recognize that in circumstances where it's a contract of adhesion or in a homeowner's policy, something like that, doctrines like contra preferendum would protect an insured. This was a manuscript contract that was policy that was submitted by the brokers to Penn Patriot. Penn Patriot did not draft it. And the whole point of equitable estoppel is to not rewrite the, I'm sorry.
Just answer the question. Was there a provision in there that said it was not predicated on the statement of values?
It said that it was predicated for purposes of assessing the premium. And the premium is naturally tied to the risk. And what equitable estoppel does is allow the policy to be written in a way and interpreted in a way that is consistent with the material representations that are made by the insured. Otherwise, there's a bargain that was not struck here. The insurer never agreed to protect against a risk of $250 million when the statement of value said it was going to be $68 million. That's where equity steps in. And I want to be clear, it's not creating a forfeiture of the policy, it's not voiding the policy, because had this insured suffered another loss in a place like Georgia or another location, the policy, and it had gotten to the level of attachment here, the policy would have paid out in this case. The situation is you can't make a misrepresentation to an insured in factual, observable facts, and then seek coverage for something that the insurer never agreed to protect against.
Well, Ms.
Counsel, Counsel, real quick question. There was no integration clause in this contract?
I don't believe there's an integration clause, Your Honor, but again, this is not, we're not talking strict.
You don't believe there was?
I don't believe there was.
Because,
This is not a contract interpretation case. This is a case where equity, we're asking the court, and I want to be clear too, we're not saying in every case an insurer would have this opportunity to raise it. Obviously this court's well-equipped, and courts in Pennsylvania to review these cases and for opportunistic, attempts to disclaim insurance. This is a very narrow defense that requires this kind of material misrepresentation from $68 million to $250 million.
Ms. McBride, equity has to follow the law.
Right.
And you have, I love that old chestnut, getting to the nub of this.
That's the nub.
Equity, I had to get there before everybody else got there.
You started it again.
Equity has to follow the law. You have a term, and I understand this was a broker written policy, and you bought on at a certain level, and I understand all those concepts. But you bought on at a certain level on a product that specifically says the statement of values is used for premium purposes only. Why isn't there a legal remedy that your client would have to file a counterclaim for unpaid premium, whatever the premium you would have charged had those values been properly disclosed? And that's your remedy, is a counterclaim for unpaid premium, unless, of course, your position is that if they would have properly disclosed these values, we wouldn't have participated in the tower, which I have a hard time believing, but maybe that's your position. But I think you need a record of that.
Well, Your Honor, absolutely. And it is, there is, this was before the court on summary judgment, and there are depositions and there is evidence in the record. But your point is absolutely well taken. It's not just about how much of a premium to charge, it's whether to participate at all in the level. And keep in mind, the premium was $68,000 for $50 million worth of insurance. And the way to convince, and this is a problem that Balfour had, it had a very poor loss history, and it had difficulty. It had to get insurance, and it had to figure out a way to get insurance in a way that was affordable for it. And so what it did was it manipulated the numbers so that the numbers appeared to be consistent or a little bit higher than the year before. And this was a renewal policy, so this had been going on for 4 years. They had reviewed this. This was the 5th year, and they kept the numbers similar, but not exact, to make it look like there were a little bit of changes. Meanwhile, they had not added anything to their portfolio. There were no acquisitions. So they led the insurer to believe that everything had remained essentially the same, while manipulating the numbers within that to...
I'm not, my question doesn't get into the nefarious nature of what they did or anything like that. I'm kind of conceding that. I'm just trying to understand. We have a lot of problems in this case, which is why the second and third question we took are very interesting to me. We don't know why the trial court did what it did. We have no real opinion. We have no idea. There are any number. Maybe the trial court felt that there were factual issues or something like that. I mean, I don't know why the trial court rejected your summary judgment motion and granted theirs. I just don't know. And it was clearly interlocutory, no doubt about it. You didn't argue. It's not a collateral order appeal. So you sought the Superior Court's grace to add it to its docket. And I'm struggling to understand why we even review at all a Superior Court's decision not to afford you the grace if you had no right. I kind of liken this to my old area of law dealing in Commonwealth Court with probation and with parole. The Board of Parole, they give you parole as a matter of grace. It's not subject to judicial review. How is a decision not to give you the grace by the Superior Court to hear an appeal that you have no right to have heard something we even review?
Well, let me just, because there were a lot of questions there, let me just start from the last question. Your Honor, this is a novel issue. This is an issue that we have researched. We have not seen any court in Pennsylvania reject the way Judge Patrick did in this case, the defense of equitable estoppel and making it available to an insurer. So I applaud this court for taking an issue that is truly novel, that requires, guidance from this court. And, to your point, I mean, that would be true in every case where the Superior Court denies and refuses to accept a petition for permission to appeal. There would never be an opportunity for this court to review that because it's always a matter of grace if it's an interlocutory appeal.
But that doesn't mean if the appeal's not denied, you're not losing anything. It's just a question of the Superior Court basically said, we're too busy. We've got all these PCRA appeals, we've got family child fast track, we've got all this other stuff. We don't have room to just graciously take this one. We'll see you later. Right?
Well, I understand that, and that's why let me just say that this is an issue that was raised specifically with respect to this defense. There were motions for some partial summary judgment filed by Balfour. They filed one saying, don't let them avail themselves of this defense, and then there was a cross motion for summary judgment saying we should be available. There were no factual issues, and if you read Balfour's brief, they'll say, well, there are factual issues, but they point to their legal argument. They have never said what facts are here. We believe if this case goes back, Judge Patrick will grant summary judgment if this is available, because it's clear it's a material misrepresentation. It's clear, and there's a presumption of justifiable reliance on a material misrepresentation, and there's no doubt that the insurer was prejudiced. So all of the elements are met. We have not heard any factual disputes. They claim it in the brief, but if you read the brief, they don't cite to any factual questions.
Could you remind us, counsel, why there's no adequate remedy at law?
The issue about whether there is an adequate remedy, and thank you for reminding me, I meant to get to that. Certainly there are other affirmative defenses, right? There's the defense of fraud, there's right. But fraud requires, it's a higher burden. You have to prove intent, and it's going to be the rare circumstance where somebody admits that it misrepresented something intentionally. So it's a higher burden. But the key is, with respect to fraud, it would vitiate the whole contract, even if it didn't relate to the claim at issue. So if you lie on an insurance policy and it's material and all the elements of fraud can be proven, the entire policy goes away. We're not asking for that here. What we're saying is equitable estoppel is a limited remedy that prevents, it stops and prevents the insured from trying to get coverage on a particular claim where it has misrepresented the values.
Wouldn't it, just one more follow-up on that, if I may. In saying your fraud avenue is not enough, or related contract defenses you might have, or contract related defenses you might have, and granting that you would have this equitable tool, would we be risking disincentivizing a robust underwriting process? I mean, obviously it would, I suppose it would save you a lot of money and time. Your underwriters going out there and doing a lot of due diligence. But is that a proper shift in the burden of this engagement that we should embark on?
Your Honor, there are still underwriting guidelines that apply. And again, I mentioned before that this was a renewal policy. It had been modeled. I mean, this is not a situation, and you may hear from my worthy opponent that, Penn Patriot did nothing. That's not true. They had done an investigation when they modeled it originally. They had renewed it and noticed that the total TIV, the total insured value, had increased less than 2%, and that's what they focused on. And this again had to do with, this is excess insurance. I mean, this isn't primary, so we're talking about the risk of catastrophic loss. And so having assessed that, seeing that they hadn't added buildings or locations, they made that determination. So it's not like we are encouraging an insurer to turn a blind eye to any of it. And if that were true, then the defense of, or the counter defense of no justifiable reliance would come into play.
Why doesn't it come into play, counsel? Because I think that goes into one of the questions we're considering, which is whether or not the grant of this certified appeal would, justify a shorter trial proceeding or something of that nature. I mean, if they have a justifiable reliance defense, and, you know, you're allowed to go forward with that claim, it certainly doesn't truncate the trial of the matter, it prolongates it.
Well, Your Honor, I believe that the issue would be decided by the trial judge sitting in equity, and that the issue of justifiable reliance is presumed in circumstances where there's a material misrepresentation.
Unrebuttable. You're saying it's an unrebuttable?
No, I don't know.
Yeah,
I'm
well,
not
they
suggesting.
They could rebut that.
They could rebut it,
With evidence.
but I will say that thus far, and again, there's a record on this, the brokers and Balfour has never given any basis for making changes, and I have the numbers here where they increased values in places like Connecticut from $68 a square foot to $115, while in Florida, they said it went from 87 to 150. So, I'm sorry, to 50. So they reduced it in Florida, added it in Connecticut, in Georgia, 38 to 83.
But wouldn't your underwriters have picked that up?
So, Your Honor, again, the underwriters, again, this is a renewal,
I get
right?
it.
Fifth policy year.
I get it. It's the second tranche. I get it.
Right, and they had already modeled it, right? So they look at that column of total, and let me just say this too, because this is an important issue, and I know we've heard a lot about public policy, but certainly there's a public policy that insureds are going to be truthful. And the whole insurance marketplace would collapse if insurers are not permitted to rely on the truthfulness and accuracy of statements of value that are being made by Balfour, which this is its business. This is what it does. It knows better. It has all the experts, and it's saying this is what we can do. This is how, and we can do it. We can do it inexpensively. This is what we can do. So they present these numbers. I mean, to allow an insurer to just present any numbers at once, and then when the risk exceeds it, to the degree that this does say, well, you know, shame on you for believing us. I mean, that the entire relationship in insurance requires that there be accountability, but also that there be an ability to rely on information as truthful. And this was not. This was the antithesis of truthful information. And then when Balfour is called to task, they say, well, you know, you should have done more. If Penn Patriot had to go and investigate 20,000 properties, I mean, the premium's not going to be $68,000, and then it doesn't become affordable.
Well, that doesn't even happen in tower policies. I mean,
Right.
you're relying on the baseline underwriters to do their underwriting too. Right. So, you know, I mean, I'm not sure whether that's a fact that you're dealing with on this equitable defense is maybe you have some sort of a claim against the primary insurers.
Well, I meant to add, and thank you for reminding me, that 30 other insurance carriers signed on to this program. So it's not, they didn't just fool Penn Patriot. 30 other carriers also, based on these manipulated numbers, agreed to participate in the tower. So, but to Justice Weck's point, the fact that this is a defense that is in addition to fraud or perhaps some other contractual claim, there shouldn't be a categorical denial or preclusion of one category of litigants in the Commonwealth to say everybody else can use equitable principles, but an insurer, because we have to be paternalistic or protection.
But that gets back to my point. We don't know if that's what the trial court did here.
Well, we believe because of the motion for summary judgment, partial motion for summary judgment. So there was a motion to amend to add this as a defense. And then there was a motion for partial summary judgment to say they're not entitled to it. And then there was a cross motion, allow us to avail ourselves of this defense. And there were no factual issues that have been raised to rebut the presumption, as Justice Donahue mentioned. We've never heard, and I don't believe it's in the record, that they have rationale for why the numbers jumped the way they did.
But you also have the trial court refusing to certify it as immediately appealable, which would indicate, I'm not saying your rationale isn't probably the probable one. I'm not discarding that, but we just don't know. And it could very well be, we take the trial judge at the judge's word when they denied certification and said, I didn't deny it because it was a controlling question of law. I denied it for a different reason. So I'm denying your request to amend the order. We just don't know.
Yeah, I mean, obviously, I agree with you. We don't know, and all we can do is look at what the parties have argued. We don't have an opinion from Judge Patrick, and we don't have an opinion from the Superior Court. I will say that there are circumstances, and I've been involved in them, where the trial court has denied certification and the Superior Court has nonetheless accepted review.
That does bring up the other issue, of course. So this case is presumably going to trial either way. Why not just deal with this as normal and let it be tried? And now, I mean, if you had some convincing showing, a ruling definitively here, I don't know if this comports with case law actually, but that a ruling here is going to drive settlement one way or another. That's sort of over the side. But how is this case? I'm not sure how you meet the standard for permissive appeal.
Because, Your Honor, with respect to material advancement, yeah. So we believe that, and again, this is, I think, pretty clear in the record, that if this goes back to the trial court and this court rules that this defense of equitable estoppel is available, as it should be equally, to insurers, that the trial judge on this record will see that there are no triable issues of fact. There is material misrepresentation. There can be no doubt about the materiality of this, given the discrepancy. I mean, this isn't a close call. Upon which the insurer relied, because the insurer issued the policy, not just because it's $68,000 for $50 million, but agreed to participate at all based on those representations. And the policy says, while it doesn't say for coverage, it says for premium purposes, which obviously drives the entire decision about whether or not to participate. So there is reliance. Again, a presumption of reliance if it's a material misrepresentation, and there's nothing in this record, and of course I know Your Honors are not aware of all the deposition testimony, but that could rebut that. We've never heard an explanation. In fact, when insurers asked about it, they were stonewalled when they asked for an explanation. How could this have changed? How could it have changed this much? What changed between 1 year to the next? Yes, Your Honor. Sorry.
Is there an allegation or the potential for an allegation here that this was not a manipulation of the facts, but merely a mistake?
That, I believe, only arose during the litigation process. I don't believe that there was ever a statement made by any of the representatives of Balfour or brokers. I think what they said was market conditions, but never articulated what that means. And certainly market conditions would not allow for the discrepancies here between and among different states. I mean, it's pretty...
Isn't that a question of fact? Isn't that a question of fact?
Yeah,
that would have to be resolved at a trial.
Yes, Your Honor, but again, I think that unless there is an actual concrete explanation and not just a label that's put on it, I mean, they'd have to actually point to facts that say, in Connecticut, the cost of housing went down, but in Florida, we have this. That is not in the record as far as I know. And so that's really the problem here, is that there's never been an explanation that was given after the fact or before. So, I mean, there's really no rationale for it. That's why this is a limited defense, but this is the clearest case. And so we're not asking for every homeowner's policy or every auto policy to allow insurers to do it, because in some circumstances it's not reasonable to rely on what your policyholder says, right? I mean, there may be circumstances where a policyholder says, I have this art and it's worth X, and that person is an art dealer. So maybe in those circumstances you could rely. But this is a situation where these are sophisticated insurers, and there's no public policy or other reason to exclude or preclude insurers, just as a category, to say you're not allowed to avail yourselves of equity, even though you've been materially misled by your insured. I just don't know, who we are protecting. And, of course, the fallout from that is that that kind of conduct would have to be priced into premiums, because now we'd have to say, well, you don't know, and they might be lying, and you don't really have any recourse unless you can prove fraud. So we'll have to price it into premiums. And who suffers? The honest policyholders.
Why should we assume, I hear you, but I guess the immediate question that comes to mind is, why are we to assume that that risk factor isn't somehow priced in? It's priced in already.
Well, because, again, $68,000 premium for $50 million worth of coverage did not price into the fact that they would misrepresent by 73% the values that they were telling us they could do. And this is what they said was going to cost to rebuild. I mean, again.
It's just that if I can just follow up, it just sort of brings to mind the question, well, your client's not a babe in the woods, it's a sophisticated entity, and you have the fraud, always have the fraud tool available. Why we're going to layer in this additional set of defenses that haven't been there before?
Well, it actually helps the insured if it's only equitable estoppel, because again, fraud knocks out the whole contract, even if the misrepresentation related to something completely different from the claim. What we're talking about is a narrow defense that applies to preclude the insured from submitting a claim that is inconsistent with the representations made. So it has to relate to that specific claim. So for instance, if they had been hit by a hurricane in Connecticut and those Connecticut values were correct, even though they had misrepresented the Florida numbers, they could still collect on this policy. So it keeps the policy intact, doesn't vitiate the policy, but it precludes conduct where somebody's trying to make a misrepresentation and then say, aha, you didn't catch me, therefore you must pay. That's what.
How would that work in practice then? Since under your construction, it's not voiding the policy. What impact is it having then?
It would preclude, in this case, it doesn't preclude Balfour from collecting coverage up to its, the amount from other insurers with respect to the claim. What it does is keep it from reaching a layer of excess coverage where the representations were that with respect to this claim, it's not going to get there. And so it keeps the insured honest and requires accountability on insured. And
But you honestly agreed to buy into a $50 million excess layer of insurance. You're being hit with you're sort of choosing through this defense of equitable your remedy for what is essentially a fraud. But you realize that the law does not allow you to void the contract based on fraud. So, and I'm completely sympathetic to this, but you could get out of this insurance at this point in time. Right. You could terminate your participation in this layer based on all the allegations you're alleging, and you got paid premium for $50 million of excess coverage, and on this loss you're paying $50 million of excess coverage, which is what you paid for. Why do you want to keep the policy in place? And if you want to keep the policy in place, why not sue them for the premium that would be required to keep the policy in place?
Well, this policy year is over, right? So this was theoretical, that if they had been hit in Connecticut and the number...
I'm going with your hypothetical.
Okay. But I guess I'm looking at it more sort of broadly, that what we're saying is, yes, there may be other arrows in a quiver that an insurer has, but why are we not allowing insurers this arrow? I have yet to hear from the other side why, with respect to insurers, do we have a different set of equity rules? I mean, equity is all about fairness and accountability. Why are we saying to one category of litigants, you're not entitled to do that? We have other doctrines with respect to contra preferendum, as I mentioned, and construing against the drafter and contracts of adhesion, but that's not what we're talking about here. And I recognize that, this court makes rules, broad pronouncements for all insureds, but this is a narrow sliver that we're dealing with sophisticated parties, material misrepresentations, not a contract of adhesion, a manuscript policy, and just a discrepancy that nobody can explain, that has to be a material thing upon which our insurer has relied. So this is the perfect case for this court to say, in those circumstances, when you can prove it by clear and convincing evidence, you as an insurer, because insureds are allowed, right? And there have been other cases, and there are two cases that they cite, August and Brakeman, where where courts have said, yes, even if, if there's a policy and you give late notice and the insurer is prejudiced, then that coverage can be forfeited. So it's not like the court has only ever said we have to do everything to protect insureds. There are circumstances where insurers have been protected, and all we're saying is that it's never been said that we can't do it. We're just asking this court to affirm the fact that we can as an insurance company.
All right, any other questions for Attorney McBride? Interesting issue, thank you. Let's
Thank
hear
you,
from
Your
Mr.
Honors.
Bashman.
Chief Justice Todd, and may it please the court, my name is Howard Bashman, and I represent the plaintiff Aplt, Balfour, Beatty Communities, a Malvern-based company. With me at council table is Andrew Guthrie of the Haynes and Boone Law Firm and Richard Placey of Montgomery, McCracken, Walker, and Rhodes. There's a lot to cover here this morning. I'm going to start on the procedural issue first because I think that necessarily must be the way that this court decides if it can.
Couldn't you begin with Magna Carta?
But I did want to point out, Justice Donahue, that opposing counsel, I'm sure inadvertently.
There is an integration clause.
There is. It's at reproduced record 388A, and it's right there in black and white in the insurance policy, which is this big. It's not a horrible document to wade through.
Does it matter, Mr. Bashman, if this isn't a contract claim, this is an equitable claim? Does it matter?
Well, it does matter.
Okay.
The first reason is, as we heard from Justice Brobson, we don't know for certain the basis on which the trial judge granted summary judgment to dismiss this defense. And in fact, the summary judgment motion that my client filed in the trial court advanced two separate grounds. The first ground was that this defense is not available as a matter of law. But the second ground is, even if this defense is available as a matter of law, the parole evidence rule prevents it from being used in this case. The petition for allowance of appeal that Penn Patriot filed in this court contained a broad question as question one, which was, did the trial court err in ruling that we can't apply the equitable estoppel defense to avoid paying this claim? But when this court granted review, with all respect, it did more than just rephrase the question presented. It wrote its own question presented, which is fine. But what the question presented this court gave was, is the equitable estoppel defense available to an insurance company in equity to avoid paying a claim? And what I submit to you is that initially this court might want to consider whether to dismiss this case as to that issue as improvidently granted, because it could resolve that issue in favor of Penn Patriot, and the case gets sent back to the trial court, and the trial court says, yeah, I just entered summary judgment based upon the parole evidence defense. I didn't say that this defense is never available to an insurance company. Generally speaking, this court only decides issues that have been.
In other words, you would say we wouldn't, in your scenario, we wouldn't be foreclosed from entertaining the merits of Ms. McBride's legal argument about equitable estoppel, but at a later date, in the event the case ripened to that point.
Absolutely. That's the main difference between the appeal by permission route that this case presents and the collateral order doctrine, which this case was considering 2 days ago in the Chaluti case.
But aren't you speculating as to how the trial judge is going to explain and rule in the future?
No, because the trial court has ruled. If the Superior Court had granted the petition for permission to appeal, and I know that 5 members of this court have previously served on the Superior Courts, so I'm not telling you anything you don't know, and I'm sure it's the same for the Commonwealth Court, even though I don't have personal experience there. If the petition for permission to appeal is granted, the first thing that happens after that is that the case on appeal is paused until the trial court writes the 1925A opinion. And at that point, you know what the trial court's basis for a decision is, which is, of course, not the situation here. And so, yes, Justice Wecht, unlike in Shaludi, where if it is a proper collateral order appeal, the right to appeal at the end of the case is insufficient. In the petition for permission, right? That's one of the elements that has to be established. In the petition for permission to appeal realm, the right to appeal at the end of the case always exists. And the reason that the materially advanced issue is not satisfied here, and we say that none of the criteria are satisfied here, but the reason that particular criteria is not satisfied here, of course, this is water under the bridge now, but this case was scheduled for trial in May of this year, and when the fraud defense, which they're entitled to assert, that's in the case, they're entitled to argue at trial that we committed fraud, and that is going to be the same exact evidence on which...
That's a question, right? Because under their view of the case, or one of their views of the case, I suppose, the parade of horribles would include, they go back, they try this case under Judge Patrick's rubric that says you can't try an equitable estoppel case, and the record's developed, and at the end of the day, they come up here and they win on the merits claim Ms. McBride has today, and then they're going to go back and spend, hundreds of thousands or whatever it is, retrying the whole kit and caboodle under the equitable estoppel rubric. So are you correct that it's entirely dispositive, that there's no other trial evidence that can get in under equitable estoppel that couldn't come in under fraud?
That's exactly what I was about to say, which is the only difference between fraud, the actual fraud defense where they have to prove intentional falsehood, among other things, and the equitable estoppel defense where a negligent misrepresentation would be sufficient is exactly that, whether the misrepresentation, if there indeed was one, was intentional or negligent. And so what we submit is that when this case goes to trial on the fraud defense, if they don't prevail on that defense, and then they appeal from the final judgment in plaintiff's favor, that appeal will allow the appellate court to decide whether they're entitled to pursue the equitable estoppel defense. And if the answer is yes, then the matter is remanded to the trial court where the parties can file proposed findings of fact and proposed conclusions of law, and that whole issue can be decided on this exact same record. There would be no evidence that would support their equitable estoppel defense that is not going to be admissible in support of their fraud defense.
I'm not sure I'm buying that, because if Attorney McBride is putting forth trial evidence only with respect to fraud, she's not necessarily going to be focused at all on the lesser evidence on reckless or negligent insertion, inclusion of these terms, or of these numbers. I don't necessarily agree with you that it's the same factual case.
Well, it certainly is the same factual case with regard to, is this a fact or an estimate? Was it made intentionally or not?
Well, but the bigger issue that the Chief's question raises, though, is would, under that scenario, would you be entitled, to limine rulings that would preclude her, or whoever's trying the case for the carrier, from going into areas that don't rise to fraud? You're saying it's coextensive, but given that they're equitable estoppel is not like a lesser included offense, so to speak, of fraud, and I just don't know whether, or maybe it's not relevant, but should we be considering the possibility that limine rulings could be entered in the trial court, which would confine the record in ways that would necessitate a whole nother trial if she wins on the legal claim later?
Well, the point is that if the conclusion of the trial is that fraud could not be proved because the intentional element of it was not established, the circumstances of the misrepresentation are certainly going to be relevant at the trial on the fraud defense, which again we completely recognize they have the right to pursue, and so I think that it is the case that there won't be in limine rulings that say this level of proof of misrepresentation is not intentional enough, and therefore you have to keep it out. They're going to be able to.
I mean, Mr. Bashman, you could do that, but you're a long game player. You're a hired gun. You come in at the appellate level, and if a trial judge or a trial lawyer is smart enough, they'll consult with you during the case of the trial. And you're a long game player. You wouldn't advise such in limine practice, particularly if we choose not to take this appeal. You would say what you're risking by going aggressively in the in limine route is that if the case comes up to the Superior Court or to this court and we decide the merits issue, you're going to have to retry this case all over again. Wouldn't you so advise a trial lawyer not to pursue such aggressive in limine tactics?
No, I think that's true, and I don't think that it would be successful in any event because, like I said, whether it rises to the level of fraud requires all the evidence of the misrepresentation.
And you want to create a robust record as much as possible, even if the jury doesn't get to decide the defense.
Correct.
You at least have the factual record created.
I'm sorry. Go ahead and answer that. I'm sorry.
No, I think that I think that all that evidence would be relevant to allow the jury to decide whether it rises to the level of intentional or not.
And that's all from the defendant's perspective. But from the plaintiff's perspective, from the insurance company's perspective in trying this suit, don't you think there's a difference as to the strategy counsel's going to pursue to try to press a fraud charge? Then she's not going to want to emphasize negligence principles or negligence facts. She's going to focus on fraud. To me, it's a different case to go back. I don't think the record would be the record she would want to rely on then if she later found out equitable estoppel is in the case.
Well, I understand that from this high level that might seem like a possible distinction. But what I'm trying to say is when this case is being tried and the other side is putting in all of the evidence of misrepresentation that they have to try to prove that it's intentional, that it would, in my view, allow the trial court to consider if they can't reach that standard, whether they had proven enough initially.
Counsel, can I
yes.
just ask, given the discussion that we've just all had, couldn't the trial court just have decided that certifying this question was not going to materially advance the resolution of this matter?
Absolutely.
There was going to be a trial anyway. Was the Superior Court wrong in maybe concluding the same thing? If we decide this issue, it doesn't materially advance anything. There's still going to be a trial.
Absolutely, and that is a main argument that we make here. And in fact, the other issue that this court granted review on, which is the other part of this petition for permission to appeal standard, involving that it must be so egregious as to justify prerogative appellate correction. That also itself is an even higher standard than in a case in which the trial court has granted permission to appeal. But Justice Donoghue, to answer your question, and to respond to something that Ms. McBride said earlier, they did cross-move for summary judgment on the same affirmative defenses that we had sought to have the trial court grant summary judgment in our favor on. And those were three separate affirmative defenses. One was negligent misrepresentation, which they have not sought to appeal by permission. The other was equitable estoppel, which they have, which, as I touched on earlier, is essentially the same thing because it would allow a negligent misrepresentation to deny coverage. And then the third was reckless misrepresentation, which the trial court denied our motion for summary judgment on. And if you look at the trial court's order, the summary judgment order from October of 2023, which is attached to Penn Patriot's opening brief, you'll see that the trial court denied their motion for summary judgment on their cross motion, and did not say, it was denied in part as moot. So it's our view, again, to follow up on what Justice Robson was saying earlier, that you could even read the trial court's order on the summary judgment motions as saying that it was denying summary judgment on all three grounds, and then separately dismissing two of the defenses that we'd asked the court to dismiss.
Ashman, can I go back to the rule?
Yes.
Let's change the facts here. Let's say the trial court judge certified this as immediately appealable. Could the Superior Court still deny it?
Absolutely.
Okay. So here the Superior Court, the trial court refused to certify. The appeal is taken from that. Let's say the Superior Court, let's say we even say that the elements for the certification that are in the rule are there. Couldn't the Superior Court still refuse to take the case?
Absolutely. And in
So we'd have to literally, if we even got to the second question, we'd have to remand to the Superior Court to see if they had some other reason not to take the case that gives them the discretion not to take.
And we would, hate anything that would further delay this case. We heard from the other side, 30 insurance companies had signed on to this coverage. What they left out is that they're the only insurance company that is here today trying to litigate whether coverage is available, because every other insurance company that was on this risk has either paid under their policy or settled with us after we sued them. And
Well, you can't hold that against them. They're allowed to litigate.
No. But again, I think that it's
She's a more zealous
Noted.
advocate.
And as you saw in the papers attached to our brief, the Air Force wants to have this base be rebuilt and have its housing be rebuilt. And this case involves issues that just transcend the facts of this case in that regard, where, I don't want to over dramatize it, but if you read what the Air Force says, the defense of this nation to an extent depends upon having the folks there at Tyndall who can afford to support these amazing jets that are going to be based at Tyndall to defend our nation. They're stealth
It would probably be the
fighters.
first time that the national security of the United States rests in Pennsylvania.
And so, Your Honor, let me turn to the merits if I can, but we do believe that the standard of so egregious as to justify prerogative appellate correction is different than just a mere abuse of discretion, as the briefs explain. Justice Brobson, again, you had the exact same reaction to the other side's merit argument as the trial judge had early in this case, which is, Penn Patriot, why aren't you here asking for more premium if you believe that the premium was set too low based upon my client's representation of replacement value?
Well, maybe they wouldn't have entered into the contract, right? Maybe they would not have entered into the insurance contract.
Well, I don't even think that they're making that argument in this case. What they are trying to do is to re-underwrite this policy at the point of claim. And when they say, they were paid X amount of dollars in coverage, and the amount that they now have to pay out in premium is way above that. I mean, it's like, are they not in the insurance industry? Do they not understand that essentially every time that they're called on to pay a big claim, it's going to be a lot more than what the premiums were? I mean,
That's not this case.
You have to agree that the way these towers are structured, they bought into a layer.
right.
And they didn't buy first dollar coverage. They bought into a layer. So part of choosing to buy into these towers, I don't know if there's reinsurance or I don't know how this thing's all structured. But this is like Lords of London type of stuff, and they price into the premium the likelihood, not saying they would never pay, but the likelihood that the loss is going to trigger their coverage. That's what this
No, absolutely. And if they can prove intentional fraud by my client, then they're entitled not to pay on this claim. So that is, again, I was listening too much to the earlier arguments. That essentially is like the nub of this case on the merits, is whether they can avoid having to pay based on a negligent misrepresentation, or do they have to prove an intentional misrepresentation?
With regard to the theory of equitable estoppel, isn't the cases that have come out in Pennsylvania on that doctrine have a issue where the parties are at disparate sophistication to enter into the contracts?
Well, there's no exception under Pennsylvania law for a sophisticated insured as not being able to rely upon the insurance law of Pennsylvania generally. I don't know if that answers your question.
My question's much more narrow than that. I just want you to acknowledge to me or tell me, no, you're wrong, that the cases where equitable estoppel has been found in the arena of insurance coverage, the one party is a much lesser vantage point in sophistication in entering into the insurance contract.
Right. Those are cases in which equitable estoppel was applied in favor of the insured, which is the position my client's in this case, and against an insurance company. And what we don't have in Pennsylvania, and Ms. McBride alluded to it in one respect. She said this case presents a novel issue because no court has rejected whether an insurance company can invoke the equitable estoppel
Stay
defense.
with me here. So the cases that we have been decided on a case-by-case basis. There's not a per se rule that equitable estoppel is out there for everybody to utilize. The trial court looks at it on a case-by-case basis, correct?
Right. Equitable estoppel is certainly a defense that can be used in contract cases as justice requires.
Okay. And so in this case, from what we hear from the appellant's argument is that your client is, in fact, much more sophisticated in the area which your contract covered, i.e. the building and rebuilding and insurance value and the value of the properties and how much it's going to take rebuilding, and that you had the companies, the construction companies that would actually come in and rebuild at a fraction of the cost. So isn't this a case of first impression where, in fact, a trial court could decide that your company has much more sophistication in the area than the insurance company?
Or at least equal sophistication.
Well, we don't agree that we have more sophistication because certainly insurance companies are familiar with what it costs to rebuild properties. But can I jump to what I think you're trying to get to, which is whether an equitable estoppel defense should be available to an insurance company that's seeking to avoid paying a claim, whether in a case like this or a case generally, which is the question that this court did grant review on as issue 1 in this case. And what we submit in that regard is that this court's holdings that recognize that a party must prove actual fraud to avoid coverage rules out, as a matter of necessity, being able to prove merely equitable estoppel, and that if an insurance company were able to roll back the clock and say, we can rely upon the equitable estoppel defense instead. Let's take the Brakeman case, for example. That included an insurance policy in which the insurance policyholder said, I will give you timely notice of a claim. The insurance company could say, we relied upon you to uphold that promise that's here in the policy, and you failed to do so. And so we're not entitled to it as a matter of law to get off the risk, but we relied upon it, and we're prejudiced as a result. We should not have to pay this claim under maybe a lesser showing than is currently the law in Pennsylvania. And so that's the first point. But also this insurance policy itself, because you're talking about these sophisticated parties, finding that Penn Patriot is entitled to invoke equitable estoppel in this case requires allowing them to put back into the policy language that simply is not there, or to contradict language that actually is there. So, well, they signed the policy the same as we did, and so they agreed that that's the contract. Right. Okay. I accept that correction. Thank you.
So you want to say add to the
right. It would allow them to add to the policy language that's contrary to what the policy actually says. And so at page 427. And what I said earlier was that our submission is that it has been ruled out as a matter of law by this court's holdings that say you have to prove fraud to avoid coverage, and that those rulings, including the August case itself, which says that we are not going to allow a policy to be voided absent fraud, either in law or in equity.
That's
I'm
not what they're
paraphrasing.
seeking, right? They're not seeking to void the policy.
Well, they're essentially, that's the whole other argument. Somehow they're benefiting us by relying upon equitable estoppel versus fraud because...
Well, it's arguably a different remedy.
But it gets the exact same outcome is what I'm trying to say. And so this year is now in the past, as we know. And if they were entitled to prove equitable estoppel, that would have capped our recovery at $68 million. It's not just them. Everyone else on that policy could have gotten the exact same result. But if I can just touch on the two reasons why what they're seeking here is contrary to the language of the policy, which again is why it's not equitable to have the defense be available in this case. The policy says, as we heard earlier, that the values of the property are for premium purposes only and shall not limit the coverages provided by this policy. So we said...
This is great. I'm loving this. But you haven't asked Justice Mundy's concern, answered Justice Mundy's concern. You're going to all the defenses you would argue as to why it's not available in this case. She's asking you a broader question. Is why shouldn't it be available to insureds and insurers alike, and let the chips fall where they may? Everything you are about to tell us, you could tell the court, the trial court.
No, I thought I did answer that, which is that this court's holdings recognizing that you have to prove actual fraud as the basis for avoiding coverage necessarily exclude the possibility of a lesser equitable estoppel defense that the insurance company can invoke. And we're here in the year 2025, and we have decades of insurance law of this court, and the equitable estoppel defense has existed for decades as well. And this is the first insurance company that I am aware of that has come to court and said, we should be entitled to pursue a defense of this nature.
So it's a case of first impression.
We're not denying it's a case of first impression, but the reason it's not been used before is not because those insurance companies also did not have wonderful attorneys on their behalf, but just that none of them was audacious enough to think that they should be able to use a defense, which is Justice Wecht was touching on earlier, would just give them a reason to deny coverage in so many more cases than they're already denying it.
Can I just, I just need some clarity on what we're doing here. It's a case in first impression. We don't have an opinion of the Superior Court that we're reviewing on this issue. We don't have even an indication from the trial court or the Superior Court that they did what they did because of this opinion.
Correct.
I mean, what does this open the door to in the future? Anytime a certification is denied, we can pick a reason that maybe the lower courts did what they did and then just sua sponte decide that issue. I mean, isn't that what we're doing?
I couldn't have said that better myself, and in fact, I wasn't sure I was ever going to get to that point. But if you do that in this case, it's going to encourage everybody to try to bring the denials of it. I'm in the trenches, as Justice Probson said before, and in the trenches, first of all, people realize it has to be an egregious abuse of discretion, and they very rarely seek PA Supreme Court review of denials of petitions for permission to appeal that the Superior Court has issued. And if this court swoops in and decides this issue, which may not even be the issue that was the basis of the trial court's decision.
There are many bases there could have been for this opinion.
Everyone's going to try to get you to get involved because there's a sexy issue in the case. And if this is a great issue, it's going to be in the case at the final judgment stage. And so if I can just wrap up by just pointing out.
Before you do, I think you should walk back the accusation that Attorney McBride was audacious.
Absolutely.
Absolutely. Isn't necessarily a negative. But I considered it a compliment.
I meant it in a good way. Because we're always.
All right, we'll leave it alone then. Let Ms. McBride take it as she wishes.
There are many times that I'm opposing her petitions for permission to appeal, and I enjoy doing that very much. But the other part of this policy I just wanted to touch on is the errors or omission provision, which is in paragraph 22 on page 422A of the reproduced record. And what it says is any unintentional error or omission made by the insured shall not void or impair the insurance hereunder, provided that the insured reports such error or omission as soon as reasonably possible after discovery. There's a provision in here that says you have to have an intentional omission or error.
A lot of facts in there.
Yes. Right, and so we say, we made the report when we told them what it's going to cost to fix the property, but this policy does say, they can't rely on unintentional errors if we correct them when we're able to, and that's exactly what they're trying to do.
Did you do that?
Yes, we did that when we told them what the cost of replacing this property would be following the devastating hurricane, which turned out to be a lot more than anybody had expected. And again, they're not saying that we should have told them it would cost $125 per square feet, which is what it ended up costing. They're saying we should have told them it cost somewhere around $80 per square feet, if I'm understanding the record in this case accurately. So they're not asking for clairvoyance. They're just saying, if you had told us 80, maybe we would have charged you more premium. But again, that was a counterclaim they could have tried to pursue, which they have not. So unless the court has any further questions for me, I thank you. We ask either that this court dismisses improperly granted or affirm the Superior Court's decision to deny the petition for permission to appeal, or affirm on the merits if the court gets to the merits. So thank you.
All right, thank you both. Very well argued. Mr. Minner, would you call the next case?
Downingtown Area School District versus the Chester County Board of Assessment Appeals. Representing the school district, Scott Withers, representing Kelly.
Yeah, I am good, thank you.
The appellant in this matter, Downingtown Area School District, filed a tax assessment appeal in 2019 with respect to 16 properties, including an apartment complex owned by Aplt Marchwood apartment owners. The school district's decision to file the appeal was pursuant to statute and in accord with its own policy of appealing properties, which, if the appeal was successful, would result in additional tax revenue of $10,000 or more. After the Chester County Assessment Board issued a notice of no change in assessment with respect to the apartment complex, the school district appealed to the trial court, which ordered that the assessment be increased in accordance with its fair market value. The trial court rejected Marchwood's claim that the school district's monetary threshold of $10,000 violated the uniformity clause because it disproportionately affected commercial properties. Marchwood appealed to the Commonwealth Court, which in a divided opinion reversed the trial court's decision. The court first noted that this court has not definitively held that use of a purely monetary threshold in selecting properties for assessment appeals is constitutional. Assuming it is constitutional, however, the court found that the school district applied its policy in an arbitrary manner. We granted review to consider whether, in order to comply with the uniformity clause, a school district must appeal all potentially under-assessed properties in the district, and further, whether the school district in this case applied its policy in an arbitrary fashion. Please proceed.
Thank you. Madam Justice Todd, Chief Justice Todd, honorable justices of this court, may it please the court. Scott Withers of Lamb-Mackerlane on behalf of the appellant, Downingtown Area School District. I'm joined at the bar by my partners, Jim Mackerlane and Mark Thompson. Policy 605.1, as Your Honor just elucidated, puts a $10,000 threshold for filing these tax assessment appeals. And it allows the school district two methods to identify those properties. Number one, annual review of recent real estate transactions. And number two, working with a third-party firm to identify potentially underassessed properties. In this case, it is the school district's position that the Commonwealth Court erred in holding that the school district applied this policy in an arbitrary fashion. The Commonwealth Court cited, the majority, cited four reasons, four instances of how the school district allegedly arbitrarily applied this policy, and we believe those were in error. I won't introduce those in order because I think it's more effective to skip around. But number 3 was that the Commonwealth Court majority said that this taxpayer's property was not on the original list of properties that the school district's consultant identified. That was a list of 15 properties. And there was nothing in the record to show why it was added. And that's demonstrably false if you look at the record. The record shows, on the basis of a business manager's deposition, which was admitted at trial, that the property was identified on the basis of a recent sale and added to the list of properties by the school district. And in fact, President Judge Cone-Jubileer pointed this out in her dissenting opinion. Nonetheless, the majority...
Why does that make a difference?
Because the Commonwealth Court's...
I know, but that sounds an error correction. I mean, say they added the property. Who cares? Isn't this about whether or not it violates the uniformity clause and whether or not there's an applicable across-the-board kind of procedure utilized by the school?
That is one of the elements, but that is not that specific finding. That finding was in regards to the Commonwealth Court found it arbitrary for that reason, and the record reflects that that's not the case. The second instance that I'd like to talk about is that the school district rejected a commercial property solely because opposing counsel was, quote, aggressive. This relates to a confusion over parcel numbers. When the consultant initially recommended these 15 properties for appeal, there was a mistake with regards to the identification of a parcel number. That parcel number was erroneously identified a Lowe's home improvement store instead of a property called P-Patch Partners. The school district and the consultant cleared up that mistake, and it is clear from the trial testimony that the consultant never intended to recommend Lowe's for an assessment appeal. Yet in the course of the final days when the assessment appeal was filed, in an email exchange with my firm's paralegal, there was a comment made by the consultant that this property wasn't on the list originally because counsel was very aggressive in pursuing a dark store theory. And the dark store theory is a theory in assessment appeals that says the actual sales and rents occupied by big box properties on the net lease market overstates their true value by factoring in the value of non-taxable assets. And it's kind of a theory that's analogous to this court's value and use theory, which says that a property's use and its resulting value and use cannot be considered in assessing the fair market value of the property for tax assessment purposes. The proponents of that theory contend that a so-called big box retailer is already taxed through its state and local income taxes and on its profits, and then it's double taxed in violation of the uniformity clause. So the consultant explained that there was a big downside in this case of appealing the Lowe's property because of the dark store theory. It wasn't just because counsel was aggressive. It was because, as Judge Cone-Jubileer pointed out in her dissent, it was because putting such a property on the list of properties to appeal as potentially underassessed could backfire, and the dark store theory could compel a result for the school district that would be absolutely contrary to the whole reason that the school district files these appeals.
Well, that may be a good reason to not include it on the list. That doesn't mean that the reason doesn't result in a uniformity violation.
Well, the problem.
I'll tell you, I'm really trying to save the statute. I'm trying hard. This case, again, reading the briefs in this case and reading the Commonwealth Court's decision, I'm just kind of wondering whether it even can be saved at this point in time. But the uniformity clause requires all the properties to be treated the same. And what you just laid out was a individualized decision not to treat one particular commercial property the same.
And Your Honor, the school district has to make those kind of decisions because from a cost-benefit analysis.
I don't disagree with you. I think it was a good decision. If I were the lawyer advising the school district, I would have told them the exact same thing. But that's not what the uniformity clause requires us to consider. It doesn't require us to consider whether the taxing authority had a valid reason from an economic perspective because they didn't want to, because the litigation would have been resoundingly excessive cost-wise to treat one property A different from property B. That's not I mean, does the Constitution allow that kind of disparate treatment?
Your Honor, if you're going to say that it's disparate treatment, then what you're saying is we had to appeal every property in the school district, and we get no discretion in deciding how to use the limited resources of the school district in a way that benefits the taxpayers. We can't. The school district would be fiscally irresponsible for the school district to appeal every property
And now
in the county.
Now you're at my conundrum. I agree with you, 100%. But the legislature gave you this ability to do individual appeals, and the problem is, as much space as the courts have tried to give in this uniformity arena to save this statute, it hasn't proven very workable. There's still disparate treatment, and your example that you just gave is a primary example of disparate treatment. We had two properties, arguably the exact same. Well,
no, Your Honor,
okay.
they were absolutely.
But they were identified. They fell within the criteria. They certainly fell within the general criteria, right?
There was no testimony that Lowe's fell within the criteria. This was an offhand remark in an email from the consultant.
Okay, let's change the facts then, because I'll go back and look at that. Let's say they did fall within the exact same criteria. Let's say this was one of the properties that was identified to meet the policy. Would under the uniformity clause, would the school district have been justified to say, yeah, this one falls within our criteria, but the litigation cost would be through the roof, so we're going to set it aside?
No, Your Honor, I don't believe so. I don't believe that they would be justified in doing that. That would be treating similarly situated properties in a different fashion. But that's not. The P-Patch Partners is a bank site. It's a bank property. It's right next to the Lowe's home improvement store. Lowe's was never.
Class of subjects?
No. Yeah, it's a different type of property. It would not have any kind of dark store theory implications, Your Honor.
But doesn't the dark story theory really rely upon the current use of a property? In other words, if a store's, say 100,000 square foot stores, one's being used for Lowe's, we evaluate one way based upon the lease and based upon the use. And if there's another 100,000 property at the other end of the mall, an anchor store that was previously a Home Depot that decides to locate somewhere else, that's going to be valued very differently if it's vacant.
Well, that would be value and use, which this court has prohibited.
Correct.
And so we're not in a situation where this school district looked at the Lowe's property. The Lowe's property was never identified as a potentially appealable property by the consultant.
Why not? Why wasn't it?
There's no testimony as to that.
No, I'm asking you would the Lowe's property fall within the criteria of the policy?
Your Honor, on this record, I do not know whether it would have, because the criteria in the policy is that this would fall under is the second criteria, which is working with a third-party firm to identify potentially underassessed properties. The third-party consultant didn't identify this as a potentially underassessed property to the school district. It identified 15 other properties.
Okay, so there's no evidence that this Lowe's property meets the threshold?
There's no evidence on this record that this property actually met the threshold. Correct. Correct.
Can I just stop and ask you, of the 15 properties that were identified, did they include both properties that were recently purchased as well as properties that had not been turned over in a sale for a period of time?
Your Honor, the Marchwood property was included as a recent sale. I do not know whether the other 15 properties that were originally recommended for appeal by the consultant, whether there had been any recent sales of those properties. But we do know from the consultant's testimony that that was a factor he considered in looking. This consultant employed a methodology that looked at every single parcel in the school district. And that's one of the data points. It was an 8,543-page spreadsheet, and that's in the record, that this consultant developed that included every parcel. And he recommended 15 of those parcels for appeal, and the school district then identified, after that, the date of the recommendation of the school district's consultant was May of 2019. This sale occurred in July of 2019 and was picked up by the school district. Justice Mundy, does that answer your question?
You're saying it wasn't arbitrary, it was using the same rubric.
He was using the absolute same rubric for all of these properties, and that rubric included looking at any recent sales.
So you concede it's strategic, but you maintain it's not arbitrary.
I'm sorry?
It's strategic. It's a strategic. There's a strategic cost-benefit approach here, but not an arbitrary one. You're saying
Exactly, Your Honor.
and that's what matters.
That is what matters, because the school district can only, there's testimony in this record that the school district limited and the consultant limited it to 15 properties because that's what the school district considered it could reasonably handle in any given tax year. And so they limited it to 15 properties, and we also have the testimony through admission of deposition testimony of the school board president and the school's business manager that that is a business decision. It's a cost-benefit analysis that the school district makes. So the school district has to determine what properties it can appeal and whether it can handle those appeals in any given year. And it's not a good idea, it's irresponsible for a school district to appeal properties where they will not result in sufficient tax revenue to justify what can be significant costs.
And where there's everything you're saying makes a lot of sense. Let's go to the 15, because you said there was a spreadsheet of 8,000 whatever, right? Mm-hmm. That he reviewed. Out of those 8,000 whatever that were reviewed, how many meet the policy?
There's nothing in this record that says how many met the policy, because we get to the consultant gets to 15 and stops.
How did that's the question. So did the consultant start at the top of the list, count to 15 that meet and stop, which means everybody on the remaining, all the remaining properties never got a look?
They did not, once they got to 15, which was the limit, they stopped.
Okay, so if you were the unfortunate property owner at the top of the spreadsheet, you had a higher likelihood of being selected as part of the 15 than the properties that were on the lower half of the spreadsheet.
That's the necessary result of any cost-benefit analysis policy. Absolutely, Your Honor.
Yeah, but even if we assume that that's arbitrary, in other words, number 16 is going to say, I'm good, 15 is going to say, this is arbitrary, I was picked, 16 wasn't. You're only talking about it on a temporal basis, right? In other words, 16 is not going to be exempt for the same exact tax assessment appeal, but it's going to be for the following year. Because the issue I think Justice Brobson is getting at is the uniformity clause requires all properties to be treated, property owners to be treated likewise. So 16 is not going to escape review. It's just that for the purposes of this particular tax year appeal, you guys only said we can only handle 15, so the top 15 is the ones we're going after. Maybe next year 16 through 30 gets it.
Justice McCaffrey, I couldn't agree with you more. Unfortunately for me, the record doesn't play that out. I can tell you that Downingtown School District...
He was asking you about a hypothetical because we're getting into this situation where, you know, how to apply the uniformity clause, and more importantly, whether or not the application or the assessment appeals that you guys, the criteria that you picked, was in fact arbitrary. I just want to make sure when we talk about arbitrariness, anyone from 1 through 15 can say, I was arbitrarily selected, 16 is just as bad as me, and they didn't get picked, so therefore it's arbitrary. But you're not saying that 16 through 30 is going to be treated exempted. You're saying,
we are not saying that at all.
You're saying we can only fiscally take the first 15 cases, 16 through 30 maybe next year.
Your Honor, and Downingtown Area School District has a history, as this court well knows, of how many times Downingtown Area School District has been in front of this court on uniformity, of continuing to to get those properties. Unfortunately, there's nothing in this record that says that the next 15 properties would have been appealed in the next year, but that's clearly the custom in this school district. I just want to make clear that that's not in this record, Justice McCaffrey.
That's not a promise.
Excuse me?
Or a threat.
It's not, but it customarily happened, and I'm answering Justice McCaffrey's question in the most candid way I can, but Justice Weck, I have to point out that's not in the record.
Yeah, if you would do that, if you wouldn't do that, so let's say you win here, and you wouldn't do that, then could they come back in on a uniformity challenge next year and say, aha, we were in the top 15, but the next 15 you guys didn't appeal, now you've hosed us?
Well, that's actually what happened, because after this decision, we've stopped. Well, this was a 2019 case for 2020 tax year. And for 2020, 2021, and 2022, the school district did file additional appeals every year at getting the properties that they hadn't had the capacity to handle in the past. After the Commonwealth Court reversed the decision of the trial court in this matter, Downingtown Area School District, and once again, this is not part of the record, Downingtown Area School, well, I guess it would be of public record, stopped filing these appeals for those tax years, but only because of the uncertain situation that had been created by the Commonwealth Court's decision saying that we, the school district, had to appeal every single property within our boundaries in order to pass uniformity muster.
So let me ask you a question. Why wouldn't you just release the list? Say, here's a list of 8,500 properties that are subject to a tax assessment appeal in Downingtown Area School District. This year, congratulations, 1 through 15, we're coming after you, but next year it's going to be 16 through 30. At that point, you're saying we can only take 15 a year. You remove the arbitrariness because you're letting everybody know what's up on the list, and more importantly, you're telling everybody you are going to be uniformly subject to the same exact analysis moving forward. Wouldn't that eliminate any uniformity clause claim or any violation or arbitrariness?
I would hope so, but I can tell you, Your Honor, practicing in this area, that there will be a challenge. There will indefinitely be a challenge. Ever since this court issued its opinion in Valley Forge Towers, the school districts are hit with what has colloquially become known as the request for the Valley Forge discount. The threat to bring proceedings which will take you all the way to the appellate courts and cost a lot of money or on the basis of uniformity. So that would be challenged as well.
I'm with you. I wasn't on the court when that was issued, and I love Valley Forge, but I wouldn't give them a discount.
Your Honor, turning back to the bases for the arbitrary finding. Another one of the bases is that the school district, the Commonwealth Court found that the school district knew there were many more properties in the district that met the threshold. In support of this claim at trial, the taxpayer presented an expert report by Dr. Angelides, and he was completely discredited. He alleged that there were multiple 29 or 30 properties, I think 30 properties in the district that met the school district's threshold and should have been appealed.
I think the import of the Commonwealth Court's decision there is similar to the line of questioning that we have right now, is if you have a criteria that is a monetary threshold, and there are 1,000 properties of all the properties in the district that meet that threshold, can you satisfy uniformity without appealing all of those 1,000? Can you pick which ones out of there, to Justice Weck's point, as long as you're strategic and not arbitrary, without violating the uniformity clause? I realize that the Commonwealth Court fact-finding might have been a little off, but you're not even disputing there were more properties on this 8,500 and some page spreadsheet that met the $10,000 threshold.
I'm disputing that this record shows that there were properties. The testimony expert was absolutely discredited because 29 of the 30 properties he identified.
You're saying for our purposes we should assume there were only the 15 selected?
On this record, well, no, we know from the coefficient of dispersion that there's not perfect equality in tax assessment in Pennsylvania. We know that there are outliers. And so I can't sit here in front of this court and say, no, there were no other underassessed properties in the school district that year. There has to be, to some degree, other underassessed properties.
That meet the monetary threshold.
That meet the monetary threshold is a little harder for me to go that far, Your Honor, on this record.
you would assume there are based on the coefficient of dispersion.
Because otherwise there'd be no point. This wouldn't be a case for us.
Correct.
Right? I mean, it would just be an as applied as to this taxpayer.
Right, but we know from the coefficient of dispersion, Your Honor, the coefficient of dispersion measures the average deviation of individual property assessment ratios, which is the assessed value divided by the market value, from the median ratio for a group of properties. It's expressed as a percentage. And we also know that a lower coefficient of dispersion indicates greater uniformity. When there's less of a spread on the bell curve, that means greater uniformity. And fairness in property assessments, meaning properties of similar market value are being assessed similarly, okay? And a higher coefficient of dispersion suggests inconsistency. It indicates that some taxpayers may be paying more or less than their fair share. And we also know from the coefficient of dispersion that every time an individual taxpayer challenges a property tax assessment as too high, and the trial court agrees and reduces its assessment, the result is a decrease in the coefficient of dispersion, which equates to an increase in uniformity. We also know from the coefficient of dispersion that every time a district, a school district, challenges a property assessment as too low, and the trial court agrees and increases the assessment, it results in a decrease in the coefficient of dispersion, which results once again in an increase in uniformity. So to get back to your question, Justice Brobson, we know that the school district, by appealing these 15 properties and adding the 16th, Marchwood, that when the trial court finds that there's no uniformity challenge and the parties stipulate that the property is grossly underassessed, please remember that's what happened in this case. The parties only tried the issue of uniformity. The parties agreed that this property was substantially underassessed. At the time of the sale, the aggregate assessment on this property was $32.7 million. The $82 million sale of this property in July of 2019 corresponds to an assessment of $40.3 million. Thus, that sale indicated a potential underassessment of $7.6 million, which would amount to about over $200,000 in additional revenue. The parties stipulated and agreed that the fair market value was $78.8 million in 2020 and $81.75 million in 21 and 22. So in this case, Your Honor, we have a situation where the identification of these properties resulted in an increase of an assessment of an admittedly underassessed property, which, as a matter of mathematics, results in a decrease in or increases uniformity. It's a mathematical certainty. So the 15 or 16 properties that were appealed and successfully appealed, those successful appeals, each one of them increases uniformity, And that's the true irony of this case. It's indisputed as a matter of math with the coefficient of dispersion that bringing this property that was woefully underassessed as stipulated to by the parties increased uniformity, and the claim is that that increase in uniformity constitutes a violation of the uniformity clause. The irony is palpable. Appealing all potentially underassessed properties in a school district is impractical. Justice Mundy, you recognize that in your OIS A in Berkshire Hills. Policy 605.1 is an attempt by the school district to be fiscally responsible by only appealing the assessments of properties that would generate enough revenue to justify the cost of the appeal. The school district's business manager, through deposition testimony, and the school district's board president both indicated it was a cost-benefit analysis. It would be absolutely impractical for a school district to be required to appeal all potentially underassessed properties in its boundaries in any given year, and to be expected to expend its limited staff, counsel, and economic resources to do so. One of the 4 amicus briefs in support of our position here said that school district couldn't ever even afford to file 16 of these appeals, let alone for every in the district. And the affirmance of the Commonwealth Court opinion in this case, the majority opinion and decision, will lead to greater inequality among taxpayers.
That's an interesting point about the school district, the amicus. What if another school district could only afford to appeal 1 at a time, but they came up with a list of 30 or 16? How would they choose which of the 16 they came up with as to be the one?
That's a very good question, and I'm glad I don't have to answer it in the facts of this case, but I don't know yet.
It's your hypothetical.
I mean, to satisfy uniformity, we are arguing that it is all right for a school district to take as many cases as it can handle in attempting to equalize tax burdens.
As long as they're moving toward a lower coefficient, it doesn't matter if there are 300 properties that fall within the rubric. That is limited by how many they can take.
So long as there's not some other improper reason that those properties weren't appealed. If there was some kind of favoritism, if there was some kind of evidence that there was some other selection criteria that was applied, that was non-neutral.
That would be the challenger's burden to prove you plainly, palpably violated the Constitution.
Yes, plainly and palpably
without
intentionally
the governmental
did.
presumption
Yes,
that you're acting.
yes.
Okay.
But otherwise, you have to let that school district with its meager resources attempt to equalize tax burdens in the best way it can. And that doesn't violate, we take the position that doesn't violate uniformity.
As long as it's not doing that in a way that violates Valley Forge.
Correct. They can't. You're right. And that was part of my reply to Justice Brobson, Justice Weck. Absolutely. You cannot violate Valley Forge and just choose to only appeal one class of property. And there's no allegation that that happened here.
Counsel, if we could just talk about that for a little. Why don't you talk about that $10,000 limit of additional tax revenue and the result that only commercial properties were being challenged?
In this particular year, only commercial properties had been challenged.
In what fiscal year would it not be? Your expert...
We had, on this record, we have testimony, and it's highlighted in the trial court opinion, that this school district has appealed a residential property in the past.
Except in this year, your expert looked at residential properties in excess of 3,500 square feet and found none that met the threshold.
In this year, correct. That's absolutely correct.
And that's a permissible threshold.
We would argue it is a permissible threshold. That $10,000 threshold appears in many prior cases in the Commonwealth Court. It's a threshold that takes into account the real-world costs of pursuing one of these appeals.
But looking at that from that perspective, it becomes legitimate to classify the properties that are being appealed, which you cannot do.
Well, and that, I understand that's an argument that this always results in a subclassification. And we can't do anything. That argument I have no counter to. There's no, unless we, the school district, appeals every property in the district that's potentially underassessed, there's going to be an ability by any clever lawyer or jurist to say there's a subclassification.
Well, it's not that clever. I mean, I wish I were, but I'm not. I mean, this $10,000 threshold resulted in only filing appeals as to commercial properties. I mean, there's a inherent subclassification here, which you cannot do.
Well, I would argue that it hasn't been established officially by this court that we cannot do that.
Isn't that why we're here? I mean,
that is.
You just said case after case has recognized the $10,000 threshold. None that I'm aware of.
Commonwealth Court, Your Honor. Commonwealth Court, not this court. Well, Commonwealth Court.
So tell me again why that's legitimate. The resources of school district drive whether or not classifications of properties can be created under the uniformity clause.
I think we have to step back and look at this statutory scheme as a whole. There's two methods by which the assessments can be changed, and that's countywide reassessments that are politically unpopular and happen very seldom, as Justice Doherty pointed out in his OISR in Berkshire Hills, excuse me.
But that doesn't make it
constitutional.
That doesn't make it constitutional. The lack of political will on the part of the legislature doesn't obviate the constitutional issue.
That's one way. And the second way is through the assessment appeal process. And every time a property owner files a tax assessment appeal and successfully reduces his overassessed property, that creates more uniformity. And every time a school district appeals an underassessed property and gets that property to its correct assessment, that increases uniformity. And my answer to your question is that the Supreme Court has never, if we go with that 10,000 threshold and that argument, Your Honor, then we're saying that there is a requirement that there be perfect uniformity in real estate taxation.
Also isn't part of your response, I take it, that there's a distinction that matters between incidental effect or idiosyncratic result and the design, the Valley Forge problem.
Absolutely, Your Honor.
And that there would have to be, otherwise this whole system comes crashing down.
I couldn't agree with you more.
Well, I'm liking Justice Weck's articulations, the idiosyncratic design, the systematic versus. I mean, this is helping me a little bit. Thank you.
There's no charge.
Thank you.
There's no assessment.
But to Justice Donahue's point, it can't be a monetary threshold for monetary threshold's sake. There still has to be some kind of a backstop from a constitutionality perspective to prevent, through the monetary threshold, a de facto Valley Forge problem.
And I don't know what that mechanism could be other than what Justice Weck just suggested, if we look at it idiosyncratically.
Well, presumably there was evidence of pretext.
And that was what I was explaining. If there's ever a pretext, if we say this is not a good, if the school district said, Marchwood, they aren't good residents. They cause us problems. We're going to go after them. We're going to pox on their house.
Could pretext be? Could evidence of pretext be? We don't have 3,500 square foot homes in our school district. We have 1,800 square foot homes. We have row homes in blighted urban areas. We have all this stuff. So we're going to set the threshold at $10,000. Now we know, I mean, that $10,000 economically makes a lot of sense for us. We can't be it, but we really know that this is going to save all the residences because there are no residences that have a square footage that would make that kind of delta. Is that pretext?
Your Honor, we have no evidence on this record that the school board adopted this policy as any pretext for exempting out homes. And the fact that it happens de facto because, as Your Honor mentions, it's very hard to find a residence that is not preferentially treated in Chester County under clean and green. All of the gentleman farms that are worth millions of dollars that get the clean and green preferential treatment make it so that those properties don't qualify for assessments. And so it's very hard. But there are properties that on this record, we know that Downingtown has in the past appealed a residential property.
But there's nothing idiosyncratic about this. You've chosen a threshold that is going to result in the taxation of commercial properties and not residential properties.
Yes, that's absolutely correct.
Most likely,
it will not result in any more any residential properties, but one of those residential properties could fall out of clean and green and show up in a future year, Your Honor. And my only response, the only possible response I have, is that is requiring absolute perfection under the Uniformity Clause. And this, we've cited many cases.
How does that require absolute perfection?
Because otherwise you can't do it. Because because you can create a subclassification for mountain. That is an all or nothing proposition, Your Honor. We'll never be able to create a threshold that's going to capture everything. Whatever criteria any school district comes up with, it's never going to capture. It's always going to be subject to saying there was a subclassification here. And what that ends up doing is doing away with a school district's ability to file these in the first place. That if you follow the argument you've posed to me to its logical conclusion that constitutes a violation of the Uniformity Clause, then the answer is no school district is allowed to file any more tax assessment appeals in Pennsylvania.
Unless it's a really small and hyper-uniform school district we haven't seen before.
Correct, Your Honor. And that will result in greater inequality among taxpayers for 5 reasons. It would cause school districts to stop pursuing appeals altogether, with underassessed properties remaining underassessed with no guarantee that a countywide reassessment would take place more frequently. Number 2, it would increase disuniformity. Taxpayers who are overassessed can reduce their assessments through appeals, and school district can't appeal underassessment. So the correctly assessed taxpayers would have to pay more of the cost of government than their proportionate share. And the underassessed properties would pay less to the government than their proportionate share and have no remedy for the school district to change that. Number 3, school districts would then be required to increase millage to make up for the shortfalls, making correctly assessed taxpayers pay even more than their proportionate fair share, and letting underassessed taxpayers pay even less than their proportionate fair share. And 4, allowing an admittedly underassessed taxpayer, like the taxpayer in this case, to pay less than his proportionate share would essentially create a protected class of taxpayers insulated from assessment appeals to correct disuniformity. And that's the ironic thing here, is that all of these, in the name of uniformity, the taxpayers are asking for a result that results in disuniformity.
So you can pick and choose the taxpayers that will bear the burden of creating more uniformity.
We can, I wouldn't characterize it as picking and choosing, but we can do our best as school districts to implement methodologies that do their best to identify underassessed properties and to equalize the tax burden that is shared among the residents of the district.
There's one property on this list that you plucked out of E.L.R. that was not included on the list prepared by your expert, and it was based upon your second criteria, which is, was it newly purchased properties? How is that not a subclassification?
Your Honor, we can't counter your subclassification argument. There is no.
No, I'm talking about not the list your expert prepared, but added on to that list was a newly purchased property.
This property.
This property.
Absolutely.
Correct. So how does that work? What about all of the other properties that were newly purchased? How did you pick that property?
The other properties that were newly purchased, that was a data point in the consultant's 8,543-page spreadsheet. One of the data points was the date of the sale, and that was looked at by the consultant. So the consultant looked at all of those dates of sale in its analysis of recommending the 15 properties. That recommendation was given to the school districts by its consultant in May of 2019. In July of 2019, after those 15 properties had been identified by the consultant, this property sold for $82 million. And it was then identified under the school district's policy, which allows properties to be identified solely on the basis of sales to be added, and the school district business manager added that.
How is that not arbitrary? I mean,
this isn't Berkshire Hills where that is the sole criteria. Remember, in Berkshire Hills, the
under
sole
that category.
sole
You have two categories, those identified by your consultant and then newly sold properties.
correct.
There are two different categories within
Two-
your categories.
Right, and Berkshire Hills only involved one.
But the answer is it's the same standard.
It's the same standard,
It's the
yes.
$10,000 delta, whether the property was identified by the consultant or the school district itself, the policy allows that. It just has to satisfy the $10,000 delta.
And so this, exactly, Justice Robson, and this school district didn't just rely on what the opinions in support of reversal in Berkshire Hills did not like, which was a policy that was solely based on sales. In addition to sales, we had a consultant identify other properties that were potentially underassessed to make sure that this was not a situation where we solely went after the new residents of the district who had done nothing other than purchase their property, and a sale resulted in a tax assessment appeal. So this school district, to make sure that it didn't run afoul of the problems with solely basing your methodology on sales, they also incorporate a third-party consultant, a professional who helps the school district in finding properties that aren't just from recent sales. Your Honors, unless there's any further questions, I would rely on the school district's brief, and we would respectfully request this honorable court to reverse the order of the Commonwealth Court in this decision. Thank you for your time.
Thank you, Mr. Withers. Well done. Let's hear from Mr. Summers.
May it please the court, my name is John Summers. I have the honor of being with me, my colleagues Matthew Hammermesh and Gianna Massioni, and in the courtroom, Mr. Fiorello, Mr. Kolsch, and Mr. Moricom, who joined on the briefs. May it please the court, and by now it's good afternoon. It's undisputed that the Downingtown area school district selected for tax year 2020 reverse appeals 16 commercial properties, no residential properties. It's also undisputed that in the prior 8 years, they had only, in which the policy was in effect, appealed one residential property. Now, what was extraordinarily missing in the argument that preceded me was the fundamental thrust of the Valley Forge decision, which I will get into in a moment, which is the prohibition against the disparate treatment of commercial properties as a class as compared to residential properties. Now, I had the honor 8 years ago of appearing in front of 5 of you in arguing the Valley Forge case. And it was a unanimous decision that the Chief Justice ruled. In the words of the GM Berkshire Hills plurality of 3, there was unfortunate dictum in that opinion that seems to be greenlighting the kind of appeals that we find in this case and in countless cases across the Commonwealth. And it's become a cottage industry in my practice to be bringing Valley Forge challenges because of the fundamental misunderstandings that the school districts have in interpreting what Valley Forge held. So what if I may do is start with a discussion of Valley Forge, what it held, apply it here, and make clear to you, it's easy for any school district to have a policy that complies with Valley Forge. There's nothing complicated, there's nothing hard, there's nothing, to use the words of my good friend Mr. Withers, impossible about doing it. What's the nub of what Valley Forge held? Valley Forge prohibits taxing authorities from treating different property subclassifications in a disparate manner. Spoiler alert, that's what happened here. The problem in this case is that they went after all the commercial properties and not the residential properties. It's not abstract notions of is it possible to have a classification one way or another. The de facto way in which the policy was implemented.
On the de facto. So, I mean, you used the word de facto, and earlier used, I think, the word thrust or fundamental thrust or something like that. And I just wonder if we're eliding or extending Valley Forge here, or if the Commonwealth Court is extending it in a way that goes too far. If the effect, I don't know if we have a dispute about the record. Perhaps we do. Perhaps there are too many off ramps to get here. But if the effect of a rubric used by a taxing authority generates an output that in a given tax year has all commercial properties, is that the same as the Valley Forge problem?
Here's what.
Start there.
Justice Weck, there was a policy in 2012 that identified a threshold. They implemented it in every year, and golly gee whiz, it turned out only commercial properties. But I've got several things. Golly gee whiz, it's only commercial properties that turn out. Now, isn't that a surprise? Number one. Number two.
Yeah, but is the issue why? I'm sorry. Isn't the issue why? Because if they implement input or criteria, and as Justice Weck, I'm waiting for the answer to that question because I think that's the nub.
I'm just going to. Well, if I may, I'm getting there.
If there's criteria that their expert uses, right, and the criteria is spit into a computer and it comes out 20 properties and they're all commercial properties and property 28 is a residential properties, they can only go after 15 or 20 a year. You have the expert report, you have the data points. That's subject to something that you can kind of, I guess, maybe cross-examine the expert on.
If I may, Justice.
Sure.
McCafferty, two things. One, our brief in exquisite details highlights that the methodology used targeted and focused on commercial properties, not residential properties, not because they're of greater value, but he looked at the system. Look at pages when you all return to chambers. Pages 8 and 9 and in other sections of our brief. Valbridge, their consultant, used a sales approach to identify properties for the tax appeals for 2020. Fair game. How'd they do it? When it came to commercial properties, they had a spreadsheet. And the spreadsheet did a dump of all the data of the sales of the non-residential properties. And then they analyzed that. And they evaluated in two ways. They did a direct approach, and they did an indirect sales approach. And I can explain that in greater detail, but it's all in the briefs. When it came to...
What's the problem with that? 'Cause
that's okay, but if you're going to do it for commercial properties, you have to do it for residential properties.
The sales approach takes that into consideration because it basically looks at like sales and then basically acquires a price based upon a per square foot basis. I mean, if I'm looking at Villanova, where there's multi-million-dollar properties and not too many commercial properties, if we use the same data point, aren't we going to come up with nothing but residential properties?
Your Honor, on this record,
They separated them.
Valbridge didn't do that. Valbridge didn't have a spreadsheet in which they looked at residential properties like they did commercial properties. Valbridge didn't evaluate the question, how many residential properties qualify under the threshold. They didn't do that.
There's 8,500 properties, I thought counsel said, right, that were on this list?
The record with respect to residential properties is as I stated. The record with respect to the differential treatment of commercial properties and residential properties is as I stated, and our brief goes into exquisite detail in pointing out that different methodologies and approaches were used with respect to the identification of residential properties and commercial properties. And it was a nullity. They didn't do anything with respect to it. He used a heuristic, a shorthand, 3,500 square foot residential properties. I'm not going to look at anything below, I'm only going to look at
Well,
above.
there's a heuristic. So, I mean, is it, you don't contest monetary thresholds per se, is that right?
I do. I will get to that later. I will get to that. But Your
These are apples and oranges. I mean, these are different types of properties. So that would be suggestive that the rubric used in some non-pretextual way is going to have to somehow employ a valuation methodology which recognizes that these are commercial and these are residential. Right?
Precisely, Your Honor. And if there was a heuristic that Valbridge had used for commercial properties that was analogous to what they did for residential, I would say you were right. But they didn't. That's my point. They used a different approach, a mindset that favored the identification of commercial properties rather than residential properties.
I'm not sure I understand your point. I mean, maybe I'm misstating it. Are you suggesting they didn't look at residential properties at all?
The testimony with respect to the review of residential properties was that they didn't actually, Valbridge actually didn't even know what it did. I will go through later a set of what the record was.
Okay. I mean, this is...
And our brief addresses exhaustively the differential treatment. And Your Honor,
But I want to get to my question to you.
Yes.
Because I think there was consideration of residential properties, and they didn't meet. They stopped it. It was the list that was created. This 8,000 some spreadsheet list included residential and commercial properties. It just so happened that the 15 that were selected happened to be all commercial. That's how I understand the record. But putting that aside, your argument seems to be something different, that in evaluating whether a property meets the 10,000 delta, that they must use the same valuation methodology for a residential property as they use for a commercial property. We don't do that in tax assessments.
Your Honor, if I may, it depends on the word methodology and what one means by that.
Well, I was talking. You were talking about methodology. If you were to go through a Board of Assessment appeals yourself, there would be, and you had a commercial property, you would be looking at certain valuation methodologies for the assessment of a commercial property. They would not be the same that someone would be using in assessing a residential property.
Your Honor, of course there's a difference between, for example, an income approach, which would apply to
Correct.
commercial, and in residential, you wouldn't have an income approach unless it was maybe a rental
Is that
property.
what you're talking about?
No.
Okay, good. What are you talking about?
I'm talking about what is in our brief and what is in the opinion that was a trial court opinion from Montgomery County that addresses precisely this. Here's an example. There was a case in Montgomery County in Lower Merion. A different consultant looked back at sales to determine whether to estimate fair market value, and they looked only back a couple of years of residential properties, and they looked way back for commercial properties. That's a different methodology that had the effect of discriminating against commercial properties, because lots of years went into consideration looking at sales, but not for residential. That's the way in which, and again, the term methodology may be a little confusing because, in a sense, yes, because
Tell me what was done here that is equivalent to that.
there was an analysis, and our brief explains it, there was an analysis of the way in which there was an analysis done of commercial properties, doing it a couple of different ways, and that's what Valbridge did. Valbridge couldn't articulate a standard of how it evaluated residential properties, and it just so happens that it didn't identify any. Okay?
You're saying the fact that you couldn't elicit, that you elicited testimony on how they reached the $10,000 delta for commercial properties, but you couldn't elicit testimony on how they reached a $10,000 delta for residential. You're saying that proves non-uniformity.
I would articulate it differently, which is that the school district could not come forward with an explanation that it treated all categories of property equal.
It's not their burden. It's your burden.
They couldn't, one way or another, they couldn't come forward with an explanation of how they did it in the same way. It is clear that under Valley Forge, they're obligated to do it in they're supposed to treat the properties the same. They're supposed to do it the same way, the review. That's part of the treatment. And they couldn't articulate that they did it in the same way. And that cuts to the heart of differential treatment, of prohibition, and the unconstitutionality of what the school district's about. Let me get to another.
I thought I'm sorry to belabor, but I thought the Valley Forge problem was the selection of a class.
It's the differential treatment of properties by class.
And you maintain that this is the same thing as that?
What I maintain is, and maybe I'm not articulating it clearly, so stay with me because I think it's totally clear, that if you only include a couple years worth of data for residential properties in your review, and you include 30 years of data for commercial properties, it's fair to say you're not treating them the same, because even if you use a $10,000 or a $15,000 threshold, you're doing the review in a different way that puts the thumb on the scale favoring residential properties.
Your position does necessitate, in order to reach a holding that there's a violation here, it does require a design more than simply an output.
It's a design of the approach to the evaluation. The design is you did it differently. You did it differently in a way that favors one category of properties over another. That is a slam dunk violation of the Uniformity Clause. And on this record, it's plain and clear. They couldn't come up with any description other than that they used the sales approach, that it was done in the same way. The best they could do is say, we did the first 15. It was arbitrary. That's okay because it's impossible. And let me go to that.
Well, didn't they go with the first 15 because it would generate the most money?
No, because if they didn't look at the 18, 19, and 20, they wouldn't have known whether it would have gotten them even more money. And that takes me precisely, Your Honor, to...
Weren't they numbered by how much money they could generate on a tax assessment appeal?
I don't believe that that's what the record shows. And so let me get to what could be a set of tests. I mean, it's actually not that complicated. And one of them is presented by the Apartments Association in its amicus brief. One could do the following. The school district, with a consultant, could have the consultant do an evaluation of the extent to which, on a percentage basis, properties are underassessed. The properties that are the most underassessed, on a percentage basis, get appealed. And then they decide, well, gosh, we can only handle 15. Then they just take the top 15.
Can I just ask a question about that? Would a percentage basis, as opposed to an actual value, would that generate the same money for the school district? Because if the school district's trying to be fiscally responsible, let's face it, I'm going to try and hit the top 15 that's going to generate the most money. You're advocating, and I think the amicus advocated, some type of percentage test. The percentage test may not generate the same dollar value on a percentage basis as an actual value.
I think there are two answers to that, Justice McCafferty. The first is that the Constitution, and Valley Forge actually says, you're not allowed to discriminate, and that trumps maximizing money that you get in through the tax. So if there's a trade-off and if there's a tension, it's the Uniformity Clause that controls, not this other consideration. That's number one. Number two, it's a completely understandable method to bring, and it makes sense if what you're trying to do is bring properties up, you want to target the ones that are most out of whack.
Okay, whether or not it's completely understandable, is it completely impracticable? So here we are in the school district of Philadelphia. How does that apartment association methodology, I mean, because I assume it's district-wide, right? that first step of that approach requires a district-wide comprehensive assessment, right?
Yeah,
Otherwise, it's non-compliant with your approach.
yeah.
And so, you know, who was it who said the Constitution is not a suicide pact? I don't know how that's not completely impossible for a large school district.
Can I just say that the methods that Valbridge used, it's as if in an analogous context in medicine, they hadn't invented antibiotics, okay? As Justice Dougherty in his opinion pointed out, focusing on countywide reassessments, there are now modern, sophisticated statistical techniques for mass appraisals. They're used in the countywide reassessment context. They're also used routinely by consultants in this area. Dr. Angelides, who submitted a report that, among other things, said that the selection of this $10,000 threshold was a target against commercial properties because of its massive disproportionate impact, okay? There are econometric techniques that in 2025 make this easy, make this inexpensive. That's what taxpayers use in this litigation all the time. There's a thing called a hedonic regression. It makes it, for relatively inexpensive, the ability to run all kinds of statistical techniques to identify the most out-of-whack properties on a statistical basis. But let me get to a second point to Justice McCafferty, which is, even under another standard, which is not a percentage standard, but an absolute dollar standard, this school district didn't come anywhere close. They didn't even try. There's no evidence in the record that they're saying it's impossible to do. All you need to do is make a good faith effort to figure out what are the X number of properties that are under-assessed and appeal those. It's what you would do in if every business in thinking about what cases to bring would look at the most valuable ones and they'd evaluate what their range of options is. They wouldn't say, gosh, once I've sort of hit 15, that hit a threshold, I'm not going to do it, which takes me to the threshold. Okay. The portion of the court's opinion has led to, if I may loosely say, school districts fetishizing this discussion of monetary thresholds. Let's talk about what's really going on, okay? There's a threshold that says you're to look at sales, and if you can raise $10,000 in aggregate tax, you may appeal it. Now, it's called a policy because it appears in a book and it's got a capital P, but let's explore for a minute what that actually does. In practice, the evidence shows that there were a lot more, as many as 100 properties that met that standard. So how do you pick which ones you appeal and which ones you don't? That's actually what a real policy does, okay? A real policy doesn't just identify a threshold that's picked at random. It picks something and then it says, if either it says you shall appeal all of them, or it says if there are a collection that you should go ahead and look at, that you would take, it gives you selection criteria for how to choose among them. This policy was a fig leaf. This wasn't like a policy that actually limited to anything. It's like saying, if you're a college, we're only going to look at students whose SAT scores exceed a certain amount. And then there are 100 times more students than there are spots. That like policy isn't doing much. It doesn't have traction.
How do you impose a policy that says they have to appeal every single property? Because as much as I like Mr. McElrain and his law firm, they'd be working around the clock for the next 20 years trying to assess.
We are not saying that that's the case.
Oh, I thought you just said that a policy, a neutral and indiscriminate policy that says they have to appeal every property that's undervalued would be a policy.
a policy that's a real policy, not this thing. This thing isn't actually a policy, okay? A real policy would say, here's a threshold, and then when you're choosing among all the qualifying properties, here's how you go about doing that.
Yeah, but
This has no guidance.
So how would that, you'd be here challenging that then as employing pretext?
Absolutely not.
So
Give
us an example then, once you get down to that second layer of analysis, what would you be looking at?
I'd say, if you have a threshold, here's the threshold. And then I'd say, okay, if there are a lot of properties that meet it, evaluate all of them and pick the most out of whack properties. That seems clear, but that is totally doable. And yes, does it have to be done with scientific precision? Like if there's a dispute about who's in the first 20, okay, but we're not on the same playing field in this record with what was done here.
I'm sorry. Go ahead. But your problem is with the monetary threshold at all. You're saying the 10,000 monetary threshold here is too high, right?
I'm saying a couple of things.
For this school district.
I'm saying a couple of things.
Well, is that one of them?
One of the things I'm saying is, no, I'm okay with the $10,000 for the purposes of this argument. I'm okay with the $10,000 threshold as long as you then have a policy that says, for all the qualifying properties, then here's how you go approach them.
Okay, okay, following the Justice Weck then. So $10,000 is fine, at least for this purpose. You're not arguing that's a de facto Valley Forge problem where $10,000 captures only commercial property.
I will later, but yes.
Okay.
Well, there is a limit to
Let's-
how many arguments we want to hear on this.
Very good.
Go ahead.
Okay.
Let's put that aside for a second. So let's say you're arguably okay with 10,000. If the policy then said we do a spreadsheet, we come up with 8,000 of the properties, or 8,000, or that was probably excessive, 1,000 properties that meet the 10,000 threshold, and they throw them into a hat, and then they randomly pick 12 out of the hat, you'd be fine.
No, outrageous. If we had a standard for students that said you have to reach this level of performance, and then we said, well, we're only going to enforce it for 1 out of 10 kids, we wouldn't allow that. The Valley Forge requires a focus on the fairness of what is being done to the taxpayer. And that is like subjecting people to a random number generator. Again, something that's not in this record and wasn't what's done is unfair. I want to take my cue as best I can from the Chief Justice and very quickly, if I may, say 3 new things, 3 quick things. 1, there's a whole other argument, which is this monetary threshold is different from most other monetary thresholds because what it is an aggregate dollar amount of tax revenues that are generated. That's different from the GM Berkshires, which was a monetary threshold about an amount of underassessment.
Sales price didn't have to do with...
That was also an issue, but I'll put that aside. Why is that important? Because if you have 2 equally underassessed properties in the school district, one in one township, one in another township, and they should be treated the same way, but under this policy they're not. Because if it's in a low millage township, then it will not meet the threshold, but if it's in a high millage threshold, it will meet the threshold, if it's a high millage.
To be constitutional, any rubric has to take that into account?
Yeah, because they're being treated differently by location within the same taxing area. And our brief addresses that argument as to why this is a fatally defective per se policy.
Your example is 2 different taxing authorities. The millage is set by the township that the property's in, not the school district. The school district is issuing the taxes as opposed to the township, which establishes the millage.
The school district is determining its millage, and the townships are determining their millage. So yes, but the school district is knowingly applying a policy that treats these 2 properties differently, yet they are equally underassessed. That violates the uniformity clause, which is about bringing properties in a uniform way. The second point, which, boy, is a can opener, I confess, which is 6 of you were on the GM Berkshire Hill decision and 1 of you was not. I think this is an opportunity to revisit that division. I think that in reading the 2 opinions, those seeking reversal and those seeking affirmance, obviously we're on the side of those seeking reversal. I would note the following, and I read carefully both, and in particular, Justice Mundy, your opinion for affirmance. Critically, what is wrong with this threshold is and please go back and look at Valley Forge, because it comes right out of the Valley Forge decision. The effect of focusing on commercial properties that is a higher rate of appeal, is to increase the effective tax rate on those properties. That's what the economist Amici in Valley Forge said, that is stated and repeated in the Valley Forge opinion. And so, when you have a pattern that increases the effective tax rate for one rather than another, that violates the traditional sort of law from Cope's estate and the like. And finally, and I recognize that that's a big issue for this court to take on, but there's an opportunity to do it now that the court has a full complement. And that goes to a per se violation. And lastly, I would just urge the court that the problem here is school districts need money, and absolutely, our clients are citizens as well and recognize that. But you can't, in reaching for revenue, break the Constitution and unfairly single out one category of properties as compared to another. That's point number 1. And point number 2 is the real solution here, which would get rid of the whole problem, as Justice Dockert, as you pointed out, and the Justice Donahue and Chief Justice Todd, I think, also recognized in their opinion, that countywide reassessments would get rid of this problem. And I started my practice early on with Mark Aronchick, and had a case in Lower Merion that led to the countywide reassessment in Montgomery County. That was almost 30 years ago. And Chester County, it's 30 years ago. Allegheny County's more recent, about half that. Philly now does it about every 3 years. If we had frequent countywide reassessments, we just wouldn't have this problem.
Legislature would have to do that, right?
Yes,
Don't hold your breath.
Well, one, respectfully, one of the things courts do is speak to co-equal branches, and
with mixed success. I mean, we do sometimes.
Far be it from a lowly lawyer to be measuring the success or not, but keep trying.
Counsel, before you conclude, tell me what type of monetary threshold you would support.
A monetary. Can I change the question slightly?
No,
Say a threshold.
No.
A threshold. A percentage threshold.
So I'm totally confused by your argument. Are you opposed to the notion of any type of monetary threshold in terms of the ability for it to comport with? Okay. Period.
Yes.
Can you briefly respond to Mr. Withers' argument about the ironic, if unintended, disuniformizing effect of your approach? That is to say, among other things, I suppose it counters the uniformity maximizing effect, at least theoretically, of the aggregate result of all these various appeals.
Having listened to the first argument, and the court weighing and thinking about the role of stare decisis. The court, this court, a couple of years ago has slammed the door on that argument because the court says the question for, there are really two components to a uniformity clause. You can't disparately treat different categories of property and say, well, we're allowed to do that because we're going to bring a couple more properties closer to a fair market value. That fundamentally, that's what the legislature has countywide reassessments do, not on an ad hoc basis school districts. That is, one-offs or occasionals to bring it up to uniformity. There's nothing ironic about what we're saying at all, okay? At the margin, if there are 15,000 properties, are you materially advantaging the disuniformity in a county by 1 or 2 or 3 movements in a marginal direction? That's not having any material impact. What is having a material impact is a systematic, and we have it back to 2012, focus and singling out on commercial properties. That's what takes precedence, and that's what the Valley Forge case was about. The very same argument that Mr. Withers is making was made by my opponent, who's now sits, a distinguished lawyer and now judge in the Montgomery County Court of Common Pleas. She said exactly that. How is it possible we could be complaining about a uniformity violation when it moves things towards uniformity? And the court answered that. I guess, Your Honor, and Justice Weck, you were on that opinion. But the whole point is that there's a fairness component, there's a component that you're not supposed to treat different categories of properties differently. And that's, there was a very substantial disconnect between the arguments we heard from my good friend, Mr. Withers, and I think what this case is about and what this record is about, which is the disparate treatment of commercial properties as compared to residential properties. And we know that because of the way in which the piecemeal implementation of this policy was done.
Counsel, you seem to be saying that that disparate treatment had nothing to do with the $10,000 cap that was placed. Yes or no? I mean, the argument that you made about the disparate treatment was one that I still don't quite grasp because of the manner in which the properties were valued, et cetera. Did it have nothing to do with the fact that they were looking to make up $10,000 in underassessment?
I think that, if I understand the question, I think there are two answers. The first answer is that that they treated commercial properties differently from residential properties in determining qualification with the $10,000 threshold. And that is disparate treatment, and Valley Forge squarely prohibits that. That's number one. Number two, it has been argued in day one in this case that the identification of the 10,000 threshold was in itself discriminatory in focusing on commercial properties. So does that answer?
Your second point did. Thank you.
Okay, thank you.
All right, thank you very much. Everybody done? Mm-hmm. Okay, you look like you wanted to argue. Thank you both. Outstanding arguments. And Mr. Minner, will you recess the court until 2 o'clock? Good afternoon. Please call the next case, Mr. Minner.
In re condemnation by the City of Philadelphia, the Airport Business Center, representing the City of Philadelphia, Mr. Aaron Richards, representing attorneys, Mr. Edward Rogers.
In 2017, the City of Philadelphia filed a declaration of taking for several parcels of land owned by Aplt, who in turn petitioned for the appointment of a board of viewers. The Board of Viewers subsequently issued a report awarding damages exceeding $139 million as just compensation for the condemnation. The city filed an appeal with the Court of Common Pleas in which it raised numerous allegations of error, including that the board applied the incorrect standard for determining the highest and best use of the property and sought a de novo trial. The trial court issued an order overruling the city's objection in that regard and concluding that the city's remaining objections to the board's report were either moot or constituted mixed questions of law and fact that would be resolved at the ensuing de novo trial. Thereafter, the city appealed to the Commonwealth Court, and appellees filed a motion to quash the appeal, contending that the trial court's order was not final and appealable under Section 518 of the Eminent Domain Code, as it did not confirm, modify, or change the board's report. The Commonwealth Court agreed and quashed the appeal. We granted discretionary review to consider whether the trial court's order constituted a final appealable order as defined under Section 518. Good afternoon.
Good afternoon. Oh, I'm going to move that back. Ira Richards from Dilworth Paxson on behalf of the City of Philadelphia. The trial court's order here is exactly what it says it is in the preamble to the order. It's an order that makes preliminary findings under Section 518 of the Eminent Domain Code. The order goes on to overrule the city's objections. As a result, it confirms the order, and under Section 518 of the Eminent Domain Code and Rule 311 of the Appellate Rules, it was an appeal as of right. There's nothing ambiguous about Section 518 or the word confirm. In Commonwealth versus Hessian, this court had the opportunity to give some content to the word confirm and explain that an order that agrees with the Board of View and then sends the parties to trial is an order that confirms the Board of View report. Later in the City of Chester case, the court reviewed an order that affirmed the Board of View. And that's exactly the trial court's order here. The Commonwealth Court focused less on the order and more on the trial court's later opinion trying to explain its order. But appeals, of course, are from orders and not from later opinions explaining them. And the order itself really shows that this is an order confirming the report under any manifestly common meaning of the word confirm. In the preamble, the court started out by saying it's making the following preliminary determinations under Section 518.1 of the Eminent Domain Code. Goes on in paragraph 10, to say what it says is the standard for determining the highest and best use in an eminent domain case. And then critically in paragraph 11, it says that the Board of View used the correct standard of proof when determining the highest and best use of the condemned parcels. Then it goes on in paragraph 12 to say, to the extent that the condemnor's legal objections with these determinations, conflict with these determinations, they're overruled. It went on in paragraph 13 to overrule an objection the city raised to the failure to apply collateral estoppel and res judicata effect to a previous dismissal with prejudice of a de facto taking action that the Hendersons, the appellees here, had brought. So if that's not an order confirming the Board Review report, I'm not quite sure what it is. The Commonwealth Court and the Hendersons both suggest that it was an order making preliminary evidentiary findings. And that's in paragraph 6 of the order. The trial court said, I'm making these findings and I'm not sending you back to another Board of Review. I'm not remanding it. You're going to trial. But that argument that these were evidentiary findings, as opposed to an order confirming the board, unravels pretty quickly. Start with Section 518 of the Eminent Domain Code. It provides the procedure for an appeal, and that provision is sequential. 518.1 requires that all objections that have been raised in a notice of appeal under the Eminent Domain Code have to be determined preliminarily, and preliminarily in this context means prior to the trial de novo. 518.2 says the trial court may then confirm, modify, change, or remand to the Board of Review its determination of the objections raised in the notice of appeal. In the 14.38 acres case, this court explained that all isn't really read literally, but it means that it's the legal objections that get determined, and then when there's a jury demand, there's those disputed factual issues, to the extent that you have to look at conflicting evidence, those get reserved for the jury. It's not an option to skip over that process, that preliminary determination of legal objections. If the trial court was making preliminary evidentiary objections, there was nothing for it to determine. There were no motions in limine. There was no exchange of exhibits. There was no identification of witnesses. There were no identification of experts. In fact, the last paragraph of the court's order confirming the board report directed the parties to meet and confer about a schedule for a trial, and including discovery. The Hendersons argue that when there's a jury trial demand, you can't have an order confirming a board review report, because that would be an advisory opinion. Everything's going to be left for the jury.
But counsel, isn't that what Judge Dozer did in this particular case with his order? I mean, paragraph 12, to the extent that Condemn's legal objections conflict with these determinations, they are overruled. Then he goes ahead and he schedules, in the remaining paragraphs, pre-trial conference for a de novo trial.
Yeah, I think that's right. And I think there are two things about that. First, the next step isn't necessarily a de novo trial. There's also, we had asked for the matter to be remanded to a board review, and he refused to do that. And the key there...
For what purpose?
The Eminent Domain Code has a pretty unique procedure. So in the run-of-the-mill civil case, we're kind of used to having discovery, a trial, and then an appeal. The Condemnation Code, the Eminent Domain Code, sets up a procedure through sections 516 and 518 that the courts have explained try to settle the board review report before there's a trial de novo to avoid it. Right? So to the extent that there are legal objections, and the legal objections undermine the basis for the board review report, those get settled first, because it changes the dynamic between the parties, and maybe the parties will be satisfied.
But the legal objections were denied.
Correct. And that's by overruling the legal objections, that confirmed the board review report.
Well, but that's like saying by overruling preliminary objections, you've disposed of the case. And I think Hessian's an interesting opinion. But you're assuming that the obligation for a trial judge, for a court to determine, these are statutory proceedings, these are not proceedings governed by the rules of civil procedure, for the trial court to confirm, or for trial courts required to rule preliminarily on the legal issues, correct?
Correct.
Then you say that ruling is also what happens in 2?
What I'm saying is that when you look at section 518.1, so the obligation on the trial court is to rule preliminarily on the legal objections.
Agreed.
That's clear. So then you get to 2.
Right.
And 2 is basically the menu that the trial court gets to choose from when it's issuing an order, reviewing the legal objections, and making those.
That's where I sort of disagree with you. Okay, and follow me on this. This is in the procurement code as well. So when the General Assembly sets up a statutory procedure, it tells the court at the end, you have a couple of options. You can confirm the lower proceeding, you can modify the order, you can reject or overturn the order, you can remand. They say there's no other disposition that you can do, which is what I sort of read paragraph 2 as saying, these are the dispositions you can do. This is all you can do. You can't do anything else. And then they say, of this menu of things that you can do to dispose of the case, meaning dispose of it, meaning you're done, only these are appealable. Why isn't that the best way to read this? So one is, oh, by the way, you have to preliminarily determine all these issues. 2 is, your final dispositions can either be confirm, reject, or remand. And 4, of those, the remand is not appealable.
I don't think that I'm disagreeing with you, because if you look at Section 1, let's start with Section 1. Section 1 is you have to make those preliminary determinations, right? That's clear.
Those preliminary determinations could just be, I overrule your objections.
I overrule your objections.
Right.
But when you look at 2 and treat 2 as the menu that you get to choose from in making that ruling?
No, I'm not saying in making that.
That's
I'm saying in finally disposing of the case. There's no question this case was not finally disposed of. There were still proceedings happening in the trial court pursuant to the eminent domain code.
Clearly not finally disposed of, but the issue is whether under the code you need to go through a trial and then appeal your legal objections to the Board of Review report. The procedure the code sets up is not that. And Section 2 of 518, it's not quite the same language, but it's parallel to Section 706 of the Judicial Code. And it's the same kind of language. And it doesn't use the word confirm, but it uses the word affirm. And in this context, when you have the trial court, in effect, sitting as an appellate court to make sure that the Board of Review applied the correct legal principles, its action in overruling objections and saying the Board of Review applied the correct legal standards are actions that confirm the board report. It's the same thing as if there was an appeal from a court of common pleas to the Commonwealth Court or the Superior Court, and the Commonwealth Court or Superior Court said that the Court of Common Pleas got it right. It applied the right legal standard. We're not sending it back for further proceedings, but that's not confirming the report, or that's not confirming what happened to go.
There's going to be a trial. This case, even by our, let's even assume the rules of appellate procedure apply, even by our definitions, this is not a final order.
It's not, and that's why Hessian is important. So the language in Hessian gave content to the word confirm, and in Hessian, the court expressly said that the opinion recognized that it's creating a situation where what could traditionally be thought of as an interlocutory appeal is not interlocutory because it's made a final order. And the part about Section 2 that's significant is that the court may confirm, modify, or change the report or refer it back to the same or other viewers. It doesn't say that you can skip that process and send the parties to trial, right? So that's not in there. And the Atkins case.
And I think it really goes to Hessian as well, which is your disposition in 1 always equivalent to one of the things in 2? And that's where I'm a little unsure. Now, Hessian may have said it was. I think there was something else going on in Hessian that isn't going on here. But it's the linkage between 1, a preliminary determination of objections, and this paragraph 2 about what you can do, which I sort of read consistent with other statutes that have these types of provisions as in your final disposition, these are the things they can do. Not in relation to preliminary determinations, but in final dispositions that this is what you can do. And of those final options, only 3 of the 4 are immediately appealable.
So to answer the first part of your question, I think the answer is yes, that these are the things that you have to do, and you always have to do one of them in making the preliminary determinations of the objections. And I think when you look at Hessian, the City of Chester decision and the 14.3 acres decision, all from this court, that's it's more than just the sense, right? In the 14.3 acres case, it's pretty explicit. This is what you do. You make the preliminary determinations. In making those preliminary determinations, you may do one of these things, and then the order making that disposition then is a final appealable order. And then the point that Hessian emphasizes is that even though it's traditionally the run-of-the-mill civil case would be an interlocutory appeal, here it's different. Because the courts have interpreted the intent of the eminent domain code and this procedure to avoid trial. So where, again, in the run-of-the-mill case, we go through everything, we go through trial, and then we get to appeal and come up with deal with all the errors and get them disposed of. In the eminent domain procedure, there's a distinct procedural step where before you make the no-go decision to go to trial, right, after an appeal, you get to have the board review report settled. And the whole idea is that the parties otherwise satisfied with a board review report may not go to trial, right? So if you know that there's it changes the dynamic between the parties, and the idea is to get to a resolved value at the board of review, applying the right legal principles to make sure both parties can have confidence in the
Counsel,
number.
could you wait till the sirens pass? Okay, thanks.
And then, Justice Brobson, I think to me the last part of the answer to your question is the end of Section 2 of 518. It constitutes a final order, right? And then under Appellate Rule 311.8, an order made final by statute is an appealable order. So under the way that this provision is written and the way that it has already been interpreted by this court, that it really is sequential. So the first thing you do is you make this preliminary determination of legal issues, and under 14.38, the job of the trial court is to separate out the factual objections and the legal objections, and we did that in our notice of appeal. And then you make, when there's a jury demand, and when you make a preliminary determination, you then make a preliminary determination of the legal objections that are raised. In doing that, sitting as essentially as an appellate court, sitting over the board of review, you do what appellate courts do. You either confirm, modify, change it, or send it back for further proceedings. Right? That's the menu. What you can't do is skip over the preliminary determinations, and then what you can't then do is skip over, well, I'm not going to confirm, modify, or change the report. The rest of the sequence is in sections 3 and 4 of section 518, because section 3 tells you, okay, we've made these preliminary determinations. We have this menu of choices, and of that menu, an order confirming a report, which is really all we're talking about here today, confirming a report constitutes a final order. Then, when you go to trial, the amount of damages shall be determined by the court unless a jury trial has been demanded. And then 4, at the trial, the condemnee is the plaintiff and the condemnor is the defendant. So you have this this sequential statute that tells you how you dispose of the appeal, and in fact, the title of the section is disposition of appeal. So, and,
can I use an example from the facts in this case? You objected to the use of extraordinary assumptions before the Board of Viewers. The trial court said, I do not agree with your objection. Objection denied. Now, In doing that, the trial court is saying in the trial that's going to take place, extraordinary assumptions can be relied on in the trial. Am I correct?
That's the way I understand it. That's the way I understand what the trial court thought he was saying. But
that's not what the trial court says. The trial court seems to say, but none of this matters because it's going to go to a trial de novo. Is the trial court thinking that in the trial de novo, there are no binding decisions being made at this level? Because if that's the case, why bother with any of this?
yeah, and I think that's the problem here. So if you look at the procedural posture of this, there was the trial court asked the parties to submit evidentiary rulings that we wanted. And when we were asked, and this is, I think, page 1374 of the record, we said, we're not asking for evidentiary rulings. We want preliminary determinations of the legal objections we made to the Board Review report. And we said the same thing about the court's request for jury instructions. And I start a little earlier. The premise of the Commonwealth Court's opinion and the Henderson's argument is exactly that. There's going to be a trial de novo, so there could be new experts, new exhibits, new witnesses, new discovery, new theories. We just don't know.
That latter part is the rub. I mean, if there can be new theories, I don't know why you go through the Board of Viewers process. I mean, what you're saying to this court, I'm asking them to review these objections, is that it was legal error to allow extraordinary assumptions to be used.
That's correct.
I mean, if you are correct, that may dispose of the entire case.
That may be so, but remember...
But on the other hand, for the trial court to say, I'm going to deny that objection, you have to conclude that he's disagreeing with you.
He is, and I think that's why I come back to the order.
But why isn't that a confirmation of what the Board of Viewers did?
I think it is a confirmation that he's disagreeing with us and said that what the Board of View did was correct. So in paragraph 11 of the order, aside from paragraph 12 saying that he specifically overrules our legal objections, in paragraph 11, he said, as reflected in the preliminary evidentiary findings above, the Board of View used the correct standard of proof when determining the highest and best use of the condemned parcels. So if you look at whether it's 14.38 acres or City of Chester or Hessian or just the manifest understanding of the word confirm, that's a confirmation of the board report and it becomes a final appealable order. The issue becomes when you say it's not a confirmation of the order, but it's evidentiary findings. Evidentiary findings on what? Right. There was nothing in front of the trial court. Nobody asked them to make evidentiary findings. We certainly didn't. And instead, he was essentially making an advisory order about how this hypothetical trial de novo would proceed. But critically, we had asked in the notice of appeal to remand it to the valuation to another Board of View or to this Board of View.
Remind me, counsel, what was the actual decree entered?
For by the Board of View?
No, by the court on the disposition of the appeal. Subsection 2 refers to a decree confirming, modifying, or changing the report constitutes a final order. What did the decree in this case say?
I think the decree in this case said that it is the order that the trial court entered, and it said the objections are overruled. The board applied the correct legal standard. I'm not remanding it to another Board of View. You're going to trial, and by the way, your objection that there was a legal failure to apply preclusive effect to a prior with prejudice dismissal that's overruled too. So if you compare this order, which I think is the decree under Section 518, and compare it to Hessian, you can't distinguish the two. If Hessian means anything, it's if you agree with the Board of View and then you send the parties to trial, that's an order confirming the Board of View.
And Hessian said in the usual world, this would be interlocutory and not appealable. But pursuant to the statute, it's appealable.
Yeah, and that's exactly what...
Because in the ordinary world, it would be not appealable.
That's right, and that's in the run-of-the-mill civil case, it's a different procedure. The General Assembly in the context of eminent domain cases chose a different procedure. Rather than waiting to the end of the case, the procedure has been interpreted to try to settle the report to get the parties to avoid going to trial.
I guess what I'm trying to understand is why wouldn't the statute say instead an order disposing of an order preliminarily disposing of the objections, an order in one, is immediately appealable?
Well, so the language there's some historical piece to it. Originally, there was a section 523 of the eminent domain code that said final orders under the code can be appealed to the Superior Court or the Supreme Court, and Hessian actually references section 523. But through the amendments to the eminent domain code, section 523 dropped out, and instead you have section 762 of the Judicial Code, which now makes appeals from orders in eminent domain matters or appeals in eminent domain matters go to the Commonwealth Court. And so you take section 762 and section 518 of the eminent domain code and then rule 311 of the Rules of Appellate Procedure, and you have the same thing that section 523 used to say, but now it's been moved to a different section.
I guess what I'm confused by is if the way that this proceeded is the way it's intended to proceed, I don't understand the purpose of the appeal.
So the purpose of the appeal...
Well, I know what I would think the purpose of an appeal would be, but if a trial court could say, I'm going to make preliminary rulings, but it's not necessarily binding on the during the trial de novo and just move on, why would you go through this appeal process?
Because the next step may not be a trial de novo. One of the things that comes back to the request we made in the notice of appeal to correct the legal standards and send it back to a board of review for a correct valuation.
I understand that. I understand that, but that's nothing like what the trial court did here.
It isn't,
and the trial court just took no action. It could be read that it took no action at all. Yes, I understand you have issues with some of the rulings and the evidentiary standards and things of that nature, but this will get straightened out in the trial de novo.
So I don't think that was an option for the trial court.
No, I agree with you. It doesn't appear to be that way.
And I think that's kind of where some of the confusion comes in. Mm-hmm. In 14.38 acres makes pretty clear that that's not an option, right? There's no pass the preliminary determination stage and go directly to trial.
If you understand it, if you weren't here and the trial took place, how would that trial go forward? Would the extraordinary assumptions be permissible in terms of the highest and best use? Do they have to prove financial feasibility? I mean, how would the trial go forward? Just as it did in the before the board?
That's how I understand the order that the trial court entered. And where's it in paragraph, the end of paragraph 11, right before paragraph 12, before he says that our legal objections are overruled. He wrote that the jury may hear and weigh testimony of various uses of property, i.e. industrial flex buildings, et cetera, air cargo, et cetera, et cetera. And then in 12, he goes on to overrule the legal objections. And then in 13, He says that condemnees are not collaterally stopped from presenting evidence that Condemn nor froze the market prior to condemnation. The objection we made that the prior with prejudice dismissal of the de facto action didn't have preclusive effect. So with no evidence in front of him, no witnesses, no exhibits, no motions in limine, none of that, he said, well, I'm making these rulings and here's what the evidence is going to look like. So if anything is an advisory opinion, it's this. But what I think that this reflects more is what the judge said, Judge Dozer said in the preamble. He was trying to make preliminary determinations under Section 518 of the eminent domain code. There is some language in Commonwealth court cases that is a bit loose. There's a statement in the Kelman decision, which by and large I think gets the procedure right, that in explaining the distinction between issues that need to be determined preliminarily in an appeal from a board report and issues that have to be determined in connection with trial, that the linking sentence is not every legal issue needs to be determined before trial. That got twisted a little bit in a decision, a later decision by the Commonwealth Court called Fackler, where and in the Commonwealth Court opinion in this case, where they took that to mean that the menu in Section 518.2 is bigger, that the menu includes, we don't have to do any of this, we can just send the parties directly to trial. What that line in Kelman was referring to, and you see it in other Commonwealth Court decisions like Whitehall Township and Route 50 that we talk about in our briefs, is if you file a notice of appeal and you don't raise any objections, you just say, I object to the amount of the award, there's nothing to preliminarily determine. Then you go directly to trial. If you don't ask for any objections to be determined preliminarily, and you take that next step of saying, okay, we're going to trial, I'm filing motions in limine, I'm filing pretrial statements, those objections, any issues relating to those pieces don't relate to the board report, they relate to the trial. So those kinds of objections don't go up on appeal. That's not an order confirming the report. But if, as the South Whitehall Township case said it, and I think it really is kind of a bright line standard, when the relief relates to the board report, then the preliminary determinations are under 518.1, and an order that agrees with the Board of View is a confirming order that's final and appealable. And when you look at how the Commonwealth Court has treated this, right? So orders just like this, where, and it's more in the trial judge's opinion trying to explain the order, where it's, no, I'm not confirming the report. I'm not treating this as an issue of settling the board report. I'm treating this as a trial issue. In Kelman, and then in another decision called Goddard, also from the Commonwealth Court, they said, no, that's wrong. You can't treat these legal objections to the board report as a trial matter. What you should have done is treated this as a preliminary determination under 518 and done one of the things in 518.2 that then make it a final order.
But how can you, I mean, I over here again, sorry about that. I'm struggling because we keep talking about the confirmation. How can you believe that the trial court order confirmed the board's report because the jury hasn't decided the highest and best use value yet?
Right.
Isn't that, I mean, we keep talking about the mixed questions of fact and law, but the ultimate issue here is what the property's highest and best use is, and that's got to be determined by a jury. So you're saying that this was a final order because it confirmed the report, and therefore it's automatically appealable. But the jury didn't determine the highest and best value yet.
Right, and that goes to the unique procedure under the eminent domain code. So, again, in the run-of-the-mill case, we would have a trial and then there would be appeal. But remember, the structure under the code.
Well, let me ask you about the structure then. You're asking to basically send it back to the Board of Review? For what purpose?
When you have a Board of Review report, the goal of this structure, according to the cases that have interpreted the code, is to get a report that the parties are satisfied with, so there isn't going to be a trial. So there may not be a trial de novo, right? You could also get a remand to the Board of Review or to get a new valuation.
How is the Board of Review going to do that any differently than the jury? Because the Board of Review's got to determine the highest and best use of the property and then give you a valuation of the property, but that's essentially what you're asking the jury to do. So that's why I'm struggling to understand. You're asking us to suggest that the condemnation code has this extra requirement that after the trial court makes the initial determination, it's got to be sent back down to the Board of Review again in the hope that the parties are going to be able to get a Board of Review that they both like and they're both therefore settle the case.
It's not that they get a Board of Review that they both like, but they get a Board of Review report that follows the law. So start with the code itself, because it really is like this is a textual case, that at the end of the day it all comes down to the words of the statute. And the principal issue is whether the opinion here, the trial court here affirmed the board report, and I think under any meaning of the word affirm, that any manifest understanding of it.
I wouldn't agree with all those. Again, I have a question. Your interpretation for affirming has in a situation where the issue is not valuation, the issue is whether there's a condemnation. So it's a little different. Material or not, I don't know, but it was a little bit different. Here, the only issue is valuation, which the code specifically puts in the hands of a trial by jury if demanded. The preliminary legal determinations here all go to what standard is going to be used at the trial. So the judge was really setting the preliminary framework for the trial, not judging anything about the Board of Review report. If the jury comes back and says, you know, the board was right on, then you get your order confirming the board report. But you're kind of saying just because there's this one little tiny legal issue that the Board of Review had out of all the issues that we're raising in the report, and in a preliminary matter, the trial court judge agreed with it and rejected our objection, that amounts to confirmation of the report, like the entire report. I think one could read the statute to say when it says confirm a report, it means confirm the report, not parts of it, not pieces of it. Confirm it.
So I'm going to try to answer your question, Justice Brobson, and Justice McCaffrey's question together. And I think it all comes back to the text of the code. But before I get into the text, I just want to address your point about the issue in Hessian being whether there was a condemnation at all. So when you look at the other cases that have been decided under the eminent domain code on this unique appeal procedure, they don't go to whether there was a condemnation at all. They're much broader. So in the 14.38 acres case, the issue was whether attorney's fees and appraisal fees could be included in the damage award. And then in the City of Chester case, also from this court, the issue was where the condemnee is a public entity, do they get to claim the value of a bridge as part of their damages? So it's broader than just was there a condemnation at all. And that's why I keep coming back to the text a little bit. Oh, and let me just add, when in our notice of appeal, and it starts at page 1112 of the reproduced record, the issues we raised, and I think the Commonwealth Court recognized it, the Hendersons admitted at page 2 of their brief, and the trial judge even said it, we raised distinct legal issues. And the Commonwealth Court said we raised an issue as to the standard of proof to be used in determining the highest and best use at the board level. But it was way more than that. So the trial court's order at paragraph 5, said the standard of proof is a threshold issue. And even in the most narrow reading of the word all under the statute, threshold issues have to be determined. It's the lens that the board is supposed to have looked at in coming up with this valuation. And remember, it's a $139 million valuation. Right? We have struggled to find a case anywhere like this. We actually took all the cases that the Commonwealth Court cited in its opinion and added up all the awards, and we didn't come close to $139 million. So under the code, we're entitled to have a board review report that applies the correct legal standard to get a credible valuation before we decide whether to go to trial. And the code, by its text, as this court has already interpreted, and I keep coming back to the 14.38 acres case, makes provision just for that. So and this is Justice McCaffrey, I'm coming back to your question a little bit. Start with section 516 of the code. Right? It's the right of appeal. And the extent of the right. A1, any party aggrieved by the decision of the viewers may appeal to the court. The appeal shall raise all objections of law or fact to the viewer's report. Then 517, it's kind of the first hint of this unique procedure under the code because it specifies what a notice of appeal has to look like under the eminent domain code. Very different than notices of appeal in traditional civil cases. Contents of the notice of appeal. A4, objections, if any, to the report other than the amount of the award. So they have to be set forth in the notice. And then you get to 518. An appeal shall be disposed of as follows. It's shall, right? This is not an option. All objections, other than to the amount of the award, raised by the appeal shall be determined by the court preliminarily. Now, 14.38 acres already takes that all and narrows it to legal objections. When there's a jury demand, there's a little bit of a tension between 14.38 acres and the court's earlier decision in City of Chester, but that doesn't much matter for our purposes today. Section 2, after being told you shall make that determination preliminarily, this is what you do. The court may confirm, modify, or change the report or refer it back to the same or other reviewers, and a decree confirming a report constitutes a final order. And then it goes on in 3 and 4 to tell you how a trial works. But Justice McCaffrey, to your point, why do this before there's been a trial? I think it's really two answers to it. Because this is how the General Assembly said to do it. And that's the way 14.38 acres treats it, and that's the way existing Commonwealth Court case law has treated it, and existing case law, whether it's Hessian or City of Chester or 14.38 acres, this is how you do it. You settle the board report first. You make sure that in applying the law, and remember that a board of review is made up of 3 people, only one of them is a lawyer. Right? So the trial court is really sitting as an appellate court overseeing the legal determinations made by essentially a board that has majority non-lawyers. And if you mess it up, if the law is wrong, like it is here, and you get this $139 million valuation that has no credibility under the law, instead of going to trial, and to avoid a trial and the expense of trial, correct the legal errors. Send it back to a board of review and get a better, more credible report, because then the parties can make a decision not to go to trial. And that's not my interpretation of the code. That's the way the cases.
So let me ask you this question. The $139 million valuation from the original Board of View as set forth in the report was based upon their acceptance of the condemnees' highest and best use valuation experts, right?
Correct.
What in Judge Dozer's trial order do you think is going to change the next Board of View's valuation of the highest and best use? Because that has to be determined by a trial de novo.
Well, that's why we appealed Judge Dozer's order, because we think he got it wrong. So you have he confirmed the report, and he shouldn't have. He should have rejected it and remanded it. And
I don't know that he confirmed the report. You keep saying you confirmed the report. The fact of the matter is that the ultimate highest and best use value has got to be determined by a trial. You're suggesting that he files an appeal on a legal issue?
Yes.
Okay. Yeah, those two things can both be true.
I got you.
Under the code. So under the procedure, step A, and distinct step A is you get a settled board report. You get a valuation, you get to appeal to the Court of Common Pleas, and you set forth all the objections to law or fact. And then following 14.38 acres, the trial court, sitting as an appellate court over the Board of View, determines the preliminarily, and preliminary means here, before a trial de novo, as it relates to the board report, those objections to the report. Its order, then under 518.2, where it can either confirm, modify, change, or remand the report, becomes final and appealable, because while it may seem interlocutory, just like Commonwealth versus Hessian said, in other contexts it would be. Here, it's a distinct step that the General Assembly provided for in the code, with a unique procedure that already has a unique structure to it, telling people, let's see if we can avoid trial. Let's see if there are objections and it turns out the Board of View got the law wrong, send it back and let's get a better report.
Counsel, let me just take it to the logical conclusion. If the trial court would have done what you suggested, which was to remand it to a new board or the existing board, your opposing counsel could have appealed that.
Correct. Well, yes and no. So there's some dispute. There's some, wait. I know, Justice Brobson, you're shaking your head.
Yes or no, but not yes and no.
Well, there's the Dacker chemical case from this court that's cited in Hessian and in Kelman, held that a remand is also appealable. But in Kelman didn't address Dacker chemical, but said no, a remand is not appealable. It does. I agree with you. And I think the position that we took, I think in a footnote is exactly that. But that doesn't matter here because that's not what happened.
Okay, are there other questions?
If the trial court had agreed with you on all of the standards that were used for highest and best use and then remanded it, the case would have been valued very differently.
Correct.
From both perspectives, in which case it may have settled.
Correct. Or my friend Mr. Rogers might have appealed to the trial court, and if the trial court then confirmed the Board of Review report, they would have a right of appeal, the Hendersons would have a right of appeal to the Commonwealth Court to correct what they saw as any legal errors.
When would that happen? After that
step of a remand, if there was an appeal back to the trial court.
Okay.
All right, Mr. Richards, thank you very much. Let's hear from Mr. Rogers.
Good afternoon, Chief Justice Todd,
Justices. Ed Rogers from Ballard Spar. With me is Nathan Farris. We represent the appellees in this very long case that may remind some of Bleak House. The taking, as Justice Todd began this session, took place 8 years ago. The one thing that can be said for sure is that if this case is reversed, if the appeal is upheld in this case, and we will be many more years before a trial. We were supposed to have a trial in 2021, which already was 4 years after the taking. Just since 2021, there have been a lot of developments that would affect the next trial. We have a new mayor, the trial judge is deceased, the city's lead witnesses no longer work for the city.
What does the mayor
And
what does the mayor have to do with the valuation of a property?
Well, what he or she has to do with the valuation of the property simply relates to the fact that it's a major liability of the city and presumably would need to approve any resolution. But the most important part of this is that a fundamental purpose of the code, and Mr. Richards talked about it a number of times, is really to obviate the need for trial, to streamline the proceedings. That's why we have boards of view. It's an administrative procedure that they don't need to follow the rules of evidence. The goal of that procedure is to keep these valuation disputes out of the courts. Okay? And also the purpose of these preliminary legal determinations by the trial judge is to expedite the litigation and to give the parties an opportunity to resolve it between themselves. The perverse effect of Mr. Richards' position is that the preliminary determinations become now the basis for potentially two levels of interlocutory appeals before we even get to the trial. And in fact, a remand from this court would result, a reversal, it would result in another appeal, an appeal before the Commonwealth Court on the merits of the legal standard, which is really the merits.
Isn't it important that the Board of Viewers gets it right?
Well, yes and no. The right that either party has who is unhappy with the Board of View is a de novo trial. In that de novo trial, not only is the Board of View report a nullity, a legal nullity, it is not, by statute, it is not admissible in the trial. The jury will never know that the Board of View thought it was $139 million. That cannot come in. And the remedy, the code explicitly gives a disappointed party in the Board of View is a jury trial. The city elected a jury trial here, and now what they're asking is to have the appellate courts write the jury instructions in advance of the trial. What they really want is a ruling that says the correct standard for highest and best use is that something be reasonably certain at the time of the taking rather than reasonably possible. We want the jury to be so instructed, and what they've done, frankly, is invited, not only have they created a huge category of interlocutory appeals, pretty much from every legal determination, and I'm going to get to 518 in a moment and explain how that is.
Counsel, before you move on, what's wrong with wanting the jury to be instructed on the correct legal standard?
There's nothing wrong at all. It's a matter of timing.
Well, that's what I don't quite understand.
Yeah.
I mean, when in the disposition of the appeal, the trial court sitting as an appellate court is to decide that legal issue prior to the trial by jury. So that's when the correct legal standard or jury instruction would be decided. What's wrong with not wanting that clarified
Let me just say,
before a trial?
let me just say that in the ordinary case, jury instructions are appealable post-trial.
Well, this is not an ordinary.
Well,
this is not an ordinary
right.
proceeding, obviously. I mean,
Understood.
Contrary to the ordinary.
What the cases say about 518.1, and I think actually maybe I should back up
and talk a little about the statute before we get into what I would call the policy arguments. So I want to start with 518.1 and 518.2 are two different sections. They are not, as Mr. Richards argued, sequential in any way. There are multiple opinions. We've cited them in our brief. Kelman is one, Fackler is another, that say, Whitehall is another, that say relatively few preliminary determinations will be confirmations or will lead to confirmations. Justice Robson, while on the Commonwealth Court, had a case like this called Quincy Township. And in Quincy Township, the appellant said, you should hear this case because Hession says you can hear this case on an interlocutory basis, period. And Justice Brobson said no. Then Judge Brobson said no. Hession was about whether Hession really involved a threshold issue. Was the property taken or not? Hession was a de facto condemnation case. Once the Supreme Court decided Hession, the litigation was over. It was dispositive. It was outcome determinative. If this court reverses, sends it back to the Commonwealth Court, and the Commonwealth Court, let's assume for the moment, decides the question of the appropriate legal standard in favor of the city and says, yes, a harder standard to prove highest and best use. That isn't outcome determinative. We just then go to trial. We have a different standard. By the way, we may have different evidence. We may have a different expert. We may have a different theory. There's all sorts of things that can happen. And as a result, the idea of these appeals in between the trial court's preliminary determination and the actual trial are themselves advisory. It is somebody asked me about extraordinary assumptions. We may or may not have extraordinary assumptions when we go to trial. There may be no need to rule on the admissibility of extraordinary assumptions. But that's just an example.
But if you attempted to use extraordinary assumptions and the trial court sitting as an appellate judge says you can't use that, then you would not be able to use that.
That's correct.
Whatever the trial court sitting as an appeals court at this juncture does is binding in the trial of the case, correct?
Not necessarily.
Now, what would be the point of making a preliminary
there is a point
for the trial?
I think this has gotten lost a little bit in this argument, okay? Because there's case law on this. The purpose of the preliminary determination is it's to inform the parties and, in effect, to help them handicap the case and decide whether to resolve it. As you can tell, that didn't work here. Instead of leading to a resolution, which would have happened in 2021, what this led to was 4 years of appeals and a lot of hours of work by Commonwealth Court and now this court on certain issues that may or may not affect the outcome of this case. And I guess that's what... Let me talk a little about interlocutory appeals, right? In general, I think it's not a controversial statement that they are the exception and not the rule. And that's why you have, when they are provided for, it is express. And when the trial judge makes a preliminary determination under 518.1, the statute doesn't say you can take an appeal. It doesn't say a preliminary determination by a trial court. This is to Justice Donahue's question. The statute doesn't say a preliminary determination from a trial court is a final order.
No, that wasn't my point at all. My point was, if you go through this process of an appeal and raise a legal issue, and that court at that time rules on that legal issue, when the case is ultimately tried, the trial judge is going to be bound by that legal ruling, or there is no point to this at all.
Well,
there's no point to this at all. If a trial judge, as sitting on as an appellate judge, makes a determination on a legal issue, and then at trial that ruling can be ignored What's the point of doing this at all?
First of all, the trial court certainly could revisit the issue of the standard once he receives competing jury instructions from both sides leading up to trial, motions in limine, whatever.
What's the point of this at all? What's the point of this
Well,
at all if it's not to get a resolution of a legal issue?
The point of it is to inform, as Mr. Richards and I agree, the point of it is to inform the parties in advance of the trial. The language the cases use is the purpose of the preliminary determinations is in the hopes that the parties will then be satisfied with the board report and will not try the case. The overriding purpose of the eminent domain code, as I said, is to streamline and reduce and make more economical the resolution of valuation disputes.
It doesn't say facilitate early appeals to make the process last longer.
Correct.
But
Sorry?
it doesn't say facilitate interlocutory appeals to make the process last longer.
Correct.
But I have a question about this appeal thing. The statute says appeal. Your opponent, during his argument, said his right to a correct board of view determination. Is the common pleas court here really sitting in the capacity as an appellate court? Other than the fact that the statute says it's an appeal, is it really an appeal?
No. Not in the way that we would ordinarily think of an appeal, because
Is there any deference being given to the fact-finding of the board of view at all?
Zero. Not only that, it's inadmissible. It's inadmissible, and the report itself, Mr. Richards talks about settling the report. That's a legal fiction. He's elected a jury trial. There is no report. There is no, the evidence that came in the board of view is not in.
I mean, I guess the court could say, I've read the report, I agree with it 100%, I'm confirming it, you're not getting your jury trial, take an appeal.
Right. Let me talk about confirm, Justice Robson, for a moment, because we spent a lot of time on that. Confirm, the common sense, dictionary, legal, whatever you want, meaning of the term confirm in this context is to give legal effect to. When a bankruptcy judge confirms a bankruptcy plan, which is the example that Black's Law Dictionary gives, okay? What that means is he gives it legal effect. It becomes a binding document that determines how much the debtor is going to pay and which creditors are going to receive. Okay? It doesn't mean agree with. It doesn't mean deal with in part. The city raised 50 objections or 20 objections, as the Commonwealth Court held in their en banc opinion. There is no point in an interlocutory appeal. It doesn't serve judicial economy. It doesn't serve the purpose of the eminent domain code because there's going to be a trial. There are many, many, many issues here.
But maybe there wouldn't be a trial if the parties felt the board of viewers had done a good job. Maybe.
I suppose that's possible. But I mean, think about what's happening here, right? The losing party objects, okay, and then in addition to getting the trial court to make these preliminary determinations, okay, it gets to go to it has the right to go to a jury. What would you prefer if you were the city? Do you want to go back to the board of view that ruled against you? And by the way, do you want to take another couple of years? Because in that board of view, let's assume for the moment it doesn't work out so well for the city in board of view number 2. Then they're going to ask for another jury trial. And the trial judge will make more preliminary determinations. And those preliminary determinations under Mr. Richards' position will be automatically appealable to the Commonwealth Court. And if he loses at the Commonwealth Court, he's going to file a petition for allowance of appeal, citing that this court's reversal in this case. Mr. Richards and I will have long retired. It'll be Mr. Farris's case at this point. And those witnesses...
That'll give you something to live for.
And let me start by saying I wasn't the first lawyer on this case for the Hendersons. But I think I think it's really important here to think about, to kind of get back to basics here, right? And basics really is, what does it mean to confirm a report? What it means is you give it effect. Then that fits, that makes sense. Why? Because if the report is confirmed and it is given legal effect, and then you file an appeal. But if the trial court doesn't confirm, your remedy is not to get the appellate courts to issue an opinion in the abstract about legal questions that the disappointed party, that the losing party believes affected the outcome. And to Justice McCaffrey's point, highest and best use is a critical issue here, and
It's the issue.
it is the issue here, and it's going to go to the jury. It absolutely could not have been decided by the jury. And I actually want to get to 1438 in a minute because it
Can I just interrupt
deals
for 1
with
second?
this. Sure.
We've spent a significant amount of time almost exclusively talking about the process and whether or not it is or is not appealable and the various subsections of the code. What was it that were the substantive objections? In other words, that's what I was trying to get to Mr. Richards. If this matter is sent back to another board of view, what is it that the city of Philadelphia is asking to do?
Well, it isn't entirely clear.
I've handled a number of condemnation proceedings in a prior life, and it's always about real estate experts.
Right.
And it's a battle of the experts. So you basically put your expert up there, you cross-examine them on a variety of subjects, and you come up to a valuation. If you're not happy with the valuation, you take the appeal, you get a trial de novo, you put it in front of a jury, and highest and best use value. If we accept Mr. Richards' kind of thought process, it goes back to another board of view, and what happens? Is there a preclusive effect on the property owner's expert?
Well, there certainly shouldn't be, since then you wouldn't really be having a de novo trial.
That's my point.
Yeah.
It all starts anew again. So it's like you're going to call the same experts or other experts who are theoretically going to give you the same price.
Yeah.
The city's going to call their same experts who are going to give you their same price.
Good for the experts.
So what is it they're asking? That's what I don't get. What is it you think would happen if we accepted the city's view on this? Like, you send it back to the board of view, and what happens?
Well, I think what Mr. Richards would say is, once properly instructed, the Board of View would...
Instructed on what? That's what I'm trying to get at.
Well, the merits of the appeal, which is actually not the subject on which this court grant allowance.
Well, the merits
of the appeal are...
Valuation, the highest and best use value.
Well, no, but that's the merits of the case. The merits of the appeal are, what is the standard, what is the legal standard that condemnees have to meet in order to show that the highest and best use on the date of the taking was not the highest and best use, that the future highest and best use would be different. And that was the issue that divided the parties. And yes, there was a full six full days of hearings. Both sides had expert appraisers. In fact, both sides had 2 expert appraisers, and they were cross-examined. And that will happen again at the trial.
But I understand that, but that's the legal challenge that was brought before Judge Dozier, which is why I started off when the first question was paragraph 12, when he said legal objections are overruled. So what Judge Dozier was saying was that the legal objections to those particular arguments that were brought up by the city of Philadelphia are overruled. So if it's sent back to another board of view, it's going to be the same exact evidence, right?
It certainly could be. It certainly could be. And the one thing that we know is...
A situation where it wouldn't be? The legal objections that were interposed by the city of Philadelphia were overruled. You're going to put up the same exact evidence. The city's going to put up the same evidence. So theoretically, you should come up to the same highest and best use value.
Yeah, but
well,
Counsel, that was not what the city wanted. I mean, they only wanted a remand if the trial court agreed with its proposition that the standard that was used was incorrect. That's when they asked for a remand, just for clarity purposes. That's what they wanted. They didn't want it to go back on the same way that it was tried in the first instance.
What's actually telling, Justice Donahue, is that they asked for it to be remanded. They could very well have have just proceeded, preserved their objections like every other civil litigant would
Well,
do.
they could have. And then what would happen is that you go through a full jury trial, arguably.
Well, maybe not.
Well, you go, assuming they aren't going to give on this, you go through a full jury trial based upon a standard of proving highest and best use that's incorrect. And then the appeal is taken, and it comes up through an appellate court, and the appellate court says, you're correct, that was not the appropriate standard of proof. And then you go back for, what, another jury trial? I'm just trying to decide where the time saving is in your approach.
It's a very important practical question. And my answer to that would be that the eminent domain code specifically and the law generally places a higher value on the efficiency of appellate proceedings than it does on the efficiency of trial proceedings. And that is why interlocutory appeals are the exception, not the rule. If the preeminent goal of the law were to make sure that every case was tried under the appropriate legal standards, every legal ruling pre-trial would be subject to an interlocutory appeal. And
But that's not how this whole system is set up. The system is set up based upon an initial board of viewers. In this case, there were three, two of them were lawyers. And the challenge is they got the law wrong. Don't make us go forward with the wrong law being applied in this case. Correct it now, send it back to the board of viewers, tell them what the appropriate law is, and then let them go at it. I mean, that's my understanding of what the position in the city is. I mean, you're right. Without this statute, we wouldn't be here. This would be clearly an interlocutory appeal. But this statute anticipates this intermediate step, whether Justice Brobson would quibble as if they're sitting as an appellate court or not. There's an intermediate step here where someone has the ability to correct a improper legal position that a board of viewers was acting on.
I don't agree, we don't agree, that that this intermediate step needs to rewind the entire lawsuit, okay? In other words, it is one thing to say the trial judge is sitting as an appellate judge for this limited purpose. It is another thing to say, if you don't like what the trial judge has done in its capacity as an appellate judge, you can go to the Commonwealth Court pre-trial and have the Commonwealth Court review preliminary determinations of the trial court without regard to whether those preliminary determinations ever make a difference in the resolution of the matter. And there's multiple ways.
I understand that. In a different case, I may be able to follow what your rationale is here, but and I could be not totally informed of everything that was happening here, but it appears that each of the legal issues that was raised here are essentially outcome determinative in the valuation method, in the valuation methodology.
Well, hold on.
No, don't hold on. Is that correct?
No, that is not correct.
That's a better answer. Okay,
I
so
apologize. That is not correct.
Go ahead.
That is incorrect. The outcome determinative would be if the trial court had said the Board of View correctly concluded that the highest and best use of this property supports $139 million. That would be one thing. That would determine the outcome, at least at the trial level. At least at the trial level. What the trial court did was it said, and frankly, quoted the eminent domain code and quoted the Supreme Court's decision, this court's decision in Pennsylvania Gas, and said, and we're getting into the merits here, but and said the correct standard is the highest and reasonably available use, okay? That in and of itself, you can certainly argue, as the city, and the city certainly believes, that use of that standard will make it more difficult for the city to prevail.
Of course.
But it does not dictate the outcome of the highest and best use.
Except for the fact that the hypothetical that you offered as to what a confirmation would actually be is not possible. Because if a jury trial is demanded, the trial court cannot rule on the amount of damages.
Well, certainly that
But
is.
that was what you said it would take for it to be a confirmation. That's not possible because the trial court could not have done that here.
That is, our position is that confirm means to give legal effect to, and that giving legal effect to something is not, it means that you know, it can't be undone short of an appeal. So.
All right, Mr. Rogers, I think we get it. Any other questions? Thank you both very much. Well argued. Who says eminent domain isn't interesting? Call the next case, Mr. Minner. Well, you've been sitting very patiently, waiting to be the final case of the day. In this appeal by allowance, mother sought to terminate the parental rights of father, who was an incarcerated sex offender. We must determine whether mother demonstrated cause under Section 2901 of the Adoption Act to allow the termination to proceed despite her failure to relinquish her own parental rights to the child and to establish that an adoption was contemplated as otherwise required by the Adoption Act. Please proceed.
Thank you, Madam Justice Todd. Justices, good afternoon. I'm Craig Bluestein. I have the honor and great privilege, and I say that very sincerely, the greatest privilege to represent Mom, E.L.R. in this case, who's seated right there in the blue shirt, because she loves her child so much and was going to do anything within legal bounds to protect her child. She comes before you today seeking your help in her desperate attempt to protect her child from the biological father, the Aplt, who was a thrice convicted child sex offender, a lifetime sexual offender registrant, a person who, by virtue of the Child Protective Services law, will never be able to work in any job involving children, will never be able to volunteer in any position involving children, will likely for a long time, if not forever, be unable to be near children at all or unsupervised. And
Is he presently incarcerated?
He is. He is incarcerated until he's February 27 or until 2037. It was a 5 to 15 year sentence. The minimum is till February 27. The maximum is till February 37. She seeks your help in a very simple way. She simply asks that you reinterpret your vision of what 2901, Section 2901 of the Adoption Act means in a way different than you found previously in the case of M.L.R. In M.L.R., 6 justices provided. Justice Doherty wrote the opinion. 4 justices agreed completely. Justice Weck dissented and concurred. By the way, with me today also, as a separate appellant, is Mary Pugh, who represented the child as a legal counsel, and of course Damian Brewster's here also representing father. E.L.R. mother is, by all accounts, and in the agreement of everybody in this case, including father and all the relatives who testified, an excellent mother, caring, loving, satisfies every need for this child. She's an educator. She trains educators. She is a person who many moms and dads entrust their children to teach them, to comfort them, to support them. It literally boggles her mind for the last few years that in order to protect her child, she would have to terminate her own parental rights or enter into a real or sham marriage to have a step-parent to adopt this child.
We have expressed that concept to the legislature by virtue of our opinions and notes, but they have not notes, we don't write them notes, I mean in footnotes to our opinions, but they have not responded.
Thank you for that. While they can respond, and while they can certainly amend the Adoption Act to reflect and impart their wisdom on the issue we're addressing today, they may or they may not, but it doesn't prevent this court from reinterpreting what 2901 means. In the very wise words of Justice Weck, as he stated in his dissent in M.L.R, he said, "It is not for the judiciary to improve upon the legislative branch's efforts in contravention of the law's plain language. The General Assembly is and was perfectly capable of designing a statutory scheme that limited the cause shown exception to specified circumstances. It did not do so. That is, the legislature did not do so."
Counsel, share with us how the child actually benefits from a termination of parental rights as opposed to the mother's current position of obtaining full legal and physical custody.
This is a child who has a father in this particular case, and there's other cases too that are relevant that I'll touch upon, but in this particular case, to answer you, Justice Doherty, this is a man who may get out of prison at a time unknown, has expressed in his sworn testimony a proclivity toward liking children. This mother is very concerned about what he might do to this child or any other child if he has access to a child. He has engaged in such behavior that calls for taking a position that he has lost his parental rights. He no longer has the right to be a parent for this child. There are other cases that I'd like to mention, at least 3 of which you don't even know about, which highlight the harms, mischief, inconsistency that the M.L.R decision has caused, is causing, and will cause, if I may. The first is called TG. It's that 2025 PA Super 35, a published opinion. It was decided after M.L.R. It was decided this year, February. In this TG case, the adoptive parents adopted him finally. They were his legal parents. After a few years, they realized that due to his challenges, his behavioral and psychological challenges, they were not equipped to parent him anymore. They were not willing to parent him anymore. So they filed a petition for voluntary relinquishment. Chester County CYS had been involved. So they were now involved with regard to this petition for voluntary relinquishment. The court below took a look at the Adoption Act, but not the adoption section, the relinquishment or termination of rights section. They looked at section 2501. In part B of that section, it says in order for the petitioners to be granted the voluntary relinquishment, the agency, that is Chester County, must consent to take custody, or in other words, must consent to the voluntary relinquishment and thereby take custody. They were faced with that at the trial court level. The trial court saw that, and it says the consent of the agency shall be required. As we all know, shall means must. Shall means shall. Mandatory. But that's not the way the court went. And remember, this is 2025 after M.L.R. The trial court exercised its wise and perceived allowable discretion to waive the requirement of that consent. The trial court felt the agency was unreasonably withholding its consent. So it waived that requirement, even though shall means shall, and granted the voluntary relinquishment petition. It went on appeal. The Superior Court affirmed that the trial court did not abuse its discretion in allowing a section of the Adoption Act to be waived, forgiven, dispensed with. And note that section of this is very important, that section of the Adoption Act that it was passing judgment upon was not the adoption sections. It was the termination of rights sections, relinquishment. So even after M.L.R, the trial court, and then the Superior Court approved, the trial court could exercise its discretion to dispense with a provision of the Adoption Act consistent with Justice Weck's comments, specific comments in his dissent in M.L.R.
Counsel, can I just interrupt, because right over here. A couple of times you mentioned the termination of parental rights section being separate from the adoption section. Is it are you claiming that the Adoption Act itself deals with more than adoptions?
Thank you, Justice. Well, it of course deals with the termination of rights, and it deals with adoption, all as part of the Adoption Act.
Right, so I guess my question is, do you believe, or is it your view, that the General Assembly, when they included the language about termination of parental rights in the Adoption Act, meant to create an independent statutory process to terminate any bad parents' parental rights?
I would say not an independent process, but a necessary process to get to adoption if an adoption is going to occur.
Right, and that's kind of to my point is in M.E.L. and T.G., adoptions were involved, right? And I'm trying to understand, I think you're asking for us more than to reinterpret what we did in M.E.L. Because the Adoption Act itself, let's just look at the venue provision, right? The venue provision ties the venue for termination of parental rights to the location of the adoptee. And the adoptee is defined as an individual proposed to be adopted. Doesn't that show the General Assembly's intent that in any termination petition under the Act, there has to be an adoptee? Otherwise, we don't know where venue lies.
Or a contemplated adoption.
Well, as defined, an individual proposed to be adopted is an adoptee, but there has to be an adoptee, as defined in the Act, in order for there to be venue for any court to decide a termination petition.
I would respectfully disagree.
In the absence of an adoptee, which court has venue?
Well, venue in the Adoption Act can be where adoptive parents live, or birth parents live, or the adoptee lives or formerly resided with the approval of the court.
But it's proposed adoptive parents of the adoptee or birth parents of the adoptee. It always relates to the adoptee.
That's true as far as you go, but in this kind of setting where no adoption is planned, it can occur where the birth parent resides. That's
Well, and
perfectly
there's no
acceptable.
other place for it to go, right? Is there any other section that it would come under other than this Adoption Act? The termination of parental rights.
Well, I'm not sure I understand your question.
Well, I think Justice Robson is asking about cabining the Adoption Act language to cases specifically involving adoption.
Well, I guess it's a little bit broader than that. I would, if I were writing for the General Assembly, I would probably write a law that allows parents to want to protect their children to file a petition somewhere to terminate the bad parents' parental rights.
Right.
I might be like all in favor of that 100% if I were in the General Assembly, and that sounds to be like the circumstance, unfortunately, that your client would be in. But what the General Assembly did here, I think, was create that statutory ability to remove somebody's parental rights in the circumstances of an adoption or a proposed adoption or potential adoption. And it's a statutory proceeding, not a proceeding that we didn't create it in common law. It's driven by the General Assembly. And I'm struggling with the fact that they put the venue of a petition to terminate under the contemplation that there is an adoptee. You do not have an adoptee by definition of the statute. So I'm wondering whether that means that this petition just isn't a viable vehicle to terminate the parental rights of the father in this case. That's my concern.
I think that a petition for termination of parental rights can occur, whether there's an adoption or not, in the county where the biological parent resides. And to address an earlier statement you made, yes, the Adoption Act does already provide that an adoptee, excuse me, who's a dependent child through his or her attorney can file a petition under Section 2512, have standing to do so, to terminate the rights of his or her own parents, without an adoption contemplated.
Counsel, I'm just blanking. The M.E.L., in M.E.L., the petitioning parent had a partner, an unmarried partner, am I right?
That's correct.
And can you remind me, did M.E.L. represent, or I can't remember if M.E.L. was the mom or the child, but did the mom in M.E.L., did she represent to the courts that if the court deemed cause shown under 2901 that this unmarried partner would adopt if permitted?
No.
Well, yes, but M.E.L. was remanded back to your county to have further proceedings consistent with the M.E.L. opinion, and in M.E.L. opinion, they were not married, and they were called upon to have an opportunity to show cause why they can't get married.
I was forgetting, sorry, go ahead.
It gets to the crux of the entire case. In that case, and M.E.L. determined a two-step process, which you, Justice Weck, disagreed with, and the two steps involved step one, that the petitioner or petitioners had to show why they could not meet a statutory requirement. In M.E.L., they could get married, they just chose not to.
Yeah, and I guess what I was getting at, as I was thinking about this, is that there are two different layers here. There's the one layer that I guess I was in a 6-to-1 minority on, was the difference between the unmarried partner and the person who's already married. On the one hand, and then there's this case which is somewhat distinct factually, and I'm just wondering whether you have any comment on whether that should, under your view of the case, view of the law, should the factual distinction have any legal significance at all in our analysis of your request?
Well, what it boils down to is this. I think this, correct me if I'm wrong, I think this answers your question, at least in part. We stand for the proposition here today that a trial court should simply have the ability to use its discretion, being in the trenches, hearing the evidence, hearing the unique circumstances of a case, have the discretion to decide whether cause was shown to excuse an otherwise required provision of the Adoption Act. If I may, because in M.E.L. the opposite was found, that is, not simply show cause why a provision should be waived, but first you have to establish that you can't, incapable, and that, Justice Weck, is what you mostly disagree with, that it doesn't say anywhere in the Adoption Act, it does not say M.E.L. created this, that the first step is to show incapability of meeting one statutory provision.
It's fair that in an adoption proceeding or in a termination proceeding, we must see this, the second part of this is seeing this through the eyes of the child. Therefore, while a child may be in the sole physical and legal and primary custody of one parent, without the termination, that child is subject to the right of inheritance or recovery of anything from that parent, including child support, should the person be gainfully employed. Termination results in a cessation of any of those potential benefits. Now, we know in custody law that a parent in custody cannot argue the benefits of child support away to pursue a custody agreement. Termination, it appears that this is a request almost analogous, that termination is a sidestep to avoid any contact with the parent at the parent's request, subject to potential financial harm or family connection without more. Wasn't that the legislative intent of the policy behind creating this particular statute? Such that the error is not for this court. The error or the modification or amendment should come from the General Assembly. I understand Justice Weck's position, and I agree with that in our formation of same-sex and intent-based parenting.
I think that you're absolutely correct that one of the reasons that underpins the Adoption Act, one of the basis for the Act in general, is, in so many words, to create a family unit, so to speak. That's just one of the purposes of the Act. Other purposes include permanency, safety, safety from a parent who would harm a child or create a grave risk of harm.
What is the present harm now if he's incarcerated?
Today, no harm because he's in jail.
And what precludes you or your client from coming back upon notice, for she will receive notice, I assume, of his potential parole? Does that not put you in a better frame under the exception to the good cause shown? But let me ask you this. I reviewed the issue that we granted, and it says whether Superior Court misapplied or misapprehended the essential holding. Are you arguing an abuse of discretion or a legal error? What are you arguing? What do you mean by misapplied and misapprehended?
The better way to frame the issue which brings us here today is that not so much that the Superior Court misapprehended what M.L.R. said, because the Superior Court essentially did what M.L.R. holds, but that the Superior Court and the Supreme Court, through reinterpretation of the Adoption Act, should allow a trial court hearing all the evidence, including the possibility of, as you mentioned, loss of inheritance, loss of child support, as factors in an overall scheme of deciding what's in the best interest of a child.
To determine cause, to determine if there is cause?
Absolutely.
Hypothetically.
But you...
I'm sorry. Hypothetically. God forbid the worst case scenario is we were to terminate this case. We agree with your finding. And father, because of the type of crimes for which he's in prison, gets murdered in prison or is killed in prison, such that the wrongful death benefits under, let's say, the political subdivision tort claim is $250,000. That child would be precluded from receiving $250,000, despite the fact that he's not, or she is not in harm's way with the father being incarcerated. Nor should the father have some issue that he seeks legal redress and obtains a financial or monetary remedy while incarcerated, outside of the money being confiscated for potential fines and costs. The child would be subject to receipt of that. Tell me, in the best interest of that child, why do we deprive a child of potential income if it's truly about the best interest of the child, as opposed to a dislike? I wholeheartedly understand that he may be repugnant, but we also have to remember that mother reproduced with this man to have this child, which gives him a set of equal footing. He's not deserving to possibly be in a civilized society. But there's nothing before this court, factually, with regard to the custody case, for you to seek us to overrule the most recent case that we have, that being M.L.R. Tell me, what has changed from that decision in 23 to now that would cause this change?
I'll answer that last part second. The fact that the father might have $500,000 in a bank account that the child will inherit if he dies in prison is relevant. But it's a relevant fact for a trial court to consider in the overall scheme of what's in the best interest of the child to decide whether a particular element of the Adoption Act like whether E.R. behind me must relinquish her own parental rights in order to terminate the gentleman's parental rights. It's one factor among many. I'm merely saying you could be right on that individual child maybe is better off with $500,000, but there's many other factors too that a court has to consider in the life of the child to decide. And we're just saying let the court decide because they're the ones in the trenches, not the appellate courts, to decide based on all the evidence what's in the best interest of a child. Let me flip the example. In the case of Z.E., that you may be familiar with, you may not, from 2019 Superior Court, unpublished. I just talk about it for illustrative and instructive and persuasive reasons. In that case, mother at age 4 started to be raped by her father and was raped for the next 16 years or so. And she had 2 children. Her children were also the children of her father. The children had, so he was a father and a grandfather. The case was heard in Monroe County at the trial level, and Judge Williamson felt constrained to not terminate his parental rights. Mother was the petitioner. There was no planned adoption. No adoption was averred. She wanted to terminate his parental rights to protect the children, even though he was scheduled to spend about the next 100 years in jail in Michigan and in Pennsylvania because of the crimes he committed. The Superior Court heard the case, unpublished but instructive, and held in so many words that there is no way in the world that the legislature intended under such circumstances that she should have to terminate her own rights, a good mother, just to terminate the rights of a father who has no business being near these children ever.
That's very interesting. I appreciate that. Let me ask you this question. Assuming hypothetically, which is not at all suggesting this will occur, but in a hypothetical world where 3 of my colleagues or more were willing to look at M.L.R. again, what would prevent the trial courts from going hog wild and applying the for cause exception not only in the Z.E. type scenario, but in cases where one parent wants to punish the other? What would guide or limit the discretion of trial judges who want to basically punish a bad behaving or neglectful parent?
It's an incredibly fair question, and it's always a question whether you're opening the floodgates when you make a decision. So this is 2025. Z.E., the Superior Court, unpublished, but provided some guidance to the Pennsylvanians out there. It said, the Superior Court said, yes, we're going to allow you, Mom, with no planned adoption, to terminate his rights under the unique circumstances of the case. 6 years passed. I only know of one other case where a person sought to terminate the rights of the father without a planned adoption, and it's this one. So for 6 years, the floodgates were not opened. But in further answer to your question, I think the orphans courts and the Philadelphia Adoption Court, judges across this state, have the great ability to hear a case, to take in the evidence, to separate the wheat from the chaff, and decide whether a case is honorable or not honorable. They have the ability, as did the trial court here, to find that a person like E.L.R. did not and was not engaging in the very appropriate consideration of custody gamesmanship, that she was not seeking to do this to punish the father. She was not seeking to do this to change the name of the child. She only sought to do this, the trial court found, for one reason, because she wanted to protect little M.L.R. That's it.
I mean, this may be the answer as to why there are no floodgates yet. And saying we're putting this in the adoption code. You know, there's a fundamental constitutional right, I believe, as a parent to exercise the right of parenting.
Agreed.
So if the General Assembly is going to create a process to terminate someone's parental rights, then we should probably strictly construe that. I'm still trying to find the hook in the adoption code that says when the General Assembly created this, it meant to create a general right of one parent to petition to terminate another bad parent's parentage out of the context of an adoption, even a contemplated adoption. I'm not saying it wouldn't be good. Maybe it would be good. But I'm struggling to get, I didn't practice in this area. It's not an area that I'm as familiar with others, but I'm just looking at the statute, and I'm looking to see where can I discern the General Assembly's intent to say, oh, this termination procedure that has to be initiated in the court where the adoptee is located, or his parents are located, that applies to any petition to terminate for any one of these reasons, and adoption is not even necessary nor contemplated.
Well, in the existing Adoption Act, a child who is dependent can petition to terminate his parental rights without an adoption being planned. That's clear.
That's not the section we're talking about here.
But it's within the Adoption Act.
It's in the Act, and you asked about that topic generally. Also, while different, the principle is the same. In the case of a public agency, or even an agency, a petition for termination of parental rights can be filed and granted without an adoption being planned. In other words, a 8-year-old foster child could have the parental rights terminated of her parents and remain an orphan for the next 10 years.
But isn't that contemplated? Isn't the idea of dependency permanency, and the goal of every dependent child is to adopt them out?
Well, the idea of permanency includes the idea of being safe and growing up happy and healthy and thriving. And no one would argue with the concept that sometimes growing up with a single parent who's an excellent, loving parent is much better than growing up with two parents who raise you highly improperly and you don't thrive. So who's to say that a single parent household is not a better place sometimes than the two-parent household?
Well, you're reciting really my concurrence in MRD from 2016, urging the legislature to act. And I guess my question is, even if we want to do what you want us to do, how can we do it without rewriting a statute or creating a new statute? It's a statutory basis. We aren't dealing with the common law here. How does this court do what you're asking us to do without rewriting a statute?
Well, first, I thank you for the question. I don't think you're rewriting the statute at all. I think you're deciding simply a very simple question. What does that mean, show cause? And what's petitioners allowed to show cause as to what?
That's presuming we get this under the Adoption Act, which is the question Justice Robson has been probing.
Well, Section 2901 is in the Adoption Act. Section 2901 says the cause for a cause shown can waive or forgive or dispense with the need to satisfy an element, a provision of the Adoption Act. In 2901, it says at the end, all other legal requirements have been met. So it suggests heavily that the legislature meant that the trial court, it says unless the court for cause shown, it dips down to all other legal requirements can be met. Justice Weck, in his dissent in M.L.R, concluded, I think very wisely and with a common sense approach, that the court, based on that language, just interpreting that language, can waive any provision of the Adoption Act, whether it's the adoption phase or the termination phase, and that's borne out by the case of T.G., which I mentioned initially, where the trial court, supported by the Superior Court in February of this year, dispensed with the need for the agency consent for that voluntary relinquishment of rights. And really importantly, in that case, you'll note, different than all the other cases. In all other cases, or most other cases, we're talking about dispensing with the provision of the Adoption Act so as to create a family unit. Not in T.G. In T.G., the Superior Court, in this voluntary relinquishment case, dispensed with the requirement that the agency consent to it to end a family.
Yeah, but respectfully, counsel, you just hit it on the head. Create a family unit. What are we creating? We are maintaining a family unit. We are terminating a parental right. And I understand that you keep referring to the safety of the child, but again, at today's date, sometimes we are back, as our Chief Justice just said, sometimes we have to make decisions that we internally despise.
The concept of creating a family unit, I understand, is used in a few cases.
That's the concept. The concept is if we're going to terminate one parent, the child's going to be replaced with another parent because we're replacing the child's potential rights of inheritance and creation of another family. Despite everything that we have, we just, because a parent has a fundamental right, the legislators believe that because it's a fundamental right, you have to give us a reason to substitute one parent for another. Because if you're a single mom who has no contact or the father is gone, that's the world we have. There is no contact. But we have a known, proven father. That's that. I would love to agree with you.
Well,
I just need you to share with me. It took us 50 years, it took them 50 years to overturn Dobbs. You're asking us to overturn ours in 2.
Well, what I'd like to do is...
Oh, if they overturned Dobbs?
Ben.
I'd like to get back to the few cases which are so illustrative of what would happen with an application of M.L.R, if I may. In a recent case decided November 2024, an adoption was granted in Montgomery County, Pennsylvania. I know because it was my case. You don't know about the case. It didn't get appealed. In that case, and I tell you about these cases because I think no one could conclude anything but the legislature did not intend this. In this case, father and mother had a child. Mother went shopping one day 5 years ago and never returned. So for 5 years, the child didn't hear from mother. Father began to live with paramour M.M. They had a child together. But the subject child, about 5 years old now, was the child of father and mother. M.M., the paramour, had been raising the child for like the last 3-4 years. It's the only mother the child knows. So this is decided just at the end of 24, after M.L.R. Father and paramour M.M. did not want to get married. And under M.L.R, if they were capable of getting married, then that would be cause to not be able to terminate the rights of mother or allow the adoption. M.M. has 2 children from a prior relationship. M.M. and the 2 children received SSI, $2,900 per month. That $2,900 was very important to them, given the family finances. If paramour M.M. was forced to marry father, his income would be considered as part of the means test, and her SSI, for her and the children, $2,900, would be eliminated. But the family couldn't afford that. It wasn't good for for paramour and her 2 children, but it also wasn't good for the subject child that this money be eliminated. So the trial court was faced with, what do I do? The Supreme Court told me in M.L.R. they have to prove to me that they can't get married, or I can't grant this adoption, which was filed by father and M.M.
You have to establish cause.
Exactly. So the trial court thought about, am I allowed to consider, do I have the discretion to...
The answer is yes. The answer is yes. The beauty of your scenario is there was no appeal.
Well, the importance of my case recital is that under M.L.R, the trial court arguably had no power to grant that adoption.
Because under M.L.R, under the majority in M.L.R, they're not barred from, there's no reason they can't marry. But instead of looking at the cause, which you just...
Right. Under the majority M.L.R decision, they would have to first establish why they can't get married, and then the trial court could think about the cause.
That's what I'm saying. MEL is, I mean, again, as I remember it, MEL, the parties didn't want to get married. They offered no reason why. Your clients had a reason why, probably a very good reason why they couldn't get married.
Yeah, the reason I stated.
Not necessarily.
Well, it could be, but go ahead, tell us how it ended.
Under MEL, no, it can't be good enough. The only way it can be good enough is if you listen to Justice Wecht in his dissent, which allows the trial court to consider all the facts and decide whether cause was shown to not require that they get married. His method, Justice Wecht's method, works.
But you could balance Justice Wecht's method with the majority opinion by saying we're balancing the financial equities in your particular scenario to the benefit of the termination. That is so distinguishable. I would be on your side had you appealed.
Well,
and
the point is, Justice Wecht's method allows the court to think, but the MEL majority method renders the trial court as a stick figure who's not allowed to think about anything.
You know, Justice Dougherty went down the road of the preservation of the family unit, and that's something we've always talked about historically in these cases. But one of the things I urged in my concurrence in MRD was that the legislature recognized that in our modern day, a family unit can just as easily be a fully capable single mother who has no intention of adding a husband to the mix, and a fully capable one-parent household is, in my view, certainly a family unit. But we are still back to this rub of how do we change what the legislature has said. And I think you make a powerful argument. We'll certainly take it under consideration. Are there any other questions for Mr. Bluestein?
Beautiful job.
Yeah.
Excellent argument.
Yes, it is.
Thank you, Justice.
Thank you. Could we hear from Ms. Pugh?
Good afternoon. I am Mary Pugh, the court-appointed counsel, having the privilege of representing the minor herein. I want to just talk about some of the things that you asked my esteemed colleague here. First, Justice Robson, you talked about the Adoption Act and the Termination of Parental Rights Act. It's a mishmash. It is a statutory conundrum. And when we try those cases, when there is a pending petition and an outstanding termination of parental rights cases, the trial court often says, almost always says, in order for me to get to the threshold of whether we can proceed, I actually have to hear the merits of the underlying petition to find out what got us here. So it is under 23 of the Domestic Relations Code together as the Adoption Act. It's the adoption proceeding and then grounds for termination. So
Provision under the adoption code applies to petitions to terminate as well as petitions for adoption.
yes.
And that specifically ties venue to where an adoptee is located.
Or the birth parents.
Well, it says the birth parents of the adoptee.
Yes.
Right, but it doesn't say birth parents blank. It says birth parents of the adoptee.
Right.
So whether it's a termination petition or an adoption petition under the Adoption Act, the only exclusive venue for the location of such a matter, as deemed by the General Assembly, something we can't change, is tied to the existence of an adoptee.
Correct, because we need a child.
No, we need an adoptee.
Or we need an adoptee, because
Right.
you can be over the age
Is
of
there an
minority.
adoptee in this case?
No, and that is the provision that Mother is asking that the trial court waive, because the General Assembly does speak. And the General Assembly under 2901, when it's talking about the time of the decree of adoption, which also applies to petitions because we're terminating parental rights, the mishmash I'm talking about, shows that unless the court for cause shown determines otherwise, no degree of adoption shall be entered unless the natural parent or parent's rights have been terminated, the investigation required by Section 2535 has been completed, the report of intermediary has been filed pursuant to Section 2533, and all other legal requirements have been met. if the legal requirements have been met, the court may enter a decree of adoption at any time. The provision that mother is asking to be excused is that the child be adopted.
I agree with you. But
So
that
that's
doesn't-
what she's asking, discretion for the
agree with-
trial court.
I agree with you, but the problem with that is once you get that condition taken away, the statute goes away, because the only provision, you have no venue to file it in. If there is no adoptee, you can't point me to a statute that provides for an alternative venue in the absence of an adoptee.
I guess the mishmash occurs at the findings. At the end, the trial court decides whether termination of parental rights is decided and whether an adoption occurs.
But there's no adoption here.
So
There's no
she says
contemplated-
adoption is not necessary because mother is going to retain her rights.
But if the trial court didn't have venue, then everything's a nullity. If it was an improper, this is not a common law proceeding where we get to decide the venue of the court, or even the parties get to decide the venue of the court. This is a statutory proceeding where the General Assembly has specifically said venue lies here and nowhere else.
So
what you're suggesting is that the waiver, the just cause, can be used to put venue in a different court.
Not necessarily. I guess I think that procedural shouldn't stump the substantive of that act, because we know the General Assembly doesn't enact nonsensical acts. And if we go further, then we say, okay, mother will consent and relinquish her rights. We will terminate father's rights. Mother will relinquish her rights. And then she will petition to adopt her own son back because she's eligible as an adult to adopt her son. There's no prohibition from her to adopt her own son. So if we want to do that legal gymnastics, she can get to the result she wants, which is nonsensical, unreasonable, and burdensome. So I don't think that would be the outcome that the General Assembly is looking for. I don't necessarily know if they even understand as a legislature that this causes so much problem procedurally when you are pursuing these cases. Which leads me to, Chief Justice, your great comment about this court has asked time and time again for the General Assembly to give them guidance on this issue of whether cause shown means that there needs to be a legal impediment to achieving the goals of the Adoption Act or what that looks like. And I submit that the General Assembly has given context. By giving trial courts the discretion to decide whether cause is shown in certain circumstances to forgive noncompliance with the Adoption Act, it is saying you will know when cause is necessary. We can't even fathom all of the specific fact patterns that will exist when in a case cause is shown where any one of the provisions could be excused, whether it's the report, whether it's the termination of one parent, or any other things. So we're leaving that up to the trial court, who's at a better level and playing field to see the litigants, to see the evidence, to see the feelings, and to know how timely these petitions are. With that said, I think that silence is deafening, because they have read your petition. They know what you're looking for. They certainly know the landscape of our families. 1 in every 3 families in America are single-parent families. And they're not just grandparents. They're not just women, fathers, mothers. They're grandparents. They're cousins. There's many, many families that don't look like what the traditional 2-person family is. And they could not possibly create statutes that would meet those needs. So they're saying, it's up to you, and our silence is actually deafening. Finally, and I want to correct my colleague here. I don't think it was Justice Doherty who wrote M.L.R, but you can check.
I didn't hear what you said.
I said to correct my colleague.
It's sirens.
I believe it was Justice E.L.R. I joined it.
Yes. Justice Doherty, you...
Oh, Justice Todd.
I'm sorry, I didn't even hear the comment because of the sirens.
I said
Could you go back?
I'll repeat again. I don't think that M.L.R despite what my comment said, was authored by Justice Dougherty.
By you.
It was authored by Chief Justice Todd. I want to give credit where credit is due. Justice Dougherty, you say, why do this? Why terminate the parental rights? What's the point? He's in jail. There's a big point.
What's the safety issue?
The safety issue, okay, and the father's brief, he says, what's the point? So kind of the same question. As counsel for the child, there's real reason here for termination of this father's rights. And these cases are really decided on a case-by-case basis. They are extremely fact-sensitive. Again, going back to the General Assembly's inability to legislate for each one of these cases. In this case, this child will someday learn about his father's proclivity for child abuse, pornography, endangering child's, many, many things that the father has done and has been in jail.
Remind me how old the child is.
Today, he's 5.5 years old, attending kindergarten as we speak. When this all started, he was a few weeks old when father was arrested for the second time for child porn. The first time was for luring a 14-year-old girl.
I apologize. The father was arrested before the child's birth?
Yes, years before, and then 2 weeks before he was born. And then he was released at that time, and then COVID hit. The child will learn someday about what happened. Today, we have to be very honest about that. There's Google, there's the internet. He can look him up in his name today. He will be embarrassed. He will be confused. He will have many questions. He will be afraid. There will be fear.
Counsel, that will happen to any parent or child whose parents incarcerated, arrested, or performed some type of sex act.
But his father's different. Thank you, Your Honor. And I respectfully do submit his father's different. He will never be able to ever be around his friends. He'll never be at a birthday party. He'll never be at a family party where his cousins are unsupervised.
I could share with you, as both of you, and I'm sure counsel for father, as practitioners in this arena, we've seen many, if not all the parents, or I shouldn't use the qualifier all, we've seen and we met many parents that should never be involved with children's lives or be parents to begin with. So,
yes, but I'm talking about this little guy today.
But that's what I'm saying. So, like, the issue here is, yes, we take that into consideration, but unfortunately, you guys will deal with the therapy down the line. The issue before us right now is, outside of those factors that are not to be considered right now under the law, tell us, convince us why a decision that was written 2 years ago should be overturned. Otherwise, you're asking us to write into legislation a portion of the statute that doesn't exist, and that is to remove or excise the section of the statute that says there must be a second parent or second party ready, willing, and able to adopt. As Chief Justice said, we have none of us have I would assume, have a problem with single parenting. You know, my mother was raised by a single mom. But that's not what the law says. I'm asking you, help me distinguish why 2 years of jurisprudence needs to be revisited and why the statute needs to be rewritten when our General Assembly has failed to do it. Because that's really the issue. We got the heartstring. We got it. We all feel it.
So I submit, I'm not asking you to rewrite the statute or to ask the legislature to. I'm saying by incorporating the language of cause shown, the General Assembly has actually given trial courts the ammunition to address these cases one by one, fact by fact, case by case. The M.L.R. court dangerously constricted that discretion and hampered it, somewhat handcuffed the trial courts to say you can't have discretion until you require litigants to show why they are incapable of satisfying the statutory requirements. And that's nowhere in the statute.
But hypothetically, it's a fact by fact It's a
Yes.
case-by-case basis. Assuming co-counsel's argument that the previous case in Montgomery County that was not appealed was more based upon a financial decision which was beneficial to the children. That's a factor to consider that can circumvent the good cause shown, if not prove it. So it kind of flies in the face of your argument that you're fact-bound or that M.E.L. changed you. The question is, you had a judge in the county permit it, and you had Superior Court reverse it. Was it based upon an error of law or abuse of discretion? What was the basis for
It was based on M.E.L. It was saying that, according to M.E.L., that this mother had to show a reason why she could not fulfill the marriage requirement. She did not do that, and therefore it was reversed and vacated.
M.E.L. was under the Adoption Act.
Correct. So therefore, Superior Court, are you arguing that the judge's application of the common law, is that an abuse of discretion or is that an error of law? What you're just saying is you're asking us for error review? We don't do that.
No, they said that it was, she did not apply M.E.L., that she did not apply the standard in M.E.L., and therefore it was vacated. And so the termination, and I remind you that what we're asking is just to get to the threshold, that the parents who are looking in these limited circumstances to terminate parental rights, I am not in favor of terminating parental rights unless it is necessary to serve the child's best interest. But it doesn't get to the end of the game. They still have to prove the elements of the termination under 2511A and 2511B. And this legislature contemplated that because one of the specific grounds for termination is a registered sex offender under 2511A11. And that was amended in 2018. They said this is a very serious ground that has to be taken into account. And we know that that's going to come before this trial courts, and they're going to have the discretion to decide that.
So are you saying that the Superior Court supplanted its own position over that of the trial judge?
Yes, no doubt about it.
Counsel, and I understand entirely your argument, and it's compelling, but I'm looking at 2512B3, where the legislature specifically identified a parent who was not entitled to the position of having rights protected by virtue of the fact that an adoption was not going to take place. They tell us that if a child is a product of rape or incest, that the requirement of the intended adoption is waived.
Yes.
Okay, well, see, here's the rub. They should add to 2512B3 or the child of a registered sex offender, and we wouldn't be here. I mean, if what they did was took all of the causes for termination and put it into B3, you would have your answer.
Yes.
And we would have your answer, and trial courts would have their answer. But in this situation where they have specifically identified an unworthy natural parent, it's very difficult to suggest that a trial court could decide, oh, but there are other categories of unworthy natural parents.
And that exception came as a result of a case wherein the Superior Court actually allowed mother to, they waived that requirement.
You've made the point. They can amend the statute.
Right.
And they haven't. I mean, and that's what we're struggling with. I mean, this is difficult. You're exactly right. I mean, this is complicated, and the situations vary as much as people vary. But when they go out of their way to identify an unworthy natural parent in this circumstance to suggest, oh, and by the way, because the termination of parental rights identifies this conduct that can result in termination, you should read it into this, because they could have put it there. See, that's the problem. I mean, that is rewriting the statute.
Right, and I'm saying that M.E.L. constricts the statute and the power of the trial court.
No, it does not.
M.E.L. construed the statute.
Correct.
I mean, and from the concurrence in M.E.L., you know that it would have been desirous to not do what I did at MEL. But when we wrote MEL, we felt bound by the statute.
That has to be a legal incapacity in order to show cause shown.
But see, that derives maybe particularly from this type of specific exception that the legislature has identified that waives the requirement. So, I mean, cause in this context has to mean something other than identifying other natural bad parents who should be deprived of their, their status.
But also,
and that's sort of, where I find the difficulty with this whole for cause issue.
Well, also, MEL was specifically under the Adoption Act. This couple wanted to adopt. The mother wanted to adopt with her partner, but he was not her husband, and she did not intend to marry him.
And that's why this case really is different from MEL.
It's not under the Adoption.
This is different from MEL. Although, your argument is just as heart-wrenching, clearly. But it's different because we're in a situation where the legislature has specifically identified the type of natural parent who is not entitled to that protection of having an identified potential adoption. It's just, it's just a different circumstance. And I sort of hearken back in a very different way to Justice Brobson's analysis. I think he's correct. I mean, you need an adoptee, and this is called the Adoption Act. And so when we're faced immediately with an argument, oh, by the way, you don't have to adopt, it's just sort of jarring in the context of the statutory scheme.
But then the nonsensical part of the whole act says to me that we have a able, willing, fit, wonderful mother who is raising a child and doing everything she can, and father's done nothing. So to Justice Doherty's point, he will probably be the indigent adult that this child will have to take care of in some point in his life and pay his debts. But at this point, she can do nothing because she doesn't have a partner, because she doesn't have a step-parent, because she doesn't have anything, yet his parenthood is just on hold because even though he has done horrendous things that we all agree, that she doesn't even get to be heard. She doesn't get a chance of a day in court to say that these rights are terminated.
Your client would be in a much better position if the child was a child of rape or incest.
How sad?
Because that's what the legislature said would eliminate the need for a prospective adoption.
And how sad that when we talk about protection.
I mean, is your argument this is similar to rape or incest? I mean, do you see what I'm saying? I mean, where does that end? And this is a particular situation where it would be so easy for them to amend this to say, or the product of a registered sex offender. Easy. Then your client is protected. But they just didn't do that. They just didn't do that.
So in sum, I say that when we talk about the Adoption Act and the termination of parental rights cases, we are actually in balancing parental rights versus the safe and nurturing environment and home of the child in favor of the parents' rights, no matter what, will prevail.
Well, I mean, Justice Doherty, consistently makes the point of those other types of inherent interests that are involved in lineage, inheritance, extended family.
And then he would maybe burdened with his debt.
That's built.
And in Pennsylvania, you are responsible for your adult if they are in debt as a child, and you're responsible for their care and maintenance under the Pennsylvania statute. So he might also have that to look forward to.
Okay, you've made a very compelling argument. We appreciate it, Attorney Pugh. Let's hear from counsel for father, Mr. Brewster.
afternoon. My name is Damian Brewster from Lewis and McIntosh. I represent Birth Father. My friends on the other side of the table, they have some sympathetic facts on
Would
their
you
side.
pull the microphone up, please?
Absolutely.
Thank you.
My friends on the other side of the table, they have sympathetic facts on their side, but I think all of the justices here have correctly identified that this case at its core is a separation of powers case. And I'll just briefly explain why. Two particular statutes at play, 23 Pennsylvania Statutes 2512, which says at its core that to file a petition for termination of another parent's parental rights, you either need to contemplate an adoption, the child needs to be the product of rape or incest, or the petition, TPR petition, has to be brought by an agency.
Does your client know the child's birthday?
Yes, Your Honor.
Has your client ever sent the child a birthday card?
I believe so, Your Honor, yes.
Do you know when?
No, I mean, the trial in this case, Your Honor, respectfully, was more than a year ago, I think, so I was familiar with those facts at that time, but...
And your client's incarcerated, correct?
That's correct.
And what's the basis for your client's desire to continue with this litigation?
Your Honor,
for the record indicates he has no desire to be a father or a parent, other than abusive process. Well, that's never been raised. What is the purpose?
Respectfully, I think he loves and cares about his child. He is right now living under difficult circumstances. He's incarcerated for the foreseeable future.
Self-imposed circumstances, you mean?
Correct.
He's a predator pedophile, correct?
He has been convicted of multiple sex offenses. That's correct, Your Honor.
Has he been deemed a violent sexual predator?
I believe he has, yes.
And do you think that's sufficient basis for his termination?
It is absolutely a grounds that the legislature wrote into the termination of parental rights statute as a basis for seeking termination of parental rights, and it was one of the grounds found by the trial court in this case. So there's no dispute about that is one of the grounds that has been met. There's no factual dispute in this case. It's strictly a question of legal error and separation of powers.
Could he voluntarily relinquish his parental rights?
Did you say could he? I'm not sure. That's not an issue that I researched in this particular case. It was not at play in the lower courts. But what we have is the legislature has written this statute, and it's been amended over time. But this is the first time, in fact, that this particular issue has been before this court in 48 years. So in 1977, in Re B.E. was before this court, and this case was actually cited, I believe, in the dissenting and concurring opinion in M.L.R. But in that case, we had the exact same fact scenario we have before the court today, where we had a mother. She was not proposing an adoption. She just wanted to terminate father's rights. And the court held at that time, we agree with the Orphans Court that the Adoption Act provides for termination of parental rights only in connection with a plan for adoption, and we affirm. And that has been the law in this Commonwealth for all of those 48 years. Now, the statute has changed a couple times, and it's been in response. The legislature has changed it a few times. They added the exception for an agency, and that's because agency petitions for TPR are part of a complex statutory framework. You have the Indian Child Adoption Act. You've got all these requirements that agencies have to go through to try to find permanency and adoptive resources for children. But with parent terminations of parental rights, the only exception that they've carved into the law is that exception when the child is a product of rape or incest. And that was actually done in response to Z.E., which was opposing counsel mentioned that case. It was a Superior Court opinion. At the time that case was decided, that legislation was already in the works. So the point I'm making is the
What year was that? What year was that?
I believe 2021, but that's a guess. I apologize for not having an exact answer. But the point I'm trying to emphasize is that the legislature knows exactly how to enable a parent to terminate another parent's rights in the absence of an adoption. They know how to do it, and they've done it in particular ways.
Granted that 2901 references adoption, obviously that's
Yes.
What is your understanding of how 2901 operates?
Sure. So, yeah, and I understand why my opponents, why they've invoked that exception, of course, because they look to that cause shown provision and they say, they make a good argument. This provides trial courts with discretion. But there's two issues, I think, or really three issues with that interpretation. Number one is the caption says time of entry of decree of adoption. There can be no entry of a decree of adoption if there's no petition for adoption in the first place, which is what we have in this case before you. There's no contemplated adoption. Nobody's filed a petition. So just the caption, the title of that provision, 2901, suggests that it has nothing to do with this factual scenario, that it's in a posit. And then they mention, otherwise, no decree of adoption shall be entered. So the language itself is clearly intended to apply to adoptions and not terminations of parental rights in the absence of an adoption. But then you have the issue of this court's interpretation of 2901, which has been consistent over a period of 15 years. And if you'll just give me a moment, I'll mention those cases. But in every single one of them, I believe there has been a contemplated adoption, which we don't have in this case. So really, and then you've got the basic the constitutional provision, and if you'll give me a moment, but when this court interprets a statute, it's presumed that the legislature, if they didn't like your interpretation of it, they would have changed. They would have rewritten the statute. And so this court, in interpreting, I'm sorry.
What I was getting at by asking my question was something a little different. It was. I don't think anything you said is nonsensical. I understand what you're saying. My question is, 2901 has to mean something.
Yes.
Okay, and obviously 2903 has to mean something. So 2903 means something. And isn't it a way to honor 2903 to read 2901 as saying no cause shown? And a way to show cause might be something different than this case, I'll grant you, but a non-married partner. In other words, couldn't the legislature there be saying you can show cause by coming in and saying, look, we're not getting married, but we are a couple, and we should avoid 2903, and we're showing cause why, maybe similar to Mr. Bluestein's scenario with the SSI case. I realize that's not this case. That's not this case. But wouldn't that be a way to honor both 2903 and 2901? Because from the other explanation you were giving, I wasn't seeing any way in which 2901 would ever apply.
Understood. So I think this court has applied 2901 in a number of different scenarios. One of them being, I think it was RBF, where you had two different same-sex couples. They were precluded by law from marrying at that time. But to your point, I did intend to address your dissent and your concurrence in M.L.R, and I'll do that now. And I think you've already recognized it doesn't apply in this case because M.L.R involved a contemplated adoption. We don't have that here. But that was the way I understood your dissent in M.L.R, was the only reason why you were differing with the majority was you recognized or you took the position, and I don't disagree or agree with it. I thought it was a very interesting analysis, and I think it's something this court could take up in the appropriate case. This is not the case because we have no contemplated adoption here. But that the legislature maybe did not specifically require that the person who's proposed as the adoptee be married, that they be spouses. That you could propose a partner potentially. They will assume all the legal duties of a parent as a result of that adoption. They don't necessarily have to be married to the other parent, the person who's already the parent. I don't have a horse in that race today. It doesn't apply to my client because in this case, there's no adoption is proposed at all.
I appreciate that. So I appreciate that, sir. I just wanted to say that so you would agree with me that that would be a possible.
You may agree or disagree. It would be a plausible interpolation of 01 and 03, a way to make sense of both of them without nullifying either of them.
Absolutely. I think in any scenario where there's a contemplated adoption, a litigant could ask the trial court to use its discretion under that cause shown provision in 2901, if that answers your question. And then just to address Justice Doherty's, a few of his comments, this is a case where, because there's no proposed adoption at all, there's just one parent seeking to terminate the rights of another parent, where there is a concern, I think, and again, this might not even become relevant because we're dealing with separation of power issues. My friends on the other side of the table are essentially asking this court to rewrite the statute, the statutory provisions, which you can't do under the separation of powers doctrine. But even if you could, we would need to look at, if you can just cut out the parental rights of one parent without proposing anyone to step in and take their place, it does have the consequence, even if we assume that my client maybe will never be able to interact with the child in a meaningful way in the future. It does cut off his inheritance rights from my client. And I'm not going to make any factual representations outside the record that those are significant in any way. I think there is a possibility that they may be. And certainly any decision this court makes, we have to take into account the different circumstances that could arise in any other case. But that is, part of the, if we're going to argue the facts, right now the child is not in any harm. Mom has sole custody right now. And if and when my client were ever paroled and wanted to seek any contact with the child, a custody court is fully fitted to weigh all the equities and the facts as they exist at that time and determine whether there should be any type of contact, and if so, what type of contact. So it's just not a case where termination of parental rights is allowed under the statute, and this court respectfully can't rewrite the statute as much as it might want to. And that's the sentiment that I think this court has expressed in MRD and also in M.L.R. So it's a situation where the legislature knows how to amend the statute or the statutory provisions if they want to. They could, maybe they will in the future, but to date they have not.
Thank you, Mr. Brewster.
Thank you.
Thank you.
Excellent arguments all the way around, and obviously we take the case very seriously and we'll take it under advisement. This concludes our Philadelphia Spring Argument session. I would like to thank PCN for providing educational programming and videoing our arguments. I'd like to thank our court crier, Brian Minner, and our prothonotary, Caitlin Gorman, as well as our court security, John Evans, Scott Town, and Gary Shovlin, along with the Philadelphia Police and their Special Dignitaries Unit. We very much appreciate their service. Mr. Minner, you may adjourn the court.
Thank you, counsel.
Thank you, Brian.
Excellent
Thank you.
arguments.
Thank you.